Check one, two. I'm fine on renewing because we allow that for our pharmacists to do.
I understand what you're saying.
Yeah.
And I agree with you.
I agree with you on the new.
But then again,
Good morning, everyone. We're going to get started in just about a minute or so. So if folks can find their seats, it'd be greatly appreciated. We're not sure if there's a smaller room in the building, but maybe we'll reserve that one in the future.
All right, good morning, everyone. We're going to call this February 14th, Happy Valentine's Day, public hearing to order. We'll start and see if my co-chair has any remarks.
Happy Valentine's Day. This is our second public hearing. There are at least 2, maybe 3 more public hearings. So if you don't see your item on the agenda today, just please be aware that we have a lot more work to do in this committee. And so I look forward to hearing great testimony and everyone getting home in time to have a special dinner with their family. So if we're all in this together, I think we can get out of here relatively. It's a commitment we're all making to each other right now.
Okay. Great, and thank you very much. Yes, my son's train gets in at 5:45. That's my goal, is to get to New Haven by then, but we'll see what happens. With that, as Representative Lamar mentioned, we do have other public hearings coming up. We have a public hearing the 19th, the 26th. If necessary, we may have another one. I know people who have testified before us in the past were used to the fact that we would do theme days. We would have all the alcohol on one day, all of the cannabis on another day, et cetera. This year, we were the committee, as we took on more cognizance this year, and we've expanded our cognizance in order to make sure we got all the bills done. We're kind of hearing them in the order that we're getting them ready. So this is not the last day we will be talking about some of these topics. We will have another day where we'll have a committee bill on gambling, another day with a committee bill on cannabis. So there will be another opportunity, and you may see the language you're looking for at a later time. So with that being said, I'd like to call the first in our order, Commissioner Caffarelli.
Appreciate the tie.
Yes, thank you very much. And good morning, Representative Lamar, Senator Maroney, Representative Ritigliano, Ciccarella, and all the distinguished members of the General Law Committee. I want to thank you for raising these bills, the DCP bills and the governor's bill, and providing the opportunity for us to testify in support of them. You have my written testimony, so I will use this to cover a few of the highlights and then take questions. So today you have before you 3 bills covering the department and then the governor's bill. The 3 department bills are the liquor control bill, the drug control bill, and the gaming division bill, and I'll take them in order briefly. So HB 6854 is the department's liquor bill. And it consists of policies to improve and streamline our liquor permitting process. We continue to work with our sister agencies, the Department of Transportation and the Department of Mental Health and Addiction Services, to deter liquor consumption by minors. We're also developing an education program for new liquor permittees, and I've identified grant funding to cover the costs and make this a free program. At least 17 other states require some type of education before selling alcohol. And this class, we believe, will help train our permittees to avoid serving minors and intoxicated people, and generally best practices to encourage safe consumption. We've also extended the restaurant caterer permit to assisted living facilities. Our seniors have earned the right to have a drink at dinner, we think. And have included that in a suggestion to the committee. In our drug control and cannabis bill, HB 6855, we seek to enhance the department's ability to ensure Connecticut residents have access to a safe drug supply. The bill adds intoxicating substances that are commonly sold at gas stations and convenience stores to the list of Connecticut controlled substances. Drugs like kratom and designer benzo.
I turned off my heater.
And it removes unregulated intoxicating substances from the reach of minors who may not understand the negative health impact of these drugs. And next, because cannabis is illegal at the federal level, cannabis businesses are generally precluded from the bankruptcy process. So states with cannabis programs have begun implementing laws to address concerns about when a cannabis business might fail or go into receivership. So the proposal creates a receivership option for cannabis establishments. It's primarily modeled off Oregon law, and it will require the person taking ownership of business to adhere to Connecticut laws and ensure the continued integrity of the cannabis operations. We also exclude bank loans from the definition of backers who require a license simply because a bank only provides funding and doesn't have active management. So there's no need for a license. And finally, the bill requires that raw hemp and manufactured hemp products be maintained behind a counter and restricted the sales to those aged 21 and older. And next in our gaming bill, Senate Bill 1235, we look to strengthen the department's enforcement and improve our regulatory oversight of the gaming industry. We strengthen criminal penalties for illegal gambling activity. It's to make sure that misdemeanor penalties aren't viewed as just the cost of doing business. We also prohibit sweepstakes, which out-of-state businesses are using to offer casino gaming and sports betting. These businesses are referred to as social casinos, and they attempt to legitimize their virtual currency by offering free cash and coins through sweepstakes. But consumers must go through multiple steps to obtain these, quote, free entries and win these free coins. And consumers who enter for free are not able to enter at the same rate of those who purchase coins. So really, it's a thinly veiled illegal gambling operation. And finally, the governor's Consumer Protection Bill, Senate Bill 1248, it addresses junk fees and auto renewal subscriptions. Consumers are often persuaded by deceptive advertisements that seek to lure in a potential customer with a low advertised price, only to find out late in the transactional process that the consumer has to pay additional and undisclosed fees. The legislation promotes open and honest transactions in the marketplace and raises consumer confidence in our retail and service industries. The bill builds off of the Federal Trade Commission's recent click-to-cancel rule. Companies have made signing up for services very free during the free trial, very easy during the free trials, but oftentimes canceling those services proves rather difficult. The governor's proposal provides user-friendly means to cancel these services so that consumers aren't stuck paying for unwanted subscriptions they no longer use. I really want to thank you for the opportunity to testify in strong support of these bills, and I stand ready to answer any questions that you may have.
Thank you very much, Commissioner. Are there any questions from the committee? Okay, Representative Turco.
Thank you, Mr. Chair. Thank you, Commissioner. I mean, there's a lot of good things that you touched on in these bills. Just one minor issue I'm very curious about. I picked up a constituent from an assisted living facility in my district last Friday to take him to an event. And, I asked them, do they serve, knowing that this proposal was coming in there, and I asked them, do they serve alcohol in your assisted living? And he says, yes, Tuesdays and Thursdays, we have happy hour and free alcohol is provided. I'm just wondering, what's the difference from what assisted living communities can already do to your proposal that allows them to serve liquor now? Thank you.
Actually, if I could just ask our Liquor Control Director, Caitlin Anderson, to come up and kind of explain those nuances. You could just sit with that.
Good morning. My name is Caitlin Anderson, and I'm the Director of Liquor Control. Please excuse my voice this morning. You are correct. There are a few assisted living communities that currently have received a permit under this permit class. There are certain limitations, however, on their ability. For example, the limited days that you noted in your question. So this would remove some of those barriers to service and allow more flexibility under that permit for these types of venues.
Thank you very much for that. And Commissioner, can you give a little bit more detail in regards to your proposal and the governor's proposal regarding being able to easily cancel contracts that you're in? We passed legislation in this committee. It was actually a proposal of mine that this committee passed out and became law that said that an individual entered into some sort of subscription contract online, they have to be able to cancel online. They can't be made to send a certified letter or have to go in person. It has to be as easy as it was when they subscribed. How is this proposal going further than that? What is it doing differently? Thank you.
Well, first and foremost, it requires the advertisement in terms of what you're actually going to be paying. And in terms of the click to cancel, there's numerous provisions in the bill that will make it easier, including having a working phone number that's available on a website and allowing people to cancel by using that phone number. They could even leave a voicemail in it. The company is required to get back to the person within one business day. So it does tighten a lot of things and makes it a little more user-friendly based on like I said, the Federal Trade Commission model, but also, other suggestions that really take into account the practicality of how you click to cancel and can actually cancel these subscriptions based on complaints and issues that consumers have had in the past while trying to cancel these free trials or trial memberships, or even auto renews that are so easy to get into, but you find it hard to get out of.
Thank you, Commissioner. I like the idea of a phone number. Some people don't have access to, mobile devices or, apps, maybe some, older adults as well. A phone number would be much easier for some people to be able to cancel. So I like that proposal. Thank you so much, Commissioner. Thank you, Mr. Chairman, for allowing me these questions.
Thank you. And thank you, Representative Turco. I believe that bill you brought was 5214 in 2023. And thank you for bringing that concept to us. And Commissioner, I believe one of the issues that was brought to us was that, we required with the cancellations, it has to be as easy to cancel online as it was to sign up. But I've heard that there were some complaints that some of the businesses would make you finalize your signing up by coming in and signing in person. And then they said then weren't no longer required to make you cancel online. So this makes it much easier and more clear, correct?
Yes, Senator.
Thank you. Thank you very much for that. Are there any other questions? Representative Lamar, and then I do have one or two.
Okay.
Thank you, Commissioner, for your testimony here today on each of the bills that you referenced. We'll be working closely with you over the next couple of months to make sure that the regulations that you've proposed, in addition to regulations and amendments that outside industry folks may propose over the next few weeks, are implemented in accordance with what the legislature thinks is appropriate, but also what you think as a regulatory agency is enforceable. So I think there's a lot of conversation that we're going to continue to have. You'll notice on some of the submitted testimony on each of the bills that there are folks in opposition to certain aspects of your proposals. And due to the nature of the public hearing process, it's hard for them to have their questions answered by us when you're the ones who are proposing it. So just to test out a few of the questions and a few opposition points that you're likely to hear later today,
Sure.
if we could kind of get you to explore some of these topics just in a little greater detail. You're hearing from industry folks about child-resistant cap requirements on THC-infused beverages. You're going to hear, I think, at least 3 or 4 different companies say that this is going to present a tremendous economic burden on these companies to comply with this, and there may not be evidence to suggest that these types of restraints actually improve child safety. Could you maybe explore that and why the agency is coming up with that as a proposal?
Sure. Yes. Well, the seltzers that are required under this proposal to have the child-resistant caps are, by and large, have colorful cans and are attractive that will be stored in the refrigerator most likely with everyday food. Everyday seltzers with or without alcohol in them are beginning to look more and more attractive to everyone, including colorful. So I guess my point there is it's easier to, as we've read and seen, and some of it's anecdotal, that it's easier to confuse them. So having a child safety cap, we believe, we've seen in other states, does help kind of curb that problem of accidental ingestion, which is really what we're getting at here. Moreover, it does bring some parity because in our regulated market, where seltzers that have 5 milligrams of THC are currently required to have this child-proof cap on them, but the 3 milligram THC seltzers that are sold elsewhere do not have it. So for those two reasons, I think that it is important. I understand that, I have seen and heard some of those complaints from the industry, but this is what the department is proposing. I mean, we are focused on public health and safety, and really we're trying to get at accidental ingestion, which is a real thing. I mean, there's been some articles about it lately in the news. I mean, not necessarily focused on seltzer, but just THC or cannabis in general, of children winding up in the hospital and poison control center complaints about it. So that's really what the gist of this proposal is.
And I think it's good to kind of weigh what the concerns are against what the industry's concerns are, right? Is we are looking at an emerging, growing set of businesses in Connecticut that see an opportunity to really enter the marketplace, both here in Connecticut and outside of the state. And they've designed all their product packaging. They've gone through this process. They've laid it all out. They've invested multiple millions of dollars, and suddenly feel like it's a new regulation coming in. Versus on the DCP side, and really just general parents of anyone, like, hey, there's a whole bunch of seltzers in the refrigerator. How do I know that my kid isn't grabbing the wrong one? What other additional protections that happen inside of the refrigerator at home that we can place on these? Like, it's a parental responsibility, of course, but also are there some safety measures that we can incorporate in just the product design so it makes it a little bit easier? So I think that that's the balance we're trying to achieve, and I think that what the regulation intends to support is like that, the ease with which parents can effectuate the accidental ingestion, which I think is where you're going from. So I appreciate that.
Correct. Thank you.
The adding of additional controlled drugs as contemplated in 68, what is it? 6854, right? 6855. You talked about kratom and other emerging marketplace sales of drugs that need to be regulated. I've gotten a lot of feedback in the last just 2 weeks, so it wasn't useful for our conversations during screening or for contemplation in a bill to this point. We may look at it as we move forward, but the continued expansion of product sales at these convenience stores and like go beyond that, but also to like diet pills with unregulated substances in them. When DCP goes through a process and review of these types of drugs that are on the marketplace, whether it's through the pharmacology division or whatever division it is, how do you receive intake about the products that are for sale, and how do you propose these regulations, and how do we potentially look at emerging marketplace conditions outside of the traditional legislative session? Is there any tools that we can provide you to crack down, rather than us having to wait until next year to regulate the product that we saw on the market this year? Is there something that we can do beyond in this bill, like where we're allowing you to move a little bit further than you have in the past? But what tools can I give you to go after new things that might emerge in the marketplace in the next few months?
So, thank you. And you are correct. It is kind of hard to keep up with all the new drugs and designer names of things that we're finding in bodegas, gas stations, other stores that are very harmful. And so that's why it's helpful for us to not only conduct our own research, but to really have a healthy dialogue and relationships with other regulators across the nation, where that we can share ideas and hear what they're finding and kind of understand what hopefully see around the corner a little bit. In answer to your question, I mean, I believe in this bill there are substances that are identified, and I want to thank the committee again for the opportunity to have this public hearing on it, so to flesh this out, to hear about the other sides of it, because it is a helpful process, and you all have the toughest job. You're the policymakers and you make the call. So we present you with this information. And in the bill, it allows the department to, through PMPs with your guidance, policies and procedures, schedule these drugs, which would automatically put them into a class that would attach criminal penalties to them, mostly focused on the person or people or entity that's distributing these harmful products. So, happy to have further conversations about how to keep that dynamic going, but I think that one of the tools is already in the bill with the policies and procedures, but how to identify and to get your approval as to the new drugs would be something that we'd like to discuss.
Thank you. And I think that that's what I was trying to get at is like, is this sufficient enough to look at the next wave? Like my fear is with the marketplace being as robust as it is and the ability for a product that Connecticut regulators and politicians, policymakers, public health folks don't even know exists in the marketplace to suddenly find itself in 300 convenience stores and gas stations across the state before we have an opportunity to even evaluate whether it should be for sale in Connecticut. Whether or not this is a sufficient tool. And so I think, like, I'm in full support of this. I think we need to attach criminal penalties to illegal product sales. I think we need to go after a lot of these drugs that are really dangerous and damaging to anyone who ingests them, but particularly to children in an unregulated marketplace. But is this dynamic enough to go after the next wave? And I think that's where I'm struggling as I see this marketplace continue to evolve in the city of New Haven, but generally everywhere in the state is dealing with similar issues. So I think
Yeah, and Representative, I think that the framework in the bill is there. It's just a matter of the mechanism for those additionally identified drugs that are kind of the unknowns right now.
Thank you.
Representative Vitigliano.
Just a quick follow-up to the chairman's question. So by putting those drugs that he was just referring to into the schedule, how does that affect your ability to go after the license of the business that might be selling? Is it that included, or is it just sort of a criminal when it goes into the schedule? Is it a criminal offense, or what tools do you have to, stop the people from operating?
So, twofold. In answer to your question, many of these entities that sell the products listed here are not licensed by us. So, it would, again, attach criminal penalties so that we could give support to local and state law enforcement for them to go after those that are selling it. But those that are licensed, for instance, vape shops, we can also go after them administratively, but in concert with the law enforcement.
Thank you.
Are there, Senator Ciccarello?
Thank you. Sorry, I'm a few minutes late. Wanted to make sure I had my Valentine's Day shopping in order. I'll be in real trouble. So, just following up on that question, I believe we had a conversation about this. We sometimes see products that are in the convenience stores, and that is a concern as we see children getting their hands on them. They're not age gated. And this would allow you another mechanism to collaborate with other agencies and address that. A lot of times we see an issue. We just dealt with one where you need two different agencies involved, DCP and DMV. This is going to allow you then to be able to clearly say what the law enforcement will say, what the law enforcement could take action on, because we've seen it was unclear to the municipalities and the police there. Is it illegal? Is it not illegal? Can they have it? Can they not have it? And they didn't want to get in trouble, so they just left it alone. So this would give a little bit more ability to make it clear what the local law enforcement in collaboration with the other state agencies can do and what actions can be taken. Would that be a fair way to understand this?
Yes, Senator, it would provide clarity. And so we are oftentimes called as subject matter experts by local and state law enforcement. Now, just to be clear, we do not have the authority to go out and arrest people. And the focus, also to clarify, is not on the user. It is on those people that are selling these products at the store and they know what they are doing. And so we, through a bill like this and other mechanisms that we are discussing here this morning, can assist law enforcement by clearly delineating what is legal and what is not legal through your actions here. And when they are classified, these drugs, law enforcement, it will be easy for them to understand what's legal, what's not legal, and then they can take the appropriate action. Because once a drug is classified into a particular schedule, penalties attach automatically.
Excellent. Thank you for answering that question. Prior to session starting, we had a bunch of speed dating, we call it, with different agencies, departments, and groups. And there was a group of mostly parents, I believe, across the state that were trying to crack down on this. And they really explained a lot of the challenges that they were having. Every municipality dealt with it differently. Maybe the municipality did take action, but then another state agency would not enforce it. So I think this is a step in the right direction to address those concerns of those parents that are in that group, and many parents that are worried about their kids getting access to things that are dangerous right at the convenience store around the corner. So thank you for putting this in the bill, and hopefully we move it forward.
Thank you very much. My colleagues asked most of the questions that I was hoping to ask, but something that you said brought up another question. And so I enjoyed a line of questioning from Representative Lamar on, how do we give you the flexibility, right? And I think we're seeing that things change faster often than government's ability to regulate them. So how do we build in that flexibility? And, one of the things in the bill, as you referenced, is the policies and procedures that have the effect of law, right? That you have the ability now to do that. Can you just talk a little bit about the difference between that as the speed that you can do the policies and procedures versus obviously the legislation, because we're not in session all the time, and then regulation?
Yeah, so policies and procedures, there are, processes that have to be followed by the agency. But once they are posted on the agency website, which is required by law, in a clear, conspicuous area where people can find them, after 15 days, I think it is 15 days, correct? Yeah. They have the full effect of law. And so, in terms of most recently, I can give you an example that when the RERACA, in 2021, the cannabis bill, the adult use cannabis bill passed, there are policies and procedures, mechanisms in there, but ultimately they sunset, in fact, this year, and they're all turned into regulations, which is a bit of a longer process. So they will go through that process, but it does, as you recognize, allow us to be a bit more nimble in terms of once these harmful substances are identified to classify them. So you can make the ability of the agency with regard to the policies and procedures narrow. So in terms of what we can use them for, i.e. scheduling harmful drugs with a mechanism as to who determines that they're harmful, and then they will take the full effect of law within 15 days of publishing them on our website.
Great. Oh, you have another. Representative Lamar.
And I think that's great. And I think what I really want to leave here today with is a great appreciation for your willingness to recognize the three House members from New Haven on this one committee, but it's not just New Haven. One of the number one complaints we hear from constituents back home is the illegal products that are for sale in so many shops across our city and really across the state, whether it's gas stations, vape shops, the corner bodegas. There's so many dangerous things involved. And the owners of these companies and these small businesses would generally we want to be supportive of, like their investment and their willingness to open in our communities and sell products for sale. But those same ones are also selling a lot of illegal, dangerous products. It needs to be classified as such, and they need to understand they're at jeopardy of losing their business if they continue to sell products that can harm our children and our families. And I greatly appreciate the agency's willingness to tackle this head on. I know it's a small staff that you guys have able to help enforce a lot of this stuff. So putting the PMPs in place, giving the empowerment to our local authorities is paramount, because we need additional tools when we recognize these products for sale are so damaging. We need to be able to go after these businesses. And so I do appreciate your forthrightness and willingness to work on this.
If, Representative, I could just add something on that. And we have heard this from this committee and others, and recognize that. And we have made an effort and realize our capacity, limited as it may be as an agency alone. And that's why we have worked with other agencies, and not only on an ad hoc basis when we hear from local police enforcement or municipalities that want help and assistance in identifying products, but on a more proactive scale. I do have to commend the sister agencies, DESP, DRS, the Attorney General, who are all involved in these in local and all the spearheaded by the local not just police, but their fire marshals, their zoning individuals. And so we can go at this with pulling every lever that is possible to combat these illegal drugs. And we have successfully done that in some cities throughout the state, and we are looking to replicate that. And I think it's a model that not only is effective in taking a lot of this illegal product off the street, it does result in both civil penalties brought by our agency, the Attorney General, but also criminal penalties that are brought by the local law enforcement and the state police. So we've seen success there, but in terms of that, but it also sends a broader message, to your point, that this will not be tolerated, and but again, and I do want to be clear, we are not going after the users, we are going after those entities that know that this is wrong and are continuing to do it, because most of these places that we go to, we've had multiple engagements with and warnings, and they just aren't getting it. And so this is really kind of the final step. And so that's how one way that we've begun to approach it.
Great. Thank you very much. And thank you for, the thoughtfulness and expertise that DCP brings really to every topic you deal with, and the ability, we understand, we recognize in the past, we've always had a great ability to work with you and work through issues, because we know through the rest of the day, we're going to hear varying viewpoints, and you're always willing to kind of work and find solutions. So thank you. Oh, Rep Candelaria, sorry.
Thank you, Mr. Chairman. And just to follow on the same points my colleagues have been talking about, it's a little bit concerning, right? We regulated a market, right? And what we're seeing with this shop, not only selling these other products, but they're also selling cannabis. And they're very strategic on how that's done. Is that you walk in, you cannot see it, but they'll determine what type of individual you are just by looking at you, how you physically look. And they said, well, what you need is in the back, right? And I think the enforcement piece is critical. And I think we need to put more resources to ensure that the enforcement, we could do as many regulations as we want, but if we don't provide the enforcement piece, we're not really going to tackle the issue. And I think that's where we need to invest the dollars. So I'm grateful, Commissioner, that you're moving this forward. You're bringing this to our attention, because it's something that needs to happen. Also, the other piece is, how do you determine which establishment has the ability to sell legally? For example, in this particular case, I'm talking about cannabis. When you go to a restaurant, you have the sign at the door that says, a restaurant, that you're going to a legitimate place. But when it comes to these, and I'm going to go specific with the smoke shops, it's very difficult to determine, and it's confusing the consumer. And I think the consumer needs to be educated, and I think we need to go a little bit beyond. And how do we identify a retail or a dispensary that's legit versus a smoke shop that's selling behind the counter cannabis products? So I think that's something that we have to start thinking about and regulating as well. So thank you, Mr. Chairman, for the opportunity.
Thank you.
Thank you, Representative Candelaria, and couldn't agree more that it's about making sure you have the resources to enforce, right? We can pass all the laws we want, but if we don't give you the ability to enforce them. Representative Paolillo.
Thank you very much, Mr. Chair. I appreciate the opportunity, and good morning, Commissioner. Thank you for being here, and I won't go over the comments that have been made by other committee members, but want to thank you certainly for for DCP's always collaborative approach. As you mentioned, I can't underscore enough your approach throughout state government, but also the collaborative approach that happens locally with municipalities. That work certainly doesn't go unnoticed, and I think we have to continue to let folks know that are not following the law and are bad actors, and we know both in our municipality and beyond that those bad actors certainly exist on an everyday basis. I know we were both in the city first thing this morning and on an unrelated issue. And these issues come up quite frequently, knowing that this is a rampant issue. So thank you for your continued work and partnership there. I wanted to touch upon, if I could change gears for a second or two, and just get some clarification around SB 1235. And there has been some testimony related to SB 1235 around some questions around licensing or changing of the licensing process or revocation and the hearing process and things along those nature. So I just wanted to give you first an opportunity to talk about some of those changes that have been mentioned in testimony in sections 2 and 4 have been highlighted in pieces of testimony that have been posted and shared with us prior to the hearing and talk about some of those changes and the reasons for some of those changes as you're proposing them from the agency.
Sure. The main thrust of the changes there are the lotto agents at the retail establishments. And we've handled the licensing of sales agents the same since the 90s, but there was apparently when the laws were rewritten about 6 years ago, some areas where it didn't carry over and we lacked some enforcement with regard to the ability to regulate lotto sales agents. And so there are instances where we do need to take enforcement against them where they are, well, one example that's comes to mind a lot lately is we've seen illegal slot machines in entities that also have retail lotto machines. And so that's illegal. And so we will seize the machine, but we will also take action against the retailer for having such a machine in their establishment. So these are necessary changes to let us take that enforcement. With regard to, let me just clarify, because I think that there's been some confusion and it's on us in terms of the drafting, which is going to be rectified. But all of this will be covered and is pursuant to the Administrative Procedure Act. So everything will happen with notice, due process, opportunity to be heard, and a hearing, for licensees if that's the case. So I'm not sure specifically if you had questions about.
I think that's a great start to kind of level set. As you mentioned, as reading through the testimony, there seems to be some difference back and forth with language or possible opportunities to continue to work on the language. So I guess my follow-up question, you mentioned some specific instances. How rampant is that through the system, or how many cases do you have open right now that has kind of served as a catalyst to look at these changes around behavior with folks that are, in the field with agents?
For the lotto sales agents in particular,
Yeah.
I don't have those stats. So we can get back to you with those, but I'll follow up if that's okay.
Sure.
Yeah.
That would be extremely helpful. And thank you for kind of laying out what a catalyst may be or reasons why you're looking at some of these changes. And then there was also some concerns around cause versus good cause. And that was laid out in some of the testimony specifically
Yeah.
from the lottery. And if you would be able to touch upon
Sure.
that.
Well, the change was, so again, we are continuing to work on this language and we'll work with the committee and the lotto and recognize their comments and take those into account as we have these conversations and dialogue. Really the thrust of changing, taking out the good cause was to be a little more transparent, quite frankly, to lay out exactly what good cause meant in the department's view. So under these certain circumstances, then the department could take action rather than just a general for good cause. So it actually enumerates in those series of subsections in the bill what good cause means to the department.
Okay. And shifting gears to another section around advertisements.
Sure.
There seems to also be some maybe confusion there as to what exactly the definition under an advertisement is, or what is intended to be. So can you, or would you be able to provide some clarification and a little more direction, or is that somewhat of a work in progress to develop that definition a little bit further?
Well, let me just say this about I think that you're talking about section 8, the advertising.
That is correct.
And so really what the department is suggesting and asking this committee to consider is the prohibition of gaming entities from advertising on websites and other media where there's advertising for illegal gambling. So at the same time, and understanding that, when you place an ad buy with, say, Google, you're buying a block of ads and Google goes out and puts it on any given website. So, the entities would not be fined if they were on that website. It rather, if we become aware of it or we are made aware of it, we would then contact the entity and they have 10 days to cure it. So take it off a website that currently has other illegal gambling, ads for illegal gambling, out-of-state operators, offshore operators. We don't think that they should be advertising on the same websites that are promoting illegal gambling. And so in that 10 days, they can just take it off or direct the advertiser to take it off. If it's not cured in 10 days, then we can take some type of action. But really, it's just a method to kind of tighten up the illegal and offshore and out-of-state gambling operators that are so pervasive in the state.
Thank you for that clarification. That's extremely helpful, and certainly we'll follow these as we continue to move through the committee process. And just a follow-up question, didn't have a chance to ask you at the informational forum. We heard from the lottery, and I know we'll hear from them again today, but wanted to follow up around their gaming system and kind of just get a status today as to, that relationship with some of the history that has played out in the last year or two with some of the issues. And we know that that does happen with something that transformational, something that prominent of a change in an organization, but wanted to be able to have a chance to ask you as the commissioner about that issue and just now the ongoing relationship and, how we continue to move forward and, work with that relationship there.
So with regard to the retail operations of the operator, IGT is what you're referring to. Yes, the lotto did convert to IGT. There were some struggles there, and we worked through a lot of them. I think that our relationship, we have a good line of communication with the lotto. There are some challenges with IGT that we continue to work through, but it's safe to play lotto. I mean, it's lotto is functioning at retail just fine, but there are issues that do come up, particular to that vendor that we work through.
And as we've talked about several of the bills that are in front of us around transparency, around, full disclosure, around being able to, you just mentioned on the advertisement piece, looking at how we communicate. I think it's important, obviously, with any regulator or any relationship between regulator and corporation or regulator and organization, that there is that back and forth, that there is that trust that works both ways and ongoing communication. I think one of the issues that the reason why this has come up frequently is we know that the issue is being dealt with, but we do want to see that constant communication with the regulator. That relationship only grows. It only is more successful and prosperous as is the lottery when there is that back and forth. And that's something that, being up here for 5 terms now, it's not the issue itself. It's sometimes the lack of communication following a blemish or following a misstep or following a hurdle that we couldn't predict. And in fairness to the lottery, there's things that come up that, an organization can't predict, but what you can generally follow up on is what happens afterwards. What you can't control is what you do afterwards. So what is the expectation? I guess my final question would be on some of the things that may have not been reported timely. Like, what is the timeline if there is a significant issue around, or as there had been with the transformation, the changeover of this system overall, that the lottery is to communicate with its partner, with its compliance officer, with its regulator? Is it a day? Is it 2 days? It's a week? You said ongoing, there's constant communication. But under those circumstances, where there is something that would be deemed significant or something out of the ordinary, what is that communication? What does that timeline look like? What does that communication look like?
Well, if I may take a bit of a journey here to answer the question, actually, I think that you were asking in a couple prior questions, but I guess I'll start by saying that when I started this role, it was a month before the conversion was to be launched with IGT. And you do flag, and it's very important, and it's the key word here is communication. And I think that between today and when I first started, communication is vastly different. That was the issue with what happened during the initial rollout of that. It could have been communicated in a much better fashion, and steps have been taken to make sure that everyone was aware and on the same page of what we were to expect as regulators, as the Lotto, the public, in terms of how such a big undertaking of a retail conversion of this nature would affect everyone. So that set the stage for kind of what followed. But I will say, you know, since this summer, things have gotten a lot better in terms of communication from the culture. I think it has changed a bit at the organization in terms of a spirit of communicating in a better fashion with the regulators. And that started with a training that the Lotto had, reminding them that all the Lotto employees are function as regulators with regard to the lottery. And so that, I hope and believe, did level set the spirit of communication and cooperation that would and will exist between the two entities. With regard to the particular issues, it depends upon what the matter is, and I think it's within a reasonable amount of time, or is there an exact number of days? Yeah, I think that in general, I mean, it's, you know, immediate, but we can get you the details of, you know, any certain circumstance and kind of what the expectation is in terms of how it should be communicated. Let's just say this, I don't think it's a surprise to Lotto what we expect in terms of communication. And if it is, we can have more discussions about that.
I appreciate your thoughtfulness and kind of working through what is kind of transpired, what the history is, and obviously, since you've taken over as commissioner and there's a change in leadership at the lottery, it's promising to hear the way that you've laid this out. And obviously, with changes, sometimes that's extremely important to reset a relationship and to develop what the expectations and the parameters of that relationship is going to be. And that certainly sounds like it's happening now. So kudos to you and your staff and to the lottery and to the leadership there for resetting and for, you know, moving away from what some may not consider an exactly transparent relationship and an open relationship and as it exists now. So that's certainly encouraging to hear. Appreciate your thoughtfulness and kind of laying that out and what expectations are, as it's important for a regulator, I believe, to have those expectations clearly articulated so that there's no question as to what in return has to be given back. So I appreciate all of your questions and answers today and your ability to be in front of us and the way that you so effectively lay things out and what your agency does every day. We're so appreciative of your leadership and your agency's work. So thank you, and thank you, Mr. Chair, for the opportunity today.
Thank you, Representative Paolillo. Sorry. I have one last question. What's more fun, answering questions from Chaz and AJ or answering questions from us? All right, you don't have to go on the record with that one. Thank you very much,
Thank you.
Commissioner. And at the beginning, I forgot to state that the first hour is reserved for public officials. We are nearing the end of the first hour. After that, we will alternate between public officials and the general public until all the public officials have testified, and then it'll just be the general public. So thank you very much. Madam Clerk, I believe next is DECD Commissioner Dan O'Keefe, and he's joining us remotely.
I am. Can you hear me okay?
Yes, we can. Please proceed.
Great. Good to see you all. Sorry to not be there in person. So good morning, Senator Maroney, Representative Lamar, Senator Ciccarella, Representative Vertigliano, and members of the General Law Committee. My name is Dan O'Keefe. I serve as Commissioner of the Department of Economic and Community Development, the DECD, and also as the state's Chief Innovation Officer. And I appreciate the opportunity to submit testimony today on the governor's proposed Senate Bill 1249. I have also submitted written testimony. Prior to entering state service, I was a technology investor for 25 years, and I witnessed multiple waves of technology adoption, starting with the desktop, and then the commercial internet, and then the ubiquity of smartphones. Each wave was larger than the last because it was built on the connectivity, the network before it. And each has ultimately propelled our economies and our societies forward by unleashing a new wave of productivity and allowing us more time and more resources to focus on higher value innovation. Machine learning is not a new technology, but what we are seeing now with the broad adoption of artificial intelligence represents a massive economic opportunity. It is poised to revolutionize the global economy by enhancing productivity, fostering innovation, and driving efficiency across nearly all industries. We need to work to position Connecticut and our workforce and our industry and our constituents to take advantage of that opportunity while also ensuring that AI is used responsibly and in full compliance with the state's strong and long-standing non-discrimination and consumer protection laws. Governor Lamont aims to prepare the state for such technological advancement through the policies outlined in this bill. First, it amends the Connecticut Unfair Trade Practices Act to make it clear that the use of AI does not absolve one of our laws. Individuals and businesses are obligated to abide by the law, regardless of whether they are using a novel technology such as AI or any other technologies that the future may bring. Connecticut's non-discrimination laws are well known, successful, and battle-tested by numerous court challenges and established case law. We should work together to ensure they are fully enforced rather than construct an untested and potentially confusing structure of parallel state-by-state regulations that could ultimately deter innovation. Next, we do recognize that there are concerns that AI might inadvertently introduce bias into consequential decisions. I believe that once properly trained, AI could ultimately be less discriminatory than a human, given the subjectivity that occurs in many such consequential decisions. Much like a human, what matters is how well the model is trained. So next, this bill empowers the state's chief data officer to make data sets available for AI developers while respecting all necessary privacy protections, thereby enhancing the training models for AI with real-world data and furthering Connecticut's attractiveness to innovators and the firms they create and sustain. Next, the bill allows multiple agencies to create an artificial intelligence regulatory sandbox. Such a program will allow an applicant to temporarily test an innovative product or service on a limited basis under a more flexible licensure or regulatory framework. Recommendations for legislative proposals to implement such a program would be reported to the Commerce, Banking, Insurance, and Public Health Committees by next January. Finally, this bill establishes an artificial intelligence and quantum technology investment fund at Connecticut Innovations, the state's public venture capital arm. This fund would invest in Connecticut companies that develop, manufacture, utilize, or deploy AI systems or quantum technologies. Connecticut Innovations will manage the fund and make investments or co-investments in such businesses. Thank you so much for your time. And with that, I would welcome the opportunity to answer any questions you may have.
Okay, thank you very much. Are there any questions? I'll let members of the committee ask questions? I know I have several, so I'll let anyone else go first. Anyone online? Okay. All right. Commissioner O'Keefe, thank you very much for coming to testify. Want to applaud you on regulatory sandboxes. I think that's something we've seen in the Utah legislation that passed last year, as well as in proposed Texas legislation, Virginia legislation, and it will be included in SB 2 as well. Also, I want to applaud you on the data. I think that was, or the governor's staff on the data, making that available for training. I do think we have to do some work there to make sure that we have the appropriate guardrails in place. You know, the proposed legislation allows people to opt out of the use of their data for AI training. I think we may want to look at some stronger privacy enhancing measures, perhaps just creating synthetic data sets based off of our data sets so we can protect the privacy. Again, the majority of the people probably didn't realize what this data was going to be used for. So just to make sure that we're, as you said, putting those privacy guardrails in effect. You know, I also wanted just to ask a question. I think, you know, in traveling around, it seems it comes down to really, to be a leader in innovation and in AI, especially, there's three aspects. It's access to data, access to compute power, and workforce. So I'm just wondering if, you know, there are other bills that are coming forth that we're going to look at increasing access to compute power and access to workforce development. And if not, yeah, I just wanted to ask about that.
Yeah, so I can answer on the compute side of things. So, and then I'll talk about workforce. I just want to acknowledge that the Governor's Workforce Council is well administered by the DECD, is separate from the DECD, but I can still comment as a member of that committee. On the topic of compute, look, I think you're absolutely right. I mean, you know, all of these innovations have at their core, you know, the necessary infrastructure and resources to enable them. And compute does, in fact, sit at the core of what's required to enable AI. What I wrestle with is whether or not that compute necessarily needs to be within the four walls of Connecticut when compute is available, you know, from other areas, whatever those areas might be, just given the connectivity that our world has. You know, we have had a series of conversations as the DECD separate from this bill about establishing access to compute. I'm not at the point at which I can publicly announce any specifics around it, but we have initiated a series of conversations and sourcing, and in fact are working on an RFI to actually look towards either procuring compute externally to Connecticut or seeing if it's economically viable to build or create it or incentivize it within the four walls of Connecticut. But I do think your question is the right one. I think making sure that our industry, our higher ed research institutions, and our startups have access to compute to be able to test and deploy some of these new technologies, you know, is an important asset for the state. So again, we are working on it, but I don't have anything to publicly talk about now. As it relates to workforce, look, you know, first I want to thank you because you have been a leader in workforce development, and I appreciate what you've created with Stony Brook, and I think that's an example of the kinds of programs we need to work on and establish to prepare our workforce for these challenges. You know, there is a risk here that you know that artificial intelligence redefines the nature of work in certain industries. But that's also an opportunity. And by the way, that's been a risk at the adoption of every one of these waves of technology. That was a risk that concerned people when desktop computing became ubiquitous. By the way, that was a risk people highlighted going all the way back to the printing press. What happens is you need to take advantage of these opportunities and retrain your workforce such that the workforce is enabled to use them as a tool rather than, you know, their work necessarily getting replaced by it. I think more work needs to be done here. As you know, the Governor's Workforce Council is capitalized with $145 million of resources, and this is one of the areas that they're currently focused on.
Great. Thank you very much. Agreed. I think with access to compute, it's probably buy not build. I don't know how much sense it makes and the time it takes to building compute. So if we can procure access, and latency isn't as much of an issue for a lot of these developers.
That's right.
Workforce, again, agreed. Every technological revolution we've seen has created more jobs than it's displaced. However, I think we do as a government need to be very cognizant that there are jobs that will be lost, and we need to provide workforce training, upskilling, and reskilling in a very thoughtful way. Jobs for the Future did I attended a presentation they did. 1/3 of women are in jobs that are at risk of being fully automated by AI versus only 1/5 of men. Half of gateway jobs are at risk of being fully automated by AI. So I think it's, as you say, it's incumbent on us as a government to provide everyone the training opportunities to succeed. I think our neighbors, we compete with our neighbors. Massachusetts has a program. They're committing $100 million over 5 years to try to become a leader in AI. New York, Empire AI, $275 million over the next 10 years to try to make themselves a leader in AI. I do appreciate, I guess you're starting the Innovations Fund at CT Innovations. Let's go a little bit to the regulatory pieces.
Before we go there, Senator, may I just comment quickly
Sure.
on Massachusetts and New York? I think this is important to mention. One, I think you're right. We spend a lot of time competing with other states. We compete for businesses. We compete for, frankly, population. But at the same time, I actually think New England is comprised of smaller states, but as a region, we're quite powerful. And I actually think there's an opportunity to collaborate more, particularly when you see this kind of a wave of innovation. And I am in close conversations with my contemporaries in both New York and Massachusetts, talking about ways we might collaborate. And then you mentioned the announced investments of both Massachusetts and New York in AI. I would be remiss if I didn't mention our own investments, which predate theirs, by the way, which was Innovation Clusters, which is a $100 million program focused on the application of next generation technologies, including AI, but as they apply to our core industries. We've announced 3 finalists for that. One is the application of AI as it relates to financial services. I'm going to put these in very summary terms. The second is the application of AI and quantum as it relates to drug discovery and biotech. And the third is the application of AI as it relates to advanced manufacturing and insurance services. So we are continuing to move forward and expect to finalize that program later this year.
Great. And so it'll be later this year when you'll announce winners?
Yes.
Okay, great. And agreed, it is important that we work together with other states. My friend Delegate Maldonado from Virginia likes to say this is a we problem, not an I problem. And so, just as you've been dealing with your contemporaries in the other states, I've been working with legislators around the country. I think our working group, which we've invited, not you, but we've invited members of the governor's office to attend our working group meetings, but it's 47 out of the 50 states who have been working together. Now, you mentioned relying on existing laws as part of this regulatory strategy. Are you familiar with the existing laws going to the Uniform Trade Practices Act? I believe you started with. I don't know if you're aware, but the Oregon and New Jersey AGs gave opinions on how you would need to comply with their Uniform Trade Practices Act and their laws against discrimination, both states that have similarly strong laws. But Oregon states an affirmative duty to disclose when you're using AI to make the consequential decisions. That was from the AG's opinion, as well as because they have a similar data privacy law that we do, they are requiring the right to opt out of processing from their data privacy. But the interesting in New Jersey, they stated that in order to make sure that you don't go afoul of the laws against discrimination, they recommend testing your AI systems and ongoing testing of your systems. Now, one of the issues with the testing is that this been brought up in a Future Privacy Forum report. Their large companies are having trouble getting access from the models. And I think by stating that putting AI is not a defense against discriminating in the laws. It seems that we're opening this up to litigation against Connecticut's small businesses and protecting potentially out-of-state developers. I don't know if you'd have any comment on
Well, so that certainly wouldn't be the goal, to state the obvious. Now, so first what I would say on other attorneys general producing opinions, that again, AI or really any technology does not absolve one of our existing laws. I have asked the attorney general to consider a similar opinion. Obviously that will be up to him and his office, but I for one would like to see something similar done in the state of Connecticut. Second thing I would say is, on the access to models and what ultimately introduces bias. I mean, the way I look at this is I model it after the real world. Humans can be biased. And my view is if a human introduces, discrimination that is against our laws, then that human needs to be either, sort of taken offline, if you will, and retrained, potentially, no longer allowed to make those consequential decisions. I view it as the same thing here. The goal is not to protect out-of-state offers by any actors by any means. The goal here is simply to say, is if the system produces discrimination or algorithm or bias that is against our laws, then the system needs to be fixed. The system needs to be retrained. The system should be taken offline until it is retrained. So to me, it's very much analogous to what happens in the real world today. What I wouldn't want to see us do is introduce new regulatory requirements when other states haven't done the same. I view this, my fear is that we end up with early patchwork of state by state regulations that makes it very difficult for innovators who are not out there trying to introduce algorithmic bias. They're just simply trying to innovate, make our systems more productive. That kind of patchwork might stifle innovation. I think we just need to have a balance between creating opportunity and making sure our innovators know Connecticut is a place where innovation can thrive, while continuing to protect, our consumers as they expect.
And agreed. I think we want to make Connecticut a leader in responsible AI innovation. The difference between discrimination from an AI system and a person is that you can test for it in an AI system and definitively know whether there is bias in that system. And as you say, you can retrain it and fix it, which would kind of lead that we're agreed. We don't want to introduce unnecessary bias. We want to fix that, right? And if possible, have a way that businesses can test. Now, using the CUTPA allows for a private right of action. So it would allow for the suing of Connecticut small businesses, but then we'd be saying AI was not a defense, so that it would say the developers were not responsible, our small businesses would be responsible. And then we're opening this up for litigation to determine how AI is going to be used. Are you familiar with Illinois' Biometric Information Protection Act? It was passed in 2008. The first lawsuit was just settled. And so it was 15 years of tying up litigation. And so I think from what I've heard, businesses would rather have certainty. And I don't know, do we want to rely on litigation over legislation?
Yeah, again, this feels like a resolvable problem. Again, I think we're agreeing that the goal here is not more litigation. The goal here is not certainly putting a burden on our small businesses. On the point of testing, I just, and I say it's a resolvable problem because I think we can make sure the language reflects what is the ultimate intent here. On the testing concept, I just want to make sure we say to our innovators and our businesses, if we're going to regulate you and say you have to pass a bar, here's where the bar is. And so being able to say as regulators, as legislators that here's a set of testing data, for example, that you must test against and demonstrate that it has a score above X. That's the kind of testing where a business can predict around it. Simply saying to someone, you must test for algorithmic bias and not introduce it, that to me is like saying, we don't know where the bar is, but you got to tell us you've cleared it. And that I think is a nebulous regulatory standard. And I'm not sure that's what you're saying, but that's what I would be concerned about. And again, it's just the concept of giving certainty, as you said, to businesses to know what's required. And I think that's one of the challenges when a space is so early in its development. And you made a comment, or someone made a comment in the prior testimony about how, I actually think it was you, Senator Maroney, about how oftentimes business can move, or technology can move quicker than regulators or governments can adapt. I think that's the case here to the extreme. And so I just want to be thoughtful and careful, as I know you all do, as we understand what the applications are, understand where there might be points of concern and problems that get introduced, but then also have a regulatory framework where we can say, no, we understand this. So here's the data, here's the testing, here's the models. You have to run it against this understood framework and make sure that's where the bar is. And now you can actually tell us you've cleared it.
Okay, thank you. I think here's where we agree that we should be offering a pathway to compliance for our small businesses. We should be offering tools for them to comply. Perhaps creating a Connecticut AI Safety Institute where we allow them to test their models so they would know when they are in compliance. There is a federal standard for discrimination, and it's the 4/5 rule. So that would mean if we were to run a test data set and using your hiring algorithm, if it came out and you hired, based on whatever the standards, if you were Caucasian, 90% were approved. So actually, let's go to, there was a study by Lehigh last year they released where they're using ChatGPT to make mortgage decisions. If you were white and you had a 640 credit score, 95% of the people were approved. If you were black and you had a 640 credit score, only 80% of the people were approved. Now, that actually, by the federal standard, would not be disparate impact. It sounds, I think anyone who's listening, that we don't want that. We want to fix that. And there's a good news, but that does not meet the bar because, 80% of 95%, I'm going to have to math. It's a little early for mathing, but let's pretend I said 90%, that it would only go to 72%. So it would have to be below that. So there is a bar. There is an established, I guess, is what I'm trying to get at. So I think that we want to make sure, and algorithmic discrimination is not new. Algorithmic bias goes back 2014 or before. There are lots of examples. So I don't know when the line is when it's time that we're able to regulate. And so I think just last week we had the Attorney General coming in on his social media feed bill. And I think if we could all wind back the clock 10 years, we would have made some changes there with things that now are foreseeable that may not have been foreseeable then, and there are things we can definitely see now. And then I guess my last question is, if there is testing, right? If let's say the AG comes back with his opinion, and just like the New Jersey AG says that you have to do testing in order to comply with our laws against discrimination, how are we going to ensure that the companies are providing the information to the Connecticut businesses?
So I understand your question. Providing what information?
The information necessary to test their models. Again, we've said that AI is not a defense against discrimination. So the people who have, at least in this initial proposed bill, and we look forward to working together to get to a resolution, but it says that AI is not a defense for discrimination.
Yep.
If you're a deployer, right, if you're using that, because it's the use case, it's not always the technology. It's how you're using the technology, if you're introducing any new risk into the system. But one of the issues has been for smaller businesses that are trying to test, even big businesses that are trying to test AI models, the developers don't always give them the information that they need.
Got it. Well, look, I think as always in these cases, the devil's in the details. So I think that's the kind of nuance and the kind of degree of details we would have to understand and figure out. So I don't have the answer to that question here today. What I would say to you is, and you made the comment, the predecessors to what we now refer to as artificial intelligence aren't new. Machine learning has been around for a long time, decades, and has played a role in many of these decisions on an automated basis for that time frame. And you mentioned testing doing with ChatGPT making mortgage decisions. ChatGPT is a generalized AI tool, which has a lot of consumer awareness for all the reasons we understand, but it's trained on the internet. And I think we all know that something trained on the broad internet is not necessarily going to be without its bias, because Lord knows my Facebook feed is filled with biases. And so you wouldn't use ChatGPT or a generalized, what that test was run on to make a consequential decision around a mortgage. Or if you did, you're subjecting yourself, I think, to action based on our existing protections. I think ultimately what we're saying here is rather than create a parallel path of regulatory frameworks, let's work and adapt the existing ones that we have today, which are established, strong, and again, backed up by case law. In the case you just described, the ChatGPT and the mortgage decision, et cetera, we have a standard, right? So if the outcome is demonstrated either through that federal standard or our own to have introduced biases, then you need to fix it. You must fix it. Now, whether or not you have to what you have to disclose and what degree of data to demonstrate that you have disclosed it, that's a degree of detail I think remains to be worked out.
No, agreed. We want to make sure we fix bias. And in that example of the Lehigh study, the good thing is once they determined the bias, they went back and changed the instructions and said to avoid discrimination. They programmed it in and they were able to get equal determination.
That's exactly. I would love to see an automated approach to that kind of decisioning that's trained on data that's demonstrated to not introduce bias versus, frankly, a human who might be trained based on their Facebook feed. Right. So I actually think this is going to take some time, but I think this is actually an opportunity to reduce bias in some of these consequential decisions. I actually think it could be a long-term positive outcome.
Agreed that it could be a long-term positive outcome, but let's go back to something you had said earlier. AI depends on the data that it's trained on. So
Yes.
until we know how we're training and we're making sure we're properly training these systems, it may not be positive yet. So I think that transparency is a key factor as we move forward.
And I would just encourage us to focus on outcomes rather than trying to allowing businesses to iterate. Right? Businesses can move at the speed of business. And I don't think they're sitting around trying to figure out how to introduce bias. So allowing businesses to iterate and understand and retrain data to get to the outcomes we want to see as regulators, as members of the legislature, as a society. I think that's where government should focus, and rather than trying to get into the details of, that iterative process.
Agreed. I think we should be focused on use cases and not the technology and high risk use cases. So that's another point of agreement. It's just how we get there, and hopefully we can work together to get there.
I'd like that.
Representative Yacarino.
Thank you, Mr. Chair. Just one question. To thank you, Mr. O'Keefe, for being here. I just read through the bill and, some of the new the language. It does have procedures for protecting individuals and just having determination and unlawful practices, avoiding that. And I would think, and I have to agree with the commissioner, this AI has been around for quite a while. Hospitals have been using it for a long time. Businesses obviously are using it. The science community uses it. And higher institutions have been using it for years. But I think when I'm reading the approach that under Senate Bill 1249 is, I think, the right approach, because we want to let the businesses foster, and they're going to grow through their own innovation and competition. But in this language, it does have protections for the individuals and for people. So I'd like to just get a response from the commission if it's okay. Here, Mr. Chair.
Well, yeah, no, but look, Representative, I agree. I think that's thank you for amplifying the point we're trying to make, which is there are existing protections, and I think it is a more streamlined approach to make it clear that those existing protections apply here, regardless again of what the technology or the tool that might end up. Whether or not you use a computer, whether or not you use the internet, whether or not you use a calculator, whether or not you use a spreadsheet, to me, none of that matters. Much like whether or not you use AI, none of that matters if you ultimately break an existing law or element of consumer protection.
I agree. And I think it's a prudent approach, and such a fast growing industry that's been around for quite a long time. Like I said, longer than I think most of us realize, and it's going to continue to grow at the speed of light, to be honest. Just going to keep growing between quantum mechanics eventually and other mechanics and the sciences and the data centers. So I do like this approach, and I appreciate the commissioner's time and your time, Mr. Chair.
Thank you. Are there any further questions? Oh, Representative Lamar.
Thank you, Mr. Chairman, and thank you, Commissioner, for your testimony today and for the governor's introduction into the conversation around regulations and AI. I do think it's an important step that the governor has taken, and you at the lead of that step, to formulate what we think an appropriate Connecticut regulatory structure can look like. I do think this conversation is a fertile ground, and I think states across the country are entering into it collaboratively. I'm not, I think, as concerned with potential patchwork of regulations across the state. I do think the evolution of this industry is paramount to long-term economic development success, advancements in healthcare, advancements in technological innovation across multiple sectors. I do think the use of AI will be a widespread component of everyone's life moving forward in ways that we cannot now or ever could have imagined. I think 10 years from now, this will look like a completely different conversation, and we'll harken back to this committee hearing today and the ones that had 2 years ago and the ones that we'll have 2 years from now, and wonder why we didn't see or foresee the evolution of this industry in quite the same way. So I guess I'm not as concerned about the potential for patchwork of regulations, given that this is going to be something that we revisit year after year moving forward as we start to recognize the true development of the industry itself. And I don't think, and this is where I think I would like you to offer some guidance. I don't think businesses are making widespread decisions about where to invest or how to invest based upon the early stage regulations that have been proffered in states across the country, whether it be Texas, Colorado, Illinois, California. Different states have taken different approaches. And have you seen businesses refusing to invest and or take part in states that have entered into this fray at this point?
Well, so and by the way, Senator Maroney has an expert's knowledge of what each state is doing and where they stand. I do not. I only know of Colorado having passed, comprehensive bill last session. California vetoed it, and again, I want to be careful because Senator Maroney will correctly comment that portions may have passed. So when I say vetoed, I'm talking about the broader bill. But what I would say is in Colorado, there was a letter from I forget the number, but it was hundreds of their businesses saying, being now the first and only state in the country that has introduced AI regulation is a point of concern. And the issue I have with it is it's not because I'm anti-regulation. I think we need to be protecting our consumers and reflecting established protections and making sure they extend into this world. What I'd be concerned about is when I talk about this concept of patchwork, we are deeply in competition with states. Look, I'm from Massachusetts. I joke that my parents chose Massachusetts, but I chose Connecticut because I've been raising my family here since 2011. So I can say this. I feel deeply in competition with Massachusetts. As the steward of economic development in Connecticut, I want to beat them. And one of the industries, one of the clusters that we've really seen emerge here is what's happening in the biotech cluster. And that's where we have real comparative advantage, particularly with the IP coming out of our higher ed institutions. And we recently announced, for example, a more attractive R&D tax credit for the biotech cluster. To be clear, we're in competition with Massachusetts to continue to attract that innovation into the state of Connecticut. If we have a regulatory framework and Massachusetts does not in this category, well, you might say, even if you just got to read it and you'll realize that it's not that complex and it's relatively straightforward. It is the simple fact that there is a regulatory burden in our state that doesn't exist in Massachusetts that I would suggest renders us less economically competitive because startups aren't going to read the bill. I was a technology investor for 25 years. I didn't read a single bill. If I heard that one state had a regulatory burden and another state didn't in an area in which one of my companies was going to innovate it, that was it. That was the end of the conversation. So that's why I say, I would rather see federal regulation here. I think we all know we're not going to see that. The vice president had remarks last week, which made that very clear. In the absence of federal action, I would at least like to see regional collaboration. I would at least like to see frameworks that are harmonized such that this local competitive element that every state is faced with is part of the discussion.
And I think that's a fair backup plan, right? Like I agree with you that there is not going to be federal regulation that is comprehensive and or scope specific to what we're concerned about for Connecticut residents. And I think my worry is absent that federal guidance, we're all going to be held to the lowest common denominator across the country, and it's always going to be used against us that North Dakota hasn't done this, so why would Connecticut? Well, won't all these businesses just locate to some other state that has failed to enter into this conversation? And so maybe a regional approach is a better approach, but we've seen the limitations of that approach even in your own space, where state after state will continue to submit the lowest common denominator. Like, oh, if you relocate your corporate headquarters to the state of Massachusetts, you don't have to pay corporate income taxes for 25 years, or we'll give you $500 million in bonuses in Connecticut if you relocate from New York. Like, we all enter into this level of competition that doesn't necessarily serve the interests of Connecticut residents, but it's business specific and it's intended to comply with a level of competition that is existing in the current marketplace. And I'd hate to have us forego regulations in this space, which we recognize the potential for real serious problems and serious consequences for Connecticut residents if we don't have some regulatory structure in place.
Yeah.
I hate for us to forego that regulatory process or that regulatory concern, or put in place concerns that we think are important for Connecticut residents to have.
Right.
Just because Massachusetts or New York hasn't done
Yeah.
it. So
And-
I think that's the fertile conversation that we are going to have for the next few months. Like, I get to rely on Senator Maroney's work on this in this space and fall back on that as a well-researched and well-reasoned local look at what regulations can put in place.
Right.
But at the end of the time, I know in New Haven, the most likely people to fall victim to an unregulated marketplace are people who are not allowed access into apartments because the AI system wasn't trained properly and we don't have local specific protections, or a hiring choice was used on an algorithm that hadn't been properly vetted and doesn't comply with a regulatory structure that we would have put in place in Connecticut,
Yeah.
except Massachusetts didn't do it, so we didn't do it either.
Yeah.
Right? So those are the concerns that I have moving forward, and I'm thankful that the governor has entered the conversation in this space, but I think we need a little bit more meat on the bones at this point. And so that's where generally I think I'm heading, where I'm hearing House members are headed as well. Thank you.
Yeah.
Great. Thank you, Representative Lamar. And yeah, I think it's not just startups who don't read the legislation. I think a lot of times walking around this building, there are a lot of people who don't read all of the legislation. Just, one last thing, yeah, agreed, a regional approach would be great. I think you may be happy to know that New York, Massachusetts, Maryland all have Colorado-style bills being proposed. And then back to California, the bill that was vetoed, you referenced 1047, it's been reintroduced as Senate Bill 53 this year. It was catastrophic risk. It was really not the same thing as what we're looking at here, but the bill that was passed and signed into law was 2013 in California, Assemblymember Jackie Irwin, and that was on data transparency. Again, getting at that issue that we need more transparency so that we can test systems to make sure we're not, as you mentioned earlier, that we're starting with the right data to train them. But again, I look forward to working with you going forward, and thank you for coming here to testify today.
My pleasure. And I look forward to working with you all as well. Thank you so much.
Okay, I believe that was the not the last. I believe we've gone over the hour. So now we are going to go to the public. Madam Clerk? Ms. January, are you on?
Hello, good morning, Chair. Yes, I'm on.
Good morning. Please proceed.
Good morning, Mr. Co-Chairs and esteemed committee members. Brianna January with Chamber of Progress in strong support of SB 1249. Chamber of Progress is a tech industry coalition advocating for the progressive future of tech and inclusive access to that future. Our partners do include household names like Amazon, Apple, and Google, as well as smaller AI innovators, but I will note that they do not have a vote or veto on our positions. Committee, AI has the tremendous potential for improving education, enabling creative expression, and creating new business opportunities. So it's critically important to us that public policy promotes the broad and equitable distribution of these innovations. And we believe that the governor's prioritization of developing AI in Connecticut, as set forth in both his proposed budget and the mechanisms of SB 1249, do so, and that it's the correct balance and will drive the Commonwealth as a model state for the region. In fact, Commissioner O'Keefe's testimony earlier outlined the exact approach that Chamber of Progress encourages public bodies to take regarding potential bias, and we thank the governor and commissioner for advancing this thoughtful policy. In particular, we support SB 1249's creative innovation through AI regulatory sandboxing, the streamlining of data management for agency efficiency, and for providing economic growth through the AI Investment Fund. We strongly encourage your support for SB 1249, and we look forward to working with the Commonwealth to implement the governor's AI proposals. I would also like to quickly comment on SB 1248 and suggest a few small amendments to improve the bill for both residents and the industry alike. As drafted, SB 1248 does not reflect the complexity of some three-sided online marketplaces and could risk unfairly penalizing platforms for third-party listings. In three-sided online marketplaces, whether they be lodging rentals, home sharing platforms, independent sellers offer and set the prices for their goods and services. The market operator themselves then connects those independent sellers with customers, and they may offer additional services like processing, safety checks, identity verification. In those sort of marketplaces, the sellers set the prices posted on the marketplace platform. So SB 1248 as drafted, the platforms could be held liable if a hotel or resort, for example, failed to incorporate all resort fees or applicable taxes into the price posted on their platform, but yet it would be that third-party seller that would still be held accountable. This could easily be addressed just by simply including a safe harbor provision that says that three-sided marketplaces and platforms that do not independently set the full price, such as those that I've just mentioned, that they are not held liable in case a hotel or resort, for example, fails to set all of those pricings. We're essentially requesting just clarification there that third-party platforms will not be held liable for external parties' failures to include all relevant fees. And then lastly, committee, in section 2, the bill requires additional disclosures and cancellation mechanisms, which in practice could make it harder for businesses to offer special deals or flexible services, discounts, etc. This could also then increase the
3 minutes are up. Would you mind summarizing, and then we'll go to
Absolutely. We're just requesting a simple amendment that would maintain both consumer choice and transparency while making sure that prices are not overly exploited for consumers. Thank you.
Great, thank you. And you're going to submit written testimony as well, correct?
We already have, correct.
Okay, great. Thank you. Are there any questions from the committee? Representative Lamar.
Thank you, Ms. January, for your testimony. Specifically with regards to 1248, I'm interested in some of the concerns you recognize regarding three-sided transactions. To me, like, again, the paramount concern is the Connecticut consumer who's subject to the lack of coherence between one party and a second party when they're making that purchase and how they go through the process. So I actually want to hear through ways that we can resolve that inherent conflict between the protections that we want to have in place for our consumers versus the challenges that two sides of that party may place. And so I think there's a space that both protects what your concerns are and how it's implemented, but also gets to our ultimate concern, which is the Connecticut consumer's experience. So I look forward to your conversations with respect to 1248. 1249, I'm certain my co-chair will have greater conversations on that bill, but I just wanted to preempt that conversation with a willingness to work with you on 1248. Thank you.
Thank you so much, sir.
Thank you. Are there other questions? Otherwise, I'll go into my questions. Thank you very much for coming to testify. You've been here to testify a number of times, I believe, in the past, or at least the Chamber of Progress has been here to testify. And I think this is the first time you're testifying in support of a bill instead of opposed to a bill. Am I correct on that?
For this session, that might be the case. There are surely other bills that we are supporting in the works, but this one is one that we are particularly pleased with.
Okay, great. Thank you. And I noticed you were at it. Were you invited here to testify in favor of this bill?
The governor's office did reach out to seek support, but we had already planned to do so, to be perfectly honest.
Okay, great. Thank you. Last time you were here, you were testifying against the AG social media feed bill. And again, let's go back. You started with some of your members. At that time, you named some of the members who funded the organization. Would you mind just sharing that list again?
Absolutely, I'd be happy to. We are a tech industry association that I'm sure you're familiar with other models. We are different from your traditional model. Our members are not actually members, they're partners. They include folks like Apple, Google, Amazon, Uber, etc. But they don't have a vote or veto on our positions. We actually lead from a center-left position as a staff, and we make our own position decisions.
Great. Is Meta also a member?
They are not actually. They partner with us for some European work, but not for domestic.
Okay, great. So, but a lot of those companies you mentioned, right, Amazon, et cetera, it would be safe to say they're tech billionaires, some of the leaders of those companies.
Absolutely, they are.
Great. Okay, thank you. Now, one of the things about the approach, and I think sometimes bills can be brilliant in their simplicity, and a good example of that would be last year, Illinois had a law that said that you could not. So the opposite of where we're going with this bill and where we're saying that AI is not a defense against discrimination, they went more proactive and said that you cannot use AI to discriminate, which then implied that you would have to test it before you're using it. Now, one of the things here is that we're introducing and we're saying it's not a defense, and we're relying on CUTPA, which is the Connecticut Uniform Trade Practices Act. That allows for a private right of action. And so it would allow for people to sue Connecticut businesses. Usually tech companies testify against bills that introduce a private right of action. The last one that actually passed with the private right of action was 2008, Illinois' Biometric Information Protection Act. I was wondering if you could share some of your thoughts on what has happened because of the BIPA law.
That's an excellent question. I would love to gather some thoughts more appropriately with some colleagues and get back to you in writing, perhaps. I will say that we have been engaged all over the country on private rights of action laws, as well as anti-bias and AI laws. Our approach is very much similar to what the commissioner outlined, which is we have no difference in our approach, whether it's human-based or algorithmic-based discrimination. We think that it's more appropriate to look at a state's existing anti-bias laws. And if there are any sort of loopholes that could be used by AI and algorithms, let's close those loopholes where they exist, because we don't care, again, if it's a human making decision, if it's the human inputting data into an algorithm that ultimately makes the decision. We want to get to the issue where it exists without stifling innovation overall.
Great. Now, due to the black box nature of AI, right, we don't require explainability. It's part of the White House's blueprint for the AI Bill of Rights to allow for explainability. But right now, sometimes we don't know how it's making the decision. How would we know if it's discriminating if we don't know the process of how it's making the decision?
That's a great question. And we support having testing done for AI data and training. I'll note that the governor's proposed approach to have kind of a set of data that can be used to help inform AI training models is an appropriate one. I would be concerned to make sure that we're having a robust input for who is selecting which data is to be used for that public availability. Training is important, and that's exactly why we're appreciative of the fact that this proposal includes a safe harbor, because ultimately we want to make sure that as companies are testing to make sure that their data is not biased, that if they find that there is some sort of issue, that they're able to, in good faith, fix that and not be in fear of having liable legal action when they're doing what they're supposed to do under a proposal like this, which is to find those issues, to fix them under good faith, and then get the data in a way that can be appropriately used without bias. So the safe harbor is really critical for us.
Okay, and so I think we have some areas of agreement here. We agree on
Absolutely.
testing, and it sounds like you agree on data transparency because you need to know the
1000%.
system is properly trained.
Absolutely, sir. 1000%.
Okay, great. Thank you so much. Now, back to the BIPA law. You know, it was passed in 2008. It took till 2019 before the first court ruling came out. And according to actually the Chamber of Progress did a great study on the BIPA law. According to your research from your organization, after that court decision came out in 2019 on how you could measure instances of harm, what constituted harm, lawsuits increased by 1,400% after that. So there was a significant increase in lawsuits from 2019 till the present. The first one was just settled. Now, this bill, it seems to rely on litigation rather than legislation again, because Uniform Trade Practices Act has that private right of action. And it says that AI is not a defense for discrimination. So in some ways, that takes the liability off of the developers, the out-of-state developers, and puts it on Connecticut's small businesses. It seems interesting that you're coming from an organization that's funded by these developers, and you're testifying to put the liability on our small businesses.
Thank you for that observation. I'd like to clarify that our members are some of the larger AI innovators, but they're also startups. They're also folks that have barely come into the marketplace and that are looking to make a splash. That said, the balance that we think this bill strikes is one that makes sure that those smaller innovators are not left out of the Connecticut market. Our fear is that overregulation will do just that. It'll ultimately end up creating a monopoly in which you only have the Amazons and the Apples and the Googles that are able to operate in the state because smaller innovators aren't able to keep up with the logistical, the administrative burden around testing, around the possible legal liability that they simply would not be able to afford to pay. And that's whether those smaller innovators are Connecticut-based or not. We think that this is the correct approach to balancing that. Small innovators are very much at a forefront of our approach to public policy and are members of ours as well. But we'd love to work with the committee to ensure that that balance is more appropriate if you don't feel that it's struck appropriately here in this language.
Yeah, and agreed that we need to offer, we want to incentivize responsible AI innovation. We want to offer a pathway to compliance and provide tools for our small businesses. And this, I guess, will be my last question. Businesses and small businesses, all businesses really, they're developing a product that they want to sell, right? They need customers. Again, this approach seems to put the liability all on the customers. But one of the things I'd ask if you're familiar with the Boston Consulting Group study from last year, January of 2024, where it said that 62% of the people they surveyed, 62% of the businesses that they surveyed were holding off on fully investing in AI until there were clearer government regulations.
I'm not familiar with that particular study, but that's exactly what we hear as well. I'll note that we share the concerns that the commissioner outlined earlier, that a patchwork of state law is exactly what will prohibit those smaller innovators from being able to comply all around the country and to enter marketplaces. So whether we take a regional approach that is more balanced to making sure that we can limit bias as much as possible, whether again it be by an algorithm or a human decision maker, and making sure that we can empower smaller innovators, or we take a state-by-state approach like we're seeing right now, but the overregulation of patchwork, especially in the Northeast with smaller states and with such regional cooperation in other economic areas, is extremely challenging for those smaller innovators for that very reason. So I'm not surprised by that data.
Right, and so that sounds like we're agreed that a regional approach to provide clear regulations and guidelines, and not even regulations, we're looking to provide guardrails, right, to protect against unwanted bias or discrimination.
Absolutely. We'd be happy to look at that approach. I am the director for the Northeast Government Relations for Chamber of Progress, so I am doing just that, working. Our definition of Northeast is a little generous. I'm working from Virginia all the way up to Vermont, as well as a little bit west. So I'd be happy to chat with the committee on how we can take that approach as well. Obviously, state level regulation can also be complementary to a regional approach.
Great, thank you. And I believe Virginia does have a bill that it made it out of the House and is poised to make it out of the Senate in the next week. So, great.
I've
Thank
been
you so
engaged,
much
yes.
for coming to testify, and I'm sure we'll be seeing you in a couple of weeks.
Just next week, I believe. Thank you so much, sir.
Okay, goodbye. All right, Madam Clerk. Please proceed, Mr. Swartz. Thank you. I'm sorry.
In the bill. Oh, is it on now? Okay, sorry. The changes outlined in this bill have the potential to streamline our operations, driving greater efficiency and enabling us to return more revenue to the state to support the valuable programs and services that Connecticut residents rely on. So Section 1 of the bill will give us more flexibility to help collect funds owed to the state. Under current law, former retailers who have failed to remit funds to CLC are required to pay the full principal, interest, and a 10% penalty. This can result in large assessments, making it challenging to recover the amount owed. By allowing these agents, most of whom are Connecticut small business owners, to apply for a hardship waiver, we would be authorized to negotiate a reduction of the interest. This change would increase our ability to collect overdue funds for the state while reducing the burden on financially distressed small businesses. Section 2 of the bill would allow CLC to utilize large distribution companies like UPS or FedEx to deliver scratch tickets from our headquarters to almost 2,900 retailers throughout Connecticut, aligning with industry best practices that provide potential cost-saving opportunities and give CLC a reliable option during emergency situations when smaller, less resource delivery service providers are unable to deliver tickets due to staffing or financial difficulties. This bill eliminates the requirement for distribution companies to have a gaming vendor license, as the requirement creates a significant deterrent for larger shipping companies because it requires gaming licenses for all employees working in distribution facilities and allowing unfettered access to their property and confidential financial and operational data. Almost all lotteries in the U.S. utilize these large distributors for delivery of scratch tickets to their retailers and shipping hundreds of millions of tickets daily. And these tickets have no value until they are activated by a retailer, which helps eliminate the risk and motivation for theft. Additionally, there are significant security measures in place to mitigate risk. These include unmarked tamper-evident packaging, as well as system tracking of shipments to confirm receipt and identify lost ticket packs. By removing this licensing requirement, we can expand our ticket distribution options and make the system more cost-effective and reliable without compromising security. Next, sections 3 through 5 focus on reducing administrative burden. Right now, it's mandatory for every CLC employee to be licensed by DCP as a condition of employment. We're just seeking a more efficient process that is just one single license per employee with appropriate endorsements from DCP. We've worked collaboratively with DCP to develop this proposal, and we are confident it will streamline operations without sacrificing oversight. Section 7 would reinstate previously agreed upon language that allowed CLC to accurately advertise online lottery draw games with an add-on feature that, for an additional cost, increased the patron's odds of winning a prize. The language in the regulation was agreed upon by DCP and CLC during the regulation-making process and addresses the uniqueness of the product. Last session, the legislature codified advertising requirements, but removed this exception. Reinstating this language would enable us to advertise the availability of such add-on features on the new iLottery platform. Taken together, these measures in this bill would enable us to operate in a more efficient and cost-effective manner, thereby generating and returning more money to Connecticut's general fund. Now, moving on to Senate Bill 1235, we truly value and support our partner agency, DCP, and their essential role in safeguarding players and promoting a fair and transparent gaming environment here in Connecticut. However, we do have serious concerns about certain provisions in this bill as written. I'm very encouraged by the fact that the commissioner mentioned earlier that he is open to the discussions and revisiting those with us. But if enacted as written, this bill would inhibit fundamental rights of every state employee, lottery sales agent, vendor, and vendor employee licensed to do business with CLC. I think it's important to recognize that I know the commissioner mentioned retail sales agents, but this actually impacts all employees as well as vendor employees, anyone with these licenses. It's not just retailers. So all individuals and entities that are required to obtain a license to work for or with CLC have a property right in their license and are entitled to procedural due process when DCP seeks to take action against that license. Unfortunately, this bill eliminates due process, lowers the standard required for punitive action, and imposes a highly restrictive and inflexible time limit for reapplying. Currently, DCP is empowered to suspend or revoke an employee, a vendor, affiliate, or lottery sales agent license after a hearing before the commissioner, which is in accordance with the Uniform Administrative Procedures Act. Both Section 2 and Section 4 of this bill seek to give DCP the authority to take additional actions against these licensees. So it expands it beyond suspension or revocation to include refusing to issue or renew a license or place conditions on a license, denying an application for a license, or even imposing a civil penalty on a license, and to do so without a prior hearing and without, at minimum, providing the licensee notice of the grounds for the action taken. Instead, DCP would be empowered to take action against a licensee, such as the suspension or revocation that would immediately impact that licensee's ability to earn a living, and then only after that action has been taken would the licensee have the opportunity to request a hearing. In the case of both managerial level and unionized state employees at CLC, revocation of their license would result in immediate termination because they can no longer work. This presents a critical issue. It strips the licensee of the ability to present their case before a decision is rendered and is contrary to the principle of due process and risks setting a dangerous precedent for fairness in future decisions. Furthermore, the bill grants DCP the authority to suspend or revoke licenses, impose conditions, and levy civil penalties, again, against employee, vendor, and affiliate licensees, not just retailers, without the requirement to establish good cause. Rather, DCP need only find cause, which is described in this bill as including a list of what I would say are highly subjective circumstances, such as lack of financial stability and failure to complete the application. This shift removes an essential safeguard against potentially arbitrary decisions that could jeopardize livelihoods. Now, finally, this bill provides that if DCP refuses to issue or renew, or they revoke or suspend or place a condition on a license, that licensee is now prohibited from applying for the same license for 1 full year. This is a significant penalty that is broadly and equally applied to all scenarios, even in circumstances where the basis for DCP's action could be cured in under a year, such as submitting a complete application. This creates a long-lasting burden on an individual's career prospects or an entity's business opportunities and could have a long-term financial impact. So while we understand the desire to enhance oversight, these changes would deprive licensees of their fundamental right to due process and could have unintended consequences, harming both the people and the businesses that make Connecticut's gaming industry thrive. We urge you to please reconsider these provisions and work with us to strike a balance that protects both the integrity of the gaming system and the rights of those who are integral to its success. Now, there's one more bill, and that's HB 5089 that impacts us. It proposes to extend the current ticket claim deadline from 180 days to 1 year. In 2009, CLC made the strategic decision to reduce the claim period from 1 year to 180 days. This change was not arbitrary. It was designed to bring Connecticut in line with industry best practices and to optimize our financial operations by reducing the time that CLC had to maintain prize funds as a liability. Making the change freed up funds more quickly and ultimately resulted in faster transfers to the general fund for the state's use, since the funds were no longer held in anticipation of claims that were not likely to occur after 6 months. Extending the claim period now would tie up more funds for a longer period, impacting overall cash flow and available funds for a general fund. A longer redemption window also opens the door to potential fraud. The change proposed in this bill would double the window of time at risk for fraud. And also, it's clear that the current 6-month redemption period is working well and is not a barrier for players. Neither us or DCP have received any complaints or concerns about this policy. There doesn't seem to be a pressing need to extend it. Thank you again for the opportunity to present these remarks, and we remain committed to working collaboratively with all stakeholders to ensure a strong and sustainable future for Connecticut's gaming industry. I'll be happy to answer any questions.
Great, thank you very much. I believe Representative Vitigliano, Representative Acker, and then Representative Paolillo.
I just have a couple of quick ones. That last part, when you were talking about the redemption period.
Yes.
I mean, it's a winning ticket. It's somebody's money.
Yes.
I mean, I don't know how there's no expiration date on a gift card in the state of Connecticut. So I don't understand. You're talking about somebody's cash. they should be able to cash it whenever they feel like. It doesn't really affect your operating profit or whatever you want to call it, because once you know there's a winning ticket, you should set the money aside in a different account waiting for somebody to redeem. So I don't know. I think 180 is pretty tight. I think just based on principle alone, I mean, it's not your money. Technically, somebody won it, and we should probably give them every opportunity they can to cash it in.
Yeah, and I think I don't disagree with what you're saying. I think what we found in the industry is that it's very few and far between that anyone is claiming tickets beyond 6 months. It's, a very rare occurrence. And also, the longer you make the period, the less, I would say, important it becomes for a player to make sure that they claim those tickets, right? They sort of forget about them and just they may never remember. But for us, it does free up the funds, right? So one of the things that they did in the past, when they changed it, it was they anticipated it was about $6.1 million that could be used quicker and could be used for a general fund or for prizes to players.
So you're essentially saying that you're unjustly rewarded by somebody's lack of turning in a ticket. So my question for you on that particular issue is, how much of that do you keep, and how much of that winning ticket that didn't get claimed goes over to the state of Connecticut?
So
do you get to keep a portion of it? So it's not like the state gets enriched, you also get enriched.
Well, it by statute, and I do have my general counsel here who can clarify for me to make sure I'm saying it correctly, but I believe by statute, we can only use it for certain things. So it has to be for prizes, for example, or the general fund, or for, I think, any other thing that might drive sales, I believe.
So you get to use it for advertising to sell more lottery
No,
tickets.
I don't think we
You
use
said
it
to
for-
drive sales.
Where is Melissa? Melissa, can you? Right.
So, all right, I won't beat it up, but if it goes into the prize pool, why not just let the person cash the ticket? Because it's the prize pool.
Yeah.
I'm confused by it. I think I've asked enough on that one. My other one is right. You too? Okay, good. Sometimes I think it's me, the iLottery, you were talking about the iLottery sales a moment ago. How do people fund the online iLottery account?
How do they fund it? With cards, so it could be
Credit
debit or
cards?
credit. Yep. Yeah, online. And that was a change when sports betting and
Yeah.
online gaming and all of that was done. But they can only use one, so there's a limit there.
So they one at a time?
No, just one for their account. So if they,
So what happens if they reach the limit on one and they remove it from their account? Can they add another one?
I believe that's true.
So really, it's
Possible.
unlimited. So when somebody wins the iLottery, how do you pay them?
They have a wallet, so up to $599, we redeposit it back into their wallet. Anything above that, they need to claim it, and it's separately done. So like,
You mean it comes by check?
yeah,
So their credit card essentially doesn't get paid, right? It's not like you pay the winning with the same way that they gambled. So
Yeah.
somebody could actually win money, but yet their balance on their credit card doesn't get reduced. It's subjecting them to really what usury interest rates for the most part.
yeah. And I will tell you, for me, in the lottery, we're neutral to whether it's a credit card or a debit card. I think, in other jurisdictions where I've been, we've limited it to debit cards for that reason.
Yeah.
Because debit cards are like cash.
I know, but debit cards turn into credit cards. If they have a Visa or MasterCard logo, once you reach, if you're out of money in your bank account, it goes to a credit card. Essentially, it's a,
not a
you
debit
could
card.
use it as a credit card. It has a Visa logo.
Right,
on
but
it.
if you don't have cash in your account, it will not go through.
I don't know how true that is. We'll have to look at that.
Well,
So
I'm pretty sure.
pretty sure.
Yeah, I was in
I get it,
banking
it's
before.
okay.
I was in banking before, so
I understand.
familiar.
My last question is, and then I'll turn it over to the good representative. When you having that iLottery, people are gambling online. Do you use any algorithm or tracking of data to see how they're playing, whether they're winning or losing? And do you have the ability to market to them or increase market to that person to get them to play more or play less, depending on how their winnings are going?
We can track the data. It's not as sophisticated as I think you're probably thinking it is. So we can track the data and pull reports, and then we can send, for example, an email or messages to them. Let's say if we have a promotion about a game that they're playing or something like that. If we want to sort of give them a discount or a free play on a game that they're playing. But it's not for us anyway, because our lottery system doesn't have that sort of AI capability or the capability to.
Does your iLottery system track data though?
Yes,
Does it
yes, there's
collect data?
reports. There's reports that we can pull.
So there's under no circumstance can you take that data, and so if somebody has lost a lot or plays a lot, you can market to them to play more?
Well, if we
Based on
wanted
that data?
to, we could look at that data and we can send communications to them. Yes.
Individually.
Yes,
So you are tracking individual data.
we can. Yes.
Okay.
But it's not something like the scenario you just mentioned is not something we do today.
I mean, in all respect, you just said that you said we can, we do.
Well, we always track data because it's reporting and we always want to understand where the sales coming from, what games are working, what games aren't working. So there's a lot of data tracking that happens as you would for any business, right? You're going to track the data.
I think some of the concern is, along with sports betting and other gambling.
Right.
You're involved.
Yeah.
Is that you have an individual who may be gambling too much or losing a lot, and
Mhm.
you sort of have the ability to market to that specific individual based on their previous habit to get them to gamble more or sort of recoup their winnings. Or if they're winning too much, you keep marketing to them so that hopefully they keep gambling and losing. So I guess I was just starting the conversation about how some of these gambling outfits, you included,
Yeah.
use this data,
Yeah.
some of the data that the good senator is concerned with, to market individually to people who may or may not have a gambling problem. So-
Right.
But you answered the question because you
Yeah.
collect the data.
We collect the data because we always, monitor.
I appreciate your answers. I'll turn it back over to the other members of the committee.
Representative Ackert.
Thank you, Mr. Chair, and thank you for your testimony.
Yeah.
Following back up to 1237 to begin with, the sections 3 through 5. So it sounds like there's an agent may have multiple licenses assigned to them, and you wanted to just have it be like they have a
Yeah.
conglomerate.
Well,
license?
not an agent, Representative Aker. Thank you for the question. It's actually our employees. So
Oh.
our employees may have to have multiple licenses. So first, it used to be just a retail lottery license, traditional lottery license. But once sports wagering online lottery came to be, now there's an additional license that we have to apply. So because a lot of our employees sort of oversee both, right? Because we don't have a ton of them, so you sort of have to be able to do multiple things. They now have to apply for a second license. And so this would just remove some of that extra administrative burden in terms of additional licenses.
Okay, so essentially you would have a license that would cover, you've been
Both,
trained
all of it.
/ and covered under everything. Yeah, because I know that DCP did something regarding the home remodelers and new home builders, because new home builders and remodelers kind
Very
of
similar.
do this. So they said, hey, let's just do one registration. It's
Right.
not even it's just a
Yes.
registration.
And that's what we were looking for. And we worked with DCP on that to make sure they were okay with that.
And then a follow-up on the ticket redemption. I'm one of those ones that I don't buy lottery tickets. I did go out and buy the Yukon one because I felt bad because I voted against one of their bills. I figured I'd go.
Well, we appreciate
It
that.
doesn't happen often. I vote against a Yukon bill, but I did, and they weren't happy with me. And so I said, I'll give them some love. I'll buy one of them $5 Yukon
Yeah.
tickets. And
Yes.
I lost, of course. And so, but the ones I have won, I might sit around because I don't, I get them up on
Yeah.
a gift raffle,
Yeah.
whatever they
Yeah.
do, right? And so I did go in and missed out. and so that money goes back into the fund. What amount of that goes back on average into a yearly fund, or how often do you use that? How often is it recorded?
Yeah, I'll have to get back to you on the exact number. I
Yep.
can tell you that annually it's about $12 million.
That's what I was looking for, yeah. So about $12 million
Yeah.
that aren't claimed.
Aren't claimed.
And what's the overall pool that you do pay out with? So it's 12 million that might go back in, percentage wise, what percentage is that in the overall
That goes
payout?
back to prizes. Is that what you're asking? Like of the 12 million?
No. The unclaimed amount is about 12 million. What is your overall annual winning payout?
Yeah, overall payout somewhere around 67%, I believe, last time we looked at it. So, and I can confirm that number for you.
I'm just trying to see what the return amount is compared to the payout amount. So in other words, what the ones that aren't being paid out, is it a 2%, 5%, 8% of it that goes back into the fund?
Oh, of the tickets that, yeah, it's going to depend on the game and, the margins that we have on those. So, the example I'll give you, like typically a Powerball or a Mega Millions game, that's about a 50% margin we have on that typically. So that's about 50% of that dollar that someone would spend, we get, and then we take out, whatever,
Sure.
expenses and things like that.
Yeah, I'm looking for probably a simpler number, like
Yeah.
what does Connecticut lottery payout gross to winners in a year?
As
Dollar
a
amount.
full amount or percentage?
If I could clarify,
Yeah.
you indicated that the people who collect after 6 months is a very small percentage.
Yes.
We've put that total dollar amount at about $12 million, I think the
Right.
good representatives established.
Thank you.
So in terms, the small amount,
Yeah.
and you determined it to be about $12 million, well, what is that big amount? $12 million
Is unclaimed prizes. And you
unclaimed
wanna
is
know
as a
how much is
percentage of
total
the
prizes.
total
Yeah.
prize payout.
Yeah. The total prizes, and I had this last time when we presented, but I believe it's somewhere around 1.2 billion. So I'll get that number to you.
That's what, what the overall that,
Yeah,
okay,
yeah.
that's all I was looking for, yeah, not a.
Yeah,
just
we give
like-
out about
So
a-
it's a small
over
amount
a
that
billion.
does
Yeah.
not get claimed, is
Yeah,
essentially what I'm looking for.
Yes, and
Yeah.
also to clarify too, typically it's $1. A lot of times it's someone might have won $1 because they got one of the balls or two of the balls, and so they just don't deem it worth their time.
Right. And then do you know, like, it goes to the machine, you put in the card per se, let's call it one of the, scratchy tickets, right?
Yeah.
You put it in and it's beyond 6 months. Do you know that's the number that that wasn't claimed, right?
Yes.
It's registered that way, that the
Yeah.
machine tells you.
Yeah, it'll tell you that it was expired.
So I guess, guys, another question. So in the next 6 months, right, do you know what percentage would have tried to have? Is it half of that 12 million or?
That number I don't know, but we could see if we
I'd be
could find
curious.
that out.
Yeah, curious. I don't ask you to, but since it's in a machine and someone's registering it, does somebody go, it's 7 months like me probably, or 8 months like me?
Yeah.
And
You
just,
want to know how many are being tried to redeem
tried to be,
after
is it of
expiration.
that 12 million, is it, 500,000 or is it, half of that?
Yeah, we
Okay.
can get that number.
Thank you. Appreciate it. Thank you for your testimony again. I appreciate
Yeah.
the information. And thank you, Mr. Chair.
Thank you very much. And since you confessed on buying the Yukon lottery ticket, I'm going to confess I have several unclaimed scratch-off tickets, but they're well past a year, so you can keep your $2. Thank you. Representative Vitigliano.
I just wanted to follow up on what you said before. You said 2 billion, you pay out 2 billion? Or
No,
that's
not
the
2
total
billion.
handle?
No. So our sales are about 1.4 billion.
Right,
we
he
pay
was
out-
asking you what you were paying.
Right, and prizes were around $1 billion. I actually have the number.
But you
somewhere.
said that your margin was 50%. Oh, you're just talking
No,
about
just
Powerball?
on that Powerball ticket.
So it's 1.4 billion in Powerball or total for the lottery?
So total for the lottery, total sales with sports is 1.7 billion, right?
With
And
sports?
With sports.
So you're saying your margin on 1.7 billion is 50%?
So prizes.
That's
no,
what- I'm
no.
just going by what
No,
you
no,
said a minute ago.
No. Let me clarify
Well,
because I
she's
think
shaking her head and
it
it's
can
not-
get a little bit confusing. I was trying to explain in one game. So like Powerball, the margin on that is 50%. We pay about 50%. On some of our scratch tickets, it can go up into 70% or whatever. So the average payout for us is around 67%. Does that make sense? Across all games, we pay out about 67% in prizes. Okay, so if it's 1.7 billion in sales, the prizes were about 1.14 billion last year. Does that make sense?
So it's about a 800 billion, no, what, 600 billion, 600 million revenue that you disperse, either you keep or
Well,
turn
after
over to the
expenses
state.
and all of that, because we have commission that we pay to retailers
Yeah.
and all of that, it's about, last year it was 387 million that we gave to the state.
So about half of the remaining, the half of your,
Yeah, a little bit more. Yeah.
Okay.
About half. Yeah.
thank you.
Yep.
That makes a little bit.
Yeah, yeah, sorry.
It's okay.
It's kind of, can get complicated.
Thank you. Representative Paolillo, did you have a question? Thank you.
Thank you, Mr. Chair. Good afternoon.
Yes,
Good
good
to see you,
afternoon.
Frank. I'll start, let's see, on 1237
Yeah.
regarding the hardship with operators and so forth.
Yeah.
To kind of go along with some of the same questions that have been asked around unclaimed tickets.
Yeah.
What would you say is the debt that is out there from operators overall that you would be looking to address with this legislation?
You're talking about the delinquent sales
The
agents?
delinquent sales
Yeah,
tickets
when,
or any other debt as a result of doing business with the
Yeah.
lottery that is on the books.
right now, based on what we have recently, it's about almost 200,000 in delinquent payments that we haven't been able to get. And that includes interest and penalties. Without interest and penalty, I believe it was about $147,000.
So 200,000 across the entire spectrum.
Yep.
With all operators.
Yes.
So how many are we actually talking about? Like how many
Uh,
cases are we
I have,
exactly talking about that would fall underneath that category? How many operator relationships do we have
I didn't
that
have
they're
an
in debt to?
exact number, but I feel like, I'll have to get back to you, but I think last time I looked, it might be like 10 or something like that, somewhere in that number.
Okay. And on these folks,
Yeah.
these operators that have debt, are there restrictions in the relationship as they're in arrears? Or
Yeah,
in
so
arrearage?
once they're former retailers, so once they don't pay, they no longer are retailers for us.
Okay, so these folks are not in business anymore, don't have a
Not
really
selling
good-
lottery, no.
Okay,
So this was just to give us an ability to just recoup that 200,000 or some amount close to that. So that way their debt could be paid and then they can move on and we can go ahead and recoup those dollars.
so they're not selling lottery. Are they involved in any other business with the lottery? Do they have the ability to sell any other products or?
No, it would,
Okay.
no, their contract with the lottery would be terminated.
Okay, all right. And underneath that, what would you consider criteria for a hardship? I mean, do we pursue civil? I mean, are these cases, is there litigation? I mean, payment arrangement plans?
Yeah, I think we have done payment plans with them. But I'd have to get back to you to tell you exactly what a hardship has been characterized in the past. I would
Okay.
assume it's financial distress that they're having
Okay.
one way or another.
Okay. And then going back to 584 or 5084,
Mhm.
in terms of the redemption period, what you mentioned in testimony, and thank you for actually getting this testimony to us yesterday.
Yeah.
Always.
Oh, you're welcome.
Always appreciated. What are industry best practices?
Yeah, so what you'll see is and I don't have the exact number, but it's sort of split in terms of the 180 and the 1 year across the country for the lotteries. But it's considered a best practice to shorten that period because it frees up funds.
Yeah, I tend to agree with some of the issues that have been raised. We're talking about, you're mentioning on $380 million that's coming back over to the state on an annual basis, or the last
387,
fiscal
yeah,
year
387,
is what's come out, 378,
387.
which has been a little bit lower than the prior 2 or 3 fiscal years. But I'll get into that in a second. But it's a pretty small percentage we're talking about, which is rightfully, if someone is playing this game or if someone is entitled, I would think that 6 months or a year, they should still be entitled to that. And it's going to be a liability on your books, regardless if you're a 3-month or 6-month or 9-month or a year. I just don't understand the reasoning, and it's not going to be as a percentage of what you're turning over to the state, really anything significant in terms of what your overall contribution to the general fund is. So I do want to work through this a little bit more, but looking at the advocate or looking at the consumer and advocating for the consumer and looking at the long-term relationships that you're attempting to have with your consumer base, I think in good faith, the higher time period would certainly be something that we would want to reward players and continue to build that relationship over some time. Going back to the operators for a second, you talked about cause and good cause in 1235, and I appreciate your testimony because it was, kind of, you parsed out some of the differences and some of the different regulations, some of the changes that have been made, but you heard the DCP commissioner talk about certain instances with operators, whether it be illegal slot machines, for instance,
Right.
At a place right there. So there wasn't a lot of mention in your testimony at what was the catalyst behind this, but I wanted you, having those direct relationships with the operators to talk about some of the illegal activities that may be happening or are happening, obviously, in DCP is there. Can you talk about that?
Yeah, so there are definitely retailers, and when we talk about retail sales agents, these are convenience stores, smoke shops. There's a variety of businesses across the state that may be having illegal gambling machines. We haven't seen. I'll be interested to see sort of what the numbers are for DCP. I think we're only aware of a few, but again, that is an issue, right? It's not necessarily within our jurisdiction to do that. So that's the Department of Consumer Protections to do that. I think that my understanding, and they can clarify, they can go after those licenses now. The bill is not necessary for them to remove those licenses currently. So, and the thing I call out specifically is that, it would be one thing if the bill was specifically only mentioning retailers and retail sales agents, but it's all the licensees that are part of this. And it's very broad. And, there's just some basic elements that we want to make sure to maintain in the due process piece, like having a hearing before your license is removed.
Well, I also think that the commissioner mentioned that there would still be due process, there still would be a hearing, and I think some of that, there may be a little bit of a different interpretation, but he did mention before that process, that due process would still be laid out. But you do have an investigative arm also inside.
Yes,
of the
we have
lottery.
investigators as well.
So you have, so
Yes.
is it my understanding that you're not investigating this, or you're not aware of
We
some of these
have
smoke
no
shops, or?
jurisdiction on illegal gambling machines. So no, we do, what we do is if our sales reps are out in the field and they're calling on a retailer and they see this, they report that. And then we do have investigations, but again, we don't control the licenses. What we can do is just terminate their contract. But again, they have to go through the due process piece of, are they guilty? Is their license removed? That kind of stuff before we terminate a contract. We want to make sure that they've had their due process also.
So would agree with you with due process and to be able to go through, to give folks a chance to know what they're doing or not doing and to defend themselves. But how many investigations then do you have open right now that kind of fit under what DCP has laid out, what the commissioner has laid out today? Because if you're getting those referrals, you have sales agents out there, you have folks out there in the field, I would think certainly your security arm would be aware of this. We've had testimony over the years from your security folks when there were bad actors for whatever the reason. And generally, as I'm remembering it now, that started at the lottery level, and then obviously in coordination with DCP, those investigations continue on. So,
Yes. Yeah, I'm probably confused. I'm not sure of the question, but what we do.
well, do you have active investigations?
Yes, we do.
Yes.
We do
so
on
that's-
retailers, but again, it's not about illegal gambling machines, it's things that we have jurisdiction over. So for example, if we believe a retailer might be selling tickets to someone underage, we'll do that. You know, we have, in conjunction with DCP, there are sting operations where we try to see if a retailer will try to buy a ticket from a player. Those type of investigations and things we continue to do, and we partner with DCP to do those. But we aren't, we don't have the jurisdiction to go and do investigations about illegal gambling machines. That's not really our place.
Yeah, it was just a general question.
Yeah,
of,
yeah,
just
yeah,
General
yeah.
investigations overall
Yeah,
for any
yeah.
oversight, which then would fit underneath a revocation of a license or a non-renewal of a license.
Yeah, I think I
so-
want to be
So that would be all encompassing.
right, right, and they
Um,
can do that today.
Okay.
Right,
That's-
without the bill. And I want to clarify a little bit on the hearing piece. The difference is that the hearing currently is required before its revocation. A hearing now in the bill comes after you revoke the license. So an employee will be terminated if their license is revoked, and that's the difference.
Mr. Chair, thank you for the opportunity. I may have one or two follow-up questions, but I appreciate the opportunity. Thank you, Frank.
Thank you.
Thank
I
you.
think Representative Lamar, then I have a question, and then we'll go see if anyone else has a question.
Thank you for your testimony, Frank. We
Yes.
really appreciate it. You raised some interesting parts of points of conversation in
Mm-hmm.
each of the bills that are respective to your agency's requests, but also
Yes.
DCP's requests. I think there's some work that we'll need to do to make sure that the interests of DCP are protected, consumers are protected.
Yes.
I think that you raise up some due process concerns that I think are relevant and worthy of consideration of how we best, most appropriately structure that process. I think we recognize what the concerns are. I think we recognize perhaps there's a due process concern that we need to rectify.
Great.
You make some solid points on behalf of your bills. I think there's tension in this committee, I think generally in the legislature, with a lottery, because it's an interesting partnership, like
Yes.
a quasi-public agency that's
Yeah.
relying upon a deliverance of revenue back to the state
Yeah.
to support our general fund needs, whether it be in education or municipal aid or any other issue that we determine to be a priority.
Right.
And you're tasked generally to come up with more revenue,
Yes.
additional revenue,
Yes.
right?
yes,
So when you
yes,
say
right.
something like, well, it's industry standard or best practice,
Yeah.
you're thinking in terms of what your actual job responsibility
Right.
is, which is normal and natural and perfectly reasonable. But for us, who are tasked with different priorities,
Mhm.
it can be somewhat jarring, right?
Yeah.
To hear that a best practice is to deny access to winnings
Yeah,
after
yeah.
6 months, right? Like that. Like, gosh, that might be
Yeah,
an
yeah.
industry best practice, but it sure doesn't sound like a best practice on behalf of Connecticut residents,
Mm.
right? So there's that natural tension that's going to emerge
Yep, yep.
on a number of issues. And I
Yeah.
think those conflicts are necessarily a component of what your testimony is versus what DCP's testimony is versus what an individual legislator
Right, right.
may introduce. And so
Yes.
I think I look forward to working with
Yeah.
you over these next few weeks and months to kind
Yeah.
of smooth those tensions and
Yeah.
determine what a good policy directive is for the state.
Right.
But it's not lost on me why your best practice or industry standard could differ from what we
Right,
think a
right,
best practice
right,
or
right.
industry standard is. So I did,
Yes.
so when you say
No, I
tension,
appreciate
it isn't directly about
No, I
you,
appreciate
or it's the natural tension that exists internal to an industry,
Yeah.
regulated as it is,
Yeah.
but also potentially problematic for our constituents.
For sure, and I appreciate that, and I completely understand. I think, as you said, my goal is just to sort of explain why it is the way it is currently, and that there are efficiencies, right? Part of what we're tasked with, and why we are an independent corporation, is to run it like a business,
Right.
and run it as entrepreneurially as we can. That means having your cash flow, having things flow as well as possible, but completely understand what you're saying. And we want to do whatever we can that will support you in your efforts.
And I appreciate that. And there's one aspect of this, and you're going to hear at a later public hearing as well, that concerns us a little bit more now than maybe it did a couple years ago when it was first allowed, which was the use of credit cards to fund
Yes.
player accounts. You indicated that there are states that have differing approaches to this
Yes.
mechanism.
Yes.
In Connecticut, you're allowed to open up an iLottery account with a credit card that's issued to either an individual or joint ownership, right? Like, so if
Right.
my wife and I have a credit card that we share,
Right.
I can open up a credit card account and encumber or sort of populate the wallet with funds from that credit card,
Yes.
but it necessarily encumbers my wife's credit
Right.
in addition to mine,
Mm-hmm.
and the liability to pay off any incurred debts fall to another individual
Right.
who may not be aware of and or a interested party in like my gambling
Right.
habits, right?
Yes.
And so I think like again, not to jump over Representative
yeah.
Tigliano
Yeah.
or like as moving forward,
Yeah.
that's going to be a point of exploration for this committee is like, what are the
Yep.
real regulations that we should put in place? How should we handle that? And like, I'm going to rely on your guidance on how
Yeah.
other states handle it because
And I
it does
understand.
seem like a potential.
Yeah, completely
conflict.
understand that. As you know, I was in DC and I was executive director there. And DC's law was you could do credit or debit, even at retail. And we purposely chose to only allow debit on our vending machines. We had the ability, because one of the things that we do want to keep in mind is that people don't carry cash anymore, right? So you know that, right? If you got anyone that's, 30 or whatever, no one carries cash. So we have to sort of make sure we're evolving with that time. But I think within the right balance and the right constraints, it makes sense. But again, the credit card piece was before I got here in terms of the legislation and how that got there. I was very comfortable with debit cards because it does end at some point. And Representative Tigliano, I can get you the information that will confirm for you that you can't go above your limits necessarily unless sometimes some people may have special accounts that are connected, right? So if you have a savings account and things like that, then it can go into that. But the reason debit cards tend to be sort of the standard is because it is as close to cash as you can get, but with the convenience of not having to carry it.
And you also indicated that you've got the ability to track sort of data of who's betting, there's demographic data that you may have
Yes.
in your possession, like whether or not like age,
Yeah. Yes.
look like place of residence,
Yes. Yes.
what their overall credit limit is.
Well, that we don't have.
You don't have an actual
No, I have
overall
credit limit.
Okay.
No. So whenever someone registers for iLottery, they have to go through this process. We identify and make sure they are who they are and that they're 18 or above. And so through that process, we get a lot of their information, but we don't get their credit information. It's just like you would at a normal retailer. Either it says yes or no, right? It's either accepted or declined.
There's aspects of like the evolution of gaming in the state was we sort of understood what problematic gambling behaviors were, what the early indicators were. Largely that information was developed with the gaming partners
Yes.
in our tribal nations and a little bit with CT Lottery. But now with the evolution of data collection and people using online services, there's more data at our fingertips.
Yes.
And so in so much as there are concerns about how that data is used, manipulated, targeted, it can also give us a window into problematic behaviors
Yes.
at an earlier stage.
Yes.
And I'm wondering, and that there's no bill before us here today,
No.
but, and you saw my questioning a couple of
Yes.
weeks ago.
Yes.
We're recognizing increased problematic behavior,
Yeah.
particularly amongst young men, starting at very early ages who are engaging in very risky behavior, oftentimes with a credit card that is either held by themselves or
someone
in
who's-
conjunction with a parent.
Mhm.
And they're getting into really bad situations that are complicating their entire long-term futures.
Right.
And so I'm hoping
Mhm.
we can figure out ways to target our anti-gaming behaviors and marketing, and it's not being used instead to encourage greater gambling
More
behavior,
yeah.
right? Like, so
Mhm. Yep.
I'm not sure what that legislation is going to look like as we
Okay.
move forward, but in that
Yeah.
this conversation is happening in this committee now,
Yeah.
and this is an interest that I think the focus is going to
Yes.
be a little bit more on correcting for deeply problematic gaming
Okay.
behavior that we're seeing evolve with time. So that's just
Understood.
a broader construct of a conversation that's going to
Yeah.
happen between you and I and
Yes.
generally this committee over the
Yeah.
next few weeks and months, but over the next couple of years.
Great. And responsible gaming for us is a core value, and it's very important. It's very important to me personally, and I look forward to those discussions.
Yeah, Representative Tigliano.
Just a quick follow-up on the good representative's questions.
Yes.
When somebody uses their credit card to purchase lottery, the iLottery, do they use it as a cash advance or as a purchase?
That's a good question. So I'll have to confirm how it's coming through for people using our iLottery. I will tell you my experience in the past is it depends on how it's coded when it goes through for the transaction. And when I say that is, like when you do a transaction, it can be coded as grocery, it can be coded as pharmacy. And if what has happened in the past, if it's coded as gaming And it really depends on the vendor and what their category is. If it's coded as gaming, a lot of the credit card companies do see it as a cash advance.
Do you, on your line item and your financials, is there a processing fee that you pay as a merchant to a credit card
I
company?
believe that's through our vendor and they're the merchant, but I can confirm that.
Because a cash advance would go solely to the player, the 3% that they would actually pay to play
Right.
the use the ladder.
Yes.
Where a credit card transaction would be a little bit from you as a merchant.
Right.
And whatever.
That's correct. That's
Okay.
right. That's right. That was also another reason why we, at retail in DC, I did only debit because I didn't want them to get the fee.
Do you have a limit on the amount somebody could gamble or bet in a day?
Do we have a limit?
Your people, they're shaking their heads behind you, so maybe they,
Yes.
$250?
Okay.
A purchase, so you actually pay a credit card fee for the purchase?
IGT, our vendor, is our merchant. So they're the merchant of record for us and they would pay the fee.
No, but, that just means they're giving you less
Yeah,
money.
yeah, eventually,
Right.
yes, but yes.
So you're paying it.
Yeah, yes.
Okay, so it's a purchase.
processing
It's
fee.
$250 a day. Okay, very good. Thank you.
Okay, are there any other questions? I just have one, you have another one? Representative Palo for the second time.
Thank you. I appreciate it. Sorry about that. Frank, if I could just go back
Yes.
to 1237.
Yes.
This is headed on the second page. Can you give an example of an add-on feature?
Yes.
So you're looking at having language reinstated, but it really doesn't kind of give an example.
Yes.
Or
So,
can you leave that out?
yes, I can do that. Thank you for the question. So on our Play 3, Play 4 game, we have an add-on feature called Wild Ball. And Lauren, keep me honest how this plays, but my understanding is if you pay $1, then one of your numbers or the can change to whatever the Wild Ball number is. So typically, let's say you're playing Play 3, you pick 3 numbers, right? And so if you play Wild Ball, then one of those numbers can change. Is that correct? You can swap it in. So like, let's say you played 1, 2, 3, the number that came out was 1, 2, 5, and the Wild Ball was 5, then you would have won. And that's how that works.
So basically, you're just adding to your odds by continuing to have an enhanced chance
Yeah.
of winning, but you're paying additional dollars.
Yeah, it's like
for
a
that
fun
enhancement.
feature for players that they can sort of add and see if they get lucky enough to match the ball.
And how is the advertising and the disclosure
Yeah.
around that piece?
Well, right now we're not actually advertising
but
Wild Ball.
Under the proposal to kind of reinstate and
Yeah.
have that ability to do this,
Yeah.
what would be the disclosures and how would that look like so that the consumer knows that there is an added feature, but at an added cost?
Typically, we'll say, for an additional $1, you can add Wild Ball to any of your plays, and if the Wild Ball matches, then it can replace the number, and if the Wild Ball matches, then you win.
Mhm. And then also under the bill, in terms of the one license that you're working in accordance with DCP for your employees,
Yeah.
Does that result in less training or
No.
Across the board? So it's more of an administrative
Yeah,
fix?
it's just administrative paperwork and the need to, because they expire every year, and so you're doing multiple ones.
And then finally, just a comment, and I appreciate your leadership and as the DCP commissioner testified a couple hours ago earlier, in terms of the trust that is forming between your agency and yourself with your leadership there, considering what has transpired in the past.
Yes.
Obviously, to acknowledge that there is the reforming and rebuilding of a relationship, you have to admit as to what transpired in the past or what didn't transpire in the past. So I wanted to commend you on that and on the rebuild of that relationship.
Thank you.
Because ultimately, as many of the questions centered around today, besides the policy piece, we're also representing your clients, your constituents.
Yes.
They're our constituents also. And, the more you build the transparency piece, obviously, the consumers that we all represent, there's more choice. And, just looking at, you mentioned before, the increase in your revenues with sports gaming, that came out of a committee in the legislature to give more choice, to be able to have the lottery offer sports gaming, to have more competition in the marketplace to have more offerings to consumers. But that also stretches across your other business as well. I mean, you need to be transparent with a regulator and across the board.
Yes.
So it's good to see that that is happening now because some of the things of the past we need to learn from and to build on. So thank you for the opportunity to ask these questions and appreciate the new leadership and fresh leadership to lead to better relationships across. And thank you, Mr. Chair, for the opportunity today.
Great. Thank you. And just one last question. It's not on a bill that's here, but a proposed bill. You'd mentioned, right, you want to give more leeway to collect from retailers because some retailers are struggling. We did have a proposed bill because there are many small businesses and retailers that are struggling to increase the commission from 5% to 6.5%.
Yeah.
I guess, is there a common percentage across states? You've worked in other lotteries.
Yeah.
And what do they pay? And could you just give some feedback on that?
No, thank you for the question. And it's going to vary, and I'm sort of shy to say industry best practice or standard, but typically, so just to be clear, it's 5% on the sale of a game, and then we also give them 1% on the cashing and validation of tickets. So they get, you know, depending on what volume they have, it's sort of a mixture, a percentage of the two. And then it just depends. You can see from jurisdictions, there's a lot that are at the 5% and typically they'll do a cashing, like a sales one and a cashing one on top of that. And it varies by jurisdiction. I'll tell you in DC, it was 5 and 1. It's very similar. But North Carolina, I believe theirs is 7 across the board. So it's just going to vary depending on the state and the jurisdiction.
Great. Thank you very much. I don't see any further questions. We've kept you here, I guess, long enough. So thank you very much.
Thank you.
I'm sure we'll see you soon.
Yeah, thank you.
Okay, next.
Next, we have Brian Perkins.
So good afternoon, co-chairs, Rep. Lamar and Senator Maroney, ranking members and distinguished members. First, I want to say happy Valentine's Day to you guys as well. I think I can speak for everyone in this room when I say there's nowhere we'd rather be today than spending Valentine's Day with the
Couldn't even say it with a straight face.
So. What was that, sir?
Couldn't even say it with a straight face.
I tried. I really tried, but you know, miss him. I do appreciate you, gentlemen, though. Thank you. My name is Brian Perkins, and I'm here today in support of HB 6478. 4 years ago, on January 30th, 2021, I ended my active service in the United States Marine Corps after 4 years of service to return to Connecticut, my home state. The state in which I lived my entire life, with the exception of serving on active duty. Although reenlistment was tempting to me, I felt I was ready to return to Connecticut and live out the American dream. Unfortunately, the unexpected and unforeseeable pandemic that was COVID threw off what was otherwise supposed to be the start of my life back in the general population. Housing prices in Connecticut soared, with the average listing price in Connecticut rising by 33.6% between January 2020 and January 2021, and average rental rates in Connecticut rising by 22.7% in the same time period. This surge in pricing in this context, as frustrated as it made me, made sense. It was supply and demand. We had a large influx of people coming in from New York, and the supply of housing was scarce and was therefore inflated. I can live with that. I can understand that. Where my concern lies with the current market in Connecticut is the fact that in just the last year alone, from February 2024 to February 2025, the average price of rent in Connecticut rose by 11%. Now, I'm sure it could be argued that it's because we're in a housing crisis, or maybe we're still feeling the effects of the pandemic. But I can't help but feel it has something to do with the fact that 14% of homes in Connecticut were purchased by investors in 2021. And listen, I'm a businessman. I know how good it feels to get a return on your investment, right? But what's currently being done to manipulate the housing market in Connecticut by means of landlords and property managers is destructive, demoralizing, and downright cruel. People my age and younger are forced into the rental game, where residents do not own the property we have and are at the mercy of landlords or property managers, where rental rates are so high that we couldn't save to purchase a home even if we want to,
as it is in the best interest of the landlords to keep their tenants trapped in the cycle of paying inflated rents instead of allowing them to save on their own. The reason for this shift isn't because people aren't working hard enough or they drank too much Starbucks. The reason is simple. It's greed. Now, I can understand airline using algorithmic pricing to raise the price of a plane ticket because I visited their site looking at tickets before. But I can't wrap my head around, what I can't wrap my head around is a similar tactic being used to extort the middle class, to artificially inflate one of the largest and most necessary expenses, to make it so that there's no chance of ever owning and lock them into a perpetual cycle of renting. I'll end here. In 2024, Consumer Affairs rated Connecticut as the worst state in the United States for renters. I gotta tell you, with the current trends we're seeing, we might be on track to win that race to the bottom for a second year. Rental rates should be determined by market value, not by algorithmic pricing that's trained on data from collusion that is in the interest of maximizing profits while minimizing tenants' rights. I urge you all to put yourself in the shoes of your younger selves to think about what it would be like to survive in this predatory and exorbitant market. If you could do that, then I feel there should be no question to support this bill. Thank you for your time.
Thank you very much, Representative Vitigliano.
Hi, good afternoon. How are you?
Good, how are you, sir?
Just a couple of quick questions.
Absolutely.
Is this for long-term rentals or does this apply to short-term rentals or, like Airbnb or anything like that?
I'm glad you brought it up. Short-term rentals is a big problem here in Connecticut. It's been an issue that I've been very focused on myself, mostly because it really hurts the housing market. We have so many short-term rentals here in Connecticut that are taking up housing that can be used for long-term. In terms of the bill itself, what it's focused on, as it's written, is the effects of rent for the long term, as in the sort of like, how do I want to explain this?
People who sign a lease is what you're saying.
Correct. Yes.
So it's
People
not
who
for
are
a
long-term.
short term, you're going for a weekend, like our VBRO can't use sort of like your airline ticket. They
Right.
They could still use whatever they need.
Yeah, I mean, at the end of the day, when you're looking at something like a short-term rental versus a long-term rental, right? A short-term rental is usually going to be much more expensive anyway.
Right.
It's not going to be the same rate as a long-term rental.
Does the bill contemplate at all the size of the apartment? Could one landlord who maybe owns a 3-family and rents out 2 or 3 of the apartments, are they able to use a different method than, say, does this contemplate whether it's, a 50 apartment complex or 100, or whether or not it's one of those massive landlords? Do you separate sort of somebody's personal investment that maybe they have 2 or 3 units from a big corporation that maybe has 50 to 100 units?
I see what you're saying. Basically, the data that's used for these algorithms is colluded by a large number of the landlords and property managers. What that statistic is between the individual landlords who are just have a duplex or a 3-family versus the ones who have multiple properties or multiple like dwellings, that's unclear to me.
Would
in that
you
regard.
think there's any value in separating, sort of treating one type of landlord differently than another type of landlord?
I think the issue doesn't lie with if the property manager or landlord owns either one building or 50 buildings. The problem lies in the fact that the algorithm is used to artificially inflate the price or change the price of the rental, not based on property value, not based on mill rate changes, not based on that kind of thing, land value, et cetera.
Are there third-party apps, because I'm not aware, that allow sort of a small landlord who maybe owns 1 or 2 houses somewhere to use this algorithmic change that you're referring to? Or is it really just sort of the bigger landlords, the big apartment complexes?
That I'm not sure of. But in regards to, like I said, the main scope of the issue is the algorithm itself being used. Because if you think about it, right, even if the big landlords are using it and they're making their rates higher,
right,
the smaller landlords are also going to see that change and know they can now charge more.
I want you to know that I recognize that there's a problem with rents. I was just trying to explore. In my mind, I sort of treat the mom and pop landlord or somebody who has a small investment different than these massive.
No, I agree
complexes.
completely.
And I didn't know if they're all using the same stuff, so I figured I'd ask you. You probably know more than I do.
Well, I'll be honest with you. I'm not in the club. I'm not a landlord, so I don't get that kind of privilege. But
I
I
was
will.
the landlord, and I would just see what the people on the street were charging,
Uh-huh.
and that's was my basis point. It was expenses plus, hey, the guy down the street advertised his, and that was my algorithm at
Right.
the time.
So now imagine if the people down the street from you were using an artificial algorithm based on data from a swath of different landlords, right, that are all raising their prices across the state. And then you look down the street, see he's raised his price, you say, I can raise my price too.
Right? Listen, in theory, in business, there's, you know, cost plus, and then there's what the market will bear. Sometimes the market will bear more than, you know, in excess of what my cost plus is. So I'm not saying I disagree with the bill or anything. I was having a conversation.
No,
and
of course, and
appreciate it very
I
much.
appreciate the
And
conversation.
good luck to you, and thank you for your service.
Oh, thank you, sir.
Thank you. I will have a few comments and questions with Representative Acker.
Thank you, and thank you for being here again, and also thank you for your service.
Thank you, sir.
So I struggle with this a little bit because I'm thinking I'm a business investor in whatever business it may be, right? And I want to get in the market of, I don't know what it is, you know, some type of a market. And I'm looking to see how I can make money at it, right? And so what we're saying here is that for this business, that someone could say, hey, listen, I want to buy a 4-family house in Manchester, Connecticut. Here's the price. Here's what the utility costs are. I need help understanding if I can make money, and I go and use this service to come up with what I should be charging for rent to make money on that. So we're trying not to allow that.
So the service isn't for the prospective landlord. It's not for the people who want to get into the business of being a property manager or being a landlord itself. The software itself is used primarily within the community of landlords and property managers already to see to basically feed data into this algorithm to see where they can maximize their profits from their tenants. It's not like a cost risk analysis, right? So, like, program is not used for that kind of thing. It's more used for basically the kind of like a conglomerate system of different landlords and property managers to be able to inflate prices based on arbitrary metrics as opposed to being based on land value or based on anything like mill rates, et cetera, expenses.
Yeah. So, but couldn't somebody, I guess what I'm trying, I think, you know, because sometimes a person that's not in the business or maybe just getting into the business that wants to know if they're, you know, they can make money at this, or if they're maybe in the wrong business, they can use that. So this looks to be like a tool for somebody to invest.
I wouldn't, in that regard, Representative, when you look at it in that regard, there's kind of a fallacy there because what you're looking at is data from an already inflated, already adjusted pool, right? So, you know, if I was going to business, right, I wouldn't be looking, if I was going to build a computer store, let's say, I wouldn't look at Apple and, you know, see what's working for them and be like, I can make an iPhone, right? That's
I probably would look at Apple.
Well,
no, I'm kidding. Go ahead, continue on. But
Well,
continue on, yeah.
What I mean by that is Apple's a good target, right? Like, I want to be an Apple, but in the grand scheme of actually getting to that level, is that the best opportunity I have? Is that the best option I have to look at that avenue? Or is it better for me to look at where my expenses are now, where I can build from with what I have and then get into that industry? So it's more so for the people already in the industry, not so much for the people who want to get into the industry. And that's where the problem lies.
Okay. Again, thank you. This is nothing completely new to me, so I appreciate your time.
Of course, thank you so much. I appreciate your questions.
Representative Lamar.
Thank you, Ryan, for your testimony and for your service.
Thank you, sir.
I wanted to highlight there are a couple of bills similar to this in housing and judiciary committee, so it's clearly a topic that has gained a lot of attention. Bills are introduced by legislators in a variety of different committees to sort of look at this.
Right.
And I think there was testimony submitted in opposition to this from someone I generally think has got a good analysis of the market and the potential implications. I looked at the home builders.
I saw the opposition.
Right,
I read that.
because it's a reasonable party that we usually can kind of have a understanding of broader implications in a marketplace other than the specific understanding of that bill, right? So I was interested to see their opposition. One component of it that I don't think this takes into account is because large apartment managers it's actually easier for them to engage, to use this software, to engage in the AI, to use the algorithms, end up purchasing the software and utilizing its broad applicability over many rental markets, not specific to necessarily New Haven, Hartford, or Bridgeport. When 40, 50, 70, 200 apartment managers in the same small state buy into that software, they're all making individual determination that this is how I can determine what the best price for my unit is. So what happens though is when you control, because what you ultimately do is you end up controlling tens of thousands of units are in the same pricing algorithm. So that individual thinks they're making a smart individual choice, but really what they're doing is entering into a market manipulation. Right? Like and I think that's the challenge of this. The individual business person is engaged in a smart business choice to get a few $100 per unit. And they think that, like, what's wrong with that? I'm looking at the next door neighbor, they're doing the same thing. But the reality is the magnitude of it is so large and the scale is so impactful on the underlying marketplace that it becomes a marketplace manipulation.
It creates a slippery slope, really.
And right. And so I think that's what your bill gets at. It's part of the bigger AI conversation. Like, there's a lot of conversations that are happening in this committee and more broadly across the state because we recognize a tool that we all think is good for increasing business productivity or health outcome. It can be used for not even nefarious purposes, unintended consequences of a market manipulation. And I think that's inherent with the bill that you have before us. And I think the fundamental question that we have to try to figure out is how do we prevent that market manipulation? And that's why I think this bill is intriguing and engaging a lot of us on both sides of the aisle. Like, there might be something here we need to figure out. So I appreciate you bringing this forward and having this conversation.
My pleasure.
Thank you very much. And just, to follow on that, we had a bill last year, Senate Bill 2, it's coming back this year, and housing is a consequential decision. And we look at, looking at the algorithms that are used for the provision or denial or terms of conditions. And price right or price gouging would be a terms or conditions. Oregon AG's office gave an opinion that uniform trade practices, the Uniform Trade Practices Act applies, but also price gouging, AI statutes and price gouging. And so one of the issues is how do we know if it's price gouging if there's not transparency into how it's making the decision? And then we have other price gouging bills on the unconscionably excessive, right, if we're making that increase.
That's a large problem with this software in particular, is that it uses private data that we don't have access to. We don't know where it's pulling these numbers from. We don't know how it's getting these results, right? With an AI, like for like an AI model, for example, there's different models that are open source. You could see how they're coming up with their calculations, how they're coming up with their tokens, right? As it's using AI, technically tokens. But in this regard, we don't have any access to it. It's a closed system. We don't know how they're being controlled, essentially, these values.
Right. The problem is the black box nature, right? We don't know how the decision is being made. We don't know what was used to train it. We don't know the parameters, right, that are set. And so we need some transparency to help us.
That's correct, sir. It's really just about like what data is being fed into it and why is that affecting into a inflated market in the sense of the market, I guess, not being inflated properly in terms of a civic adjustment, mill rate adjustment, et cetera, as opposed to being artificially inflated just for the case of making profit.
And so we know we have a housing crisis in the state. And in addition to looking at regulating algorithms in regards to pricing, would you be interested in looking at, in terms of making the decisions on whether or not you're getting an apartment? So for instance, 50 to 70% of large landlords, depending on which survey, are now using AI for screening tenants. Do you think that should also be regulated and tested in some way?
Well, listening to the testimony from the prior individuals, one thing with AI in particular that I'm very careful of is the trust process, right? Is knowing that what it's doing is proper and it's actually it's using the data that we give it and it's not daydreaming it, right? Because a lot of models daydream data.
Right.
In terms of landlords using AI to approve tenants, I think there should be regulation on that, just because there's so many models out there that you can throw the same candidate through all these different models and get different results on if they're qualified or not. So I think there really needs to be a baseline there. If we're going to go down the AI route for that, there has to be a baseline set or established, at least some kind of rules or regulation on that. I think AI should be regulated properly before it can really wreak havoc on our lives, essentially.
I think agreed on the trust, right? People need to trust it before we see full adoption.
Yeah,
Pew Research has a lot of data on, right now it's over 60% of the people are more concerned than optimistic about using AI.
I think a large amount of the concern just comes from the lack of regulation, from just the fact that, you know, we have all these different models out there, all these different systems out there that can go do everything from, you know, solve math equations to clone someone's voice, right? Like there's no bounds that people feel. And I think that's a big issue with AI. And I think that's an issue with the trust, is that we just, you know, are able to do so much with it. And it's like the Wild West right now.
And would it, I guess this isn't going to surprise you. It's going to surprise some of the people listening probably, but to know, obviously we've heard AI is not new. So there's actually a 2019 lawsuit in Connecticut for a man who was denied an apartment because it had erroneous data attached to his name. So what if we're not allowing people to see what the decision was based on? Are they going to continue to get denied for apartments? And again, in terms of that being nothing new, FCRA, Federal Credit Report, Fair Credit Reporting Act, was passed in 1970, that in financial decisions gives you the right to see that data.
Right. And I think even with that regard, if AI is going to turn down tenants, you know, that are qualified to rent, and let's say they pay an application fee to apply to that apartment, you know, if you think about that, that's lost money that if a human looked at it, they may have been approved for.
Yeah, that's an interesting way.
You know,
an interesting point you've brought up, that if you're not correcting that, they're going to continually be paying to get denied.
Yeah, if let's say the AI system, right? Let's say the model is broken and the landlord doesn't know it.
Right.
And now they're just denying every single tenant. They think they're just getting, you know, poorly qualified applications, but they're just stacking up application fees now. Now they're just making money off of that because the AI is denying everyone. They don't think there's anything wrong with it. It's AI, you know, it's smarter than I am, you know, so.
Great. Thank you so much for your testimony. Are there any other questions? Thank you very much.
Thank you. Thank you guys so much.
Okay. Next up is Aaron Kirk.
Hi there. Can you hear me?
Yes, we can hear you. Please proceed.
Good afternoon, esteemed members of the General Law Committee, and thank you for allowing me to testify today. My name is Erin Gorman Kirk, and I'm proud to serve as the first in the nation cannabis ombudsman. With a 40-year career in government affairs, intelligence, international maritime, and business, I'm excited to elevate Connecticut's interstate and international commerce in the cannabis and hemp industries as they grow, positioning us to lift up communities, create jobs, and add to state revenues, all while protecting the health and well-being of Connecticut patients. The Connecticut Office of Cannabis Ombudsman was established under PL Act 2379 in 2023. We are a dedicated patient advocacy office created with the main purpose of servicing cannabis patients, many of whom are in palliative care, undergoing chemotherapy and radiation, suffering from diagnoses of chronic neurological pain, Huntington's and Parkinson's diseases, and our hero veterans suffering from PTSD and other combat and service-related maladies. The statutes mandate that the ombudsman represent the interests of qualifying patients and caregivers, identify, investigate, and resolve complaints, monitor the palliative use of marijuana, and recommend and facilitate public comment on any changes to the laws, regulations, policies, and actions that the OCO deems appropriate to, among other things, improve the palliative marijuana market in this state. I'd like to point out that most of the patients we hear from are over the age of 50, who have unsuccessfully tried opioid-based treatments recommended by prior caregivers and have found cannabis to be a far more impactful alternative with fewer harmful side effects. Medical cannabis patients in Connecticut are currently facing significant challenges that threaten their access to essential treatment. Despite the state's best efforts, patients continue to encounter obstacles such as high costs, limited product availability, and bureaucratic hurdles. These issues have been exacerbated by the rollout of the adult use marketplace, which has diverted resources and attention away from the medical program, unfortunately. The argument put forth by larger, wealthy cultivators, including those who will testify before you today, that the medical program will die a natural death is deeply troubling. Data from other states with both medical and recreational markets have shown a concerning decline in medical cannabis programs. For instance, Nevada experienced a 32% drop, and Colorado reported a 28% decline in registered medical marijuana patients, much like Connecticut following the adult recreational legalization. It is morally imperative that wealthy entities who have profited immensely from the loyalty and trust of medical cannabis patients over the past decade continue supporting this vulnerable population. These patients have relied on medical cannabis to manage chronic pain, anxiety, and other debilitating conditions. Abandoning them now would be a grave injustice and a betrayal of the very foundation on which these businesses were built. Why would those who we gave first market advantage and who have reaped millions and millions of dollars from loyal patients now turn their backs on these very individuals? The community at large believes there is only one answer: greed. Greed blinds you to the loyalty of those who built your success, and in the end, it will be your undoing, is a very common saying that I'm sure you've heard. Patients are not abandoning their medication. They are illegally purchasing it online and illegally driving to other states where they can get the medication they need. For them, the risk is worth it. They want the same consistent medication they've had for years, and they've expressed to this office that they are being denied that consistency. Massachusetts, New York, Rhode Island, New Jersey, and even Maine are now common destinations for our patients who have ceased patronizing our own businesses due to their perception of their treatment and the lack of availability of their medication on a consistent basis. Retailers in these states are actively seeking businesses from Connecticut, patients, and other residents by advertising their superior product quality, potency, and variety. They have billboards right on our corner. We must recognize that the success of the medical cannabis industry is intertwined with the well-being of its patients. Without their support, these businesses would not have achieved their current success. It is both unethical and short-sighted to turn away from those who have been instrumental in their growth. Instead, we should strive to ensure that medical cannabis programs remain robust and accessible, providing the relief and care that patients so desperately need. Relative to earlier testimony, the OCO would also like to mention, we have contacted the AG's office upon hearing of tainted illegal products being sold and fully support and encourage aggressive, very aggressive enforcement against unlicensed businesses. New York, by the way, has a specific label, a sign on all their dispensaries with a QR code on the front that all legitimate dispensaries must put on their doors before anyone walks in. I think Connecticut should absolutely utilize that. I recently heard from a child, 20 years old at Fairfield University, who went to the Savvy Shopper in Westport and got a bag of 1,000 milligram gummies. Our package limits are 5. They took a 50 milligram gummy and ended up in the hospital. I did mention this to the AG's office, and I have not heard back, but I think we should aggressively go after these folks. I would also like to mention, earlier we talked about children. Parents need to take additional precautionary measures with their cannabis, as should everyone with any medication. This office endorses the use of locked storage mechanisms, particularly with the biometric lock, which only a parent can open. And we have Connecticut companies which make those exact things. So in conclusion, I thank you for this position, the first in the nation. We have 38,000 patients. I've heard from about 100 so far in the very few months that I've been here. I've reached out and spoken to many of the cultivators, and I secretly shop at many of the stores and have seen both the good and the bad. And all I'm asking is that in relation to the caregiver bill, if we are not going to do a micro-medical grow or anything that satisfy the needs of patients, then perhaps this would be a good alternative. And I appreciate your time. Thank you so much. I'm happy to take any questions.
Great, thank you so much. Are there any questions from the committee? Very interested in the what you mentioned with the QR code in New York. So I will reach out to you after this, and we'll continue to work with you on seeing if there's a possibility to integrate that into our legislation. But thank you for taking the time to come and testify before us today.
Thank you. I'm sure there'll be other opportunities, but I didn't want to miss this on behalf of our patients. Thank you.
Thank you. Next, Representative Tracy Mara.
Good afternoon, Chairman Maroney, Chairman Lamar, ranking members, Rutigliano.
I'm sorry. Next is Representative Mara, and then you'll follow after that.
Gotcha. So my
I'm sorry. Okay, Representative Mara, please proceed.
Thank you so much. Thanks so much for squeezing me in. Thank you to the General Law Committee. This is one of my favorite committees, actually. I have a little bit of FOMO. I like being here. I'm here today in support of the DCP Bill 6855, in particular, sections 4I that talks about the language of kratom and its derivatives being considered as a scheduled drug. So I imagine that you will hear a lot about kratom today, but in brief, it is an herb similar to caffeine and has been gaining in popularity in the U.S. for the past 15 years. It is natural in its natural, unadulterated form. Kratom has mild stimulant effects and it's a small opioid-like effect. But it does interact with the same receptors that opioids do. The growing concern is the widespread adulteration of kratom that we have now. Companies have been able to synthetically alter kratom, producing products with significantly heightened opioid effects. And over the years, we've seen a troubling rise in deaths linked to these stronger, unregulated formulas. And at one point, the federal government even attempted to ban kratom back in, I believe it was 2016, but at that point, there was a large public outcry that prevented it. Since then, today, we've seen a different, more urgent situation. Adulterated kratom is increasingly being marketed to children, often in candy-like products with dangerous high opioid effects. And the ease with which these products can be purchased is very simple. You can easily pull out your phone right now and type in "buy kratom," and you will find numerous local shops as well as plenty of online colorful, flavored, and highly concentrated kratom products. So the federal government has failed to act in this situation, and it has now come upon us as the state to protect our community. I strongly support the bill and any measure that is aimed at banning the adulteration of kratom, to prevent synthetic alterations that increase those opioid effects, and prohibiting the sale of kratom to children, and to prevent that predatory marketing that we have. We consistently discuss the need to address all forms of addiction and protecting the residents of Connecticut, whether we're talking about social media, whether we're talking about cannabis, and now we're talking about kratom. So I sincerely urge that you support this, and I feel like I am speaking to the choir, but I thank you for the opportunity to testify. Thank you.
Thank you so much, Representative Lamar.
I want to thank you, Representative Marr, for coming here today, highlighting this issue. I think you're going to find this bipartisan support on this. It's something that clearly is impacting every one of our communities, getting in the hands of, not only children, but just people who generally may fall for some marketing line that may be completely inaccurate, and they end up with a dangerous product on their shelves in their home. And I think this is a responsible way for us to look at this, giving DCP the power to crack down on folks. And it's usually the businesses that are illegally selling these products. They know what they're up to. They know what they're doing. They know these products aren't allowed on the shelves in Connecticut. So I do respect the bipartisan effort that we've had in our early stage conversations and screening. Representative Rutigliano, myself, Senator Maroney, Senator Ciccarella have been like lockstep on making sure we get these products off the shelves here. So I appreciate your
one of the things I love about this committee.
So thank you.
Are there further questions? Representative Acker.
I did have a question, but I thought that the good chair kind of had closing remarks on this, so this was pretty good. But just for my knowledge, Representative, would you consider this to be like a low dose opioid? Because you said it acts like the receptors are like opioids. Is that correct?
That's right. And so in the original form, yes, it was low dose. But what is happening now is it's been adulterated so that now you have different products that are coming out of it. So it's more synthetic. It's not just the original leaf anymore, and you just don't know what you're going to get. And that's what happens when things are unregulated like this.
Thank you for that. I appreciate that. Thank you again, Mr. Chair.
And I will submit testimony, and I'll have a couple links at the bottom that if anybody wants to do a deeper dive. And
Great. Thank you so much.
thank you so much.
Okay, next, Jerome White, to be followed by Representative Kara Rochelle.
Good afternoon, take two. Chairman Maroney, Chairman Lamar, ranking members Rutigliano and Ciccarella, and all members of the General Law Committee. My name is Jerome White. I'm a licensed electrician in Connecticut and a proud member of Local Union 488 of the International Brotherhood of Electrical Workers. Thank you for the opportunity to speak today on SB 1236, an act concerning solar licensing exemptions. I have submitted written comments as well, but I wanted to speak to you today about the confusion this exemption creates and how this bill will help clarify that confusion. From what I have already read from those that oppose this bill, there is a concern that individuals performing non-electrical work will now have to obtain an electrical license. The argument you will hear is that installing a solar panel or making a high voltage wiring connections is not electrical work, even though a solar panel starts producing energy as soon as it is exposed to sunlight. The definition of electrical work from the Connecticut General Statute means the installation, erection, maintenance, inspection, testing, alteration, or repair of any wire, cable, conduit, busway, raceway, support, insulator, conductor, appliance, apparatus, fixture, or equipment that generates, transforms, transmits, or uses electrical energy for light, heat, power, or other purposes. In 2005, through legislation, solar electricity was further defined and a limited solar electrical license was created to address the concerns of having properly installed installations and increasing the labor pool through licensure, workforce development, and apprenticeships. The exemption we are talking about today was passed in 2007 without a public hearing, crippling the intent of the solar license and weakening the integrity of electrical licensure. Would you also believe that there are only 11 active PV1 contractor licenses and 18 active PV2 journey person licenses in the entire state? 29 license holders for a license created 20 years ago? The new clarification will better separate work requiring an electrical license from the work that can be done by trade workers like roofers, laborers, carpenters, or even operating engineers. This comes more into focus on large commercial scale and utility scale projects where there's a potential to have dozens of workers on a project. Solar energy systems are inherently electrical by nature and should be treated as such. There is also a level of integrity and pride that comes with any occupational license as well as a statewide recognition. And current installers performing solar work, I feel, are the ones missing out. I know you have a busy day today, so thank you for your time and consideration.
Thank you very much for your testimony. Representative Acker.
Thank you, Mr. White. I thank you for your testimony and what you do with IBEW. So my question, and I think you touched on it a little bit. You mentioned that more of a focus in terms of the large commercial scale work, and I take it that IBEW is very active in that commercial scale work. Is that correct?
We're trying to become more active.
What would be on the commercial side? What would be inhibitive of you being more active?
Well, the way the exemption is written right now, it's unclear on who needs to have that electrical license. When it comes to claiming work, do we have laborers saying we can install the solar panels? I mean, even by the way the exemption's currently written, and I hate assuming things out of statute, but it says without the license being excluded, it says you can perform work limited to hoisting and placement and anchoring of solar collectors and photovoltaic panels. Doesn't say the interconnections, doesn't say the bonding, doesn't say anything like that. So right now there's confusion on who does the electrical work. Just by the definition of what is electrical work, a solar panel, I feel is electrical work by the statute, and we're just trying to reclaim that work.
Thank you. So the racking component, which is the grid work per se, right? The metal work that is done, on the roof, putting that in would still be under the I'll call them installers in a case, or roofers in many cases do that, carpenters, because they're more inclined to be climbing on roofs. Those would still be under the non-licensed category?
Yeah, I mean, we're removing we're trying to clarify what can be done without an electrical license. Anything from uncrating, uncrating, hoisting, placing, anchoring supports, mounting of those racking systems, distribution of the panels and collectors, the concrete work, and installation of ground screw supports. This way, yeah, if that is all the work that individual is doing, he doesn't need to have a license. If he's installing the glass and making those interconnections, I mean, we created this license 20 years ago. If they want to have a limited photovoltaic license, and I encourage that we go back to the original intent from 2005 and create that license, and not create the license, but advocate and use that license.
Do you know thank you for that. And do you know the scale of the because I look at the residential side in terms of the amount of work that's being done by many of our good companies in the state of Connecticut that do solar work. And many of the companies, in most cases, have more installers as opposed to trade licenses doing the work, meaning that the trained people that get up and do the roof and they carry the panels up. I've done that work. Carry the panels up, mount them, screw them down, and then they plug them in, and the electrician does the line voltage work. How much does your IBEW members and other union members doing the magnitude of solar work for residential in the state of Connecticut at this time?
I don't have a good number for the entire state of Connecticut. We are trying to do more commercial and industrial. We have several contractors that perform well in that area. Residential across the IBEW has always been a challenge. Prices are more competitive. We have employers that try to do more work in that area, but unfortunately at this time, I don't have a definitive answer.
Okay, well, thank you again. And again, I appreciate your time with us, as I always do, speaking with the union members. Thank you. Thank you. Mr. Chair.
Thank you. Are there further questions? Okay, hearing none. Thank you for coming to testify.
Thank you, everyone.
Next, Representative Rochelle, Kara Rochelle.
Good afternoon, members of the General Law Committee, Senator Maroney, Representative Lamar, and the entire team. Thank you for taking the time. I'm testifying on a bill I introduced, HB 6478. This bill specifically addresses the use of algorithmic software in setting rental rates and the negative impact that is having. For those that are not aware, there is a multi-state lawsuit in conjunction with the Department of Justice that is currently ongoing regarding specifically this issue. The issue isn't hypothetical. This is happening right now. Connecticut recently joined North Carolina, Colorado, Tennessee, California, Oregon, Washington, Illinois, Massachusetts, Minnesota, and others in a lawsuit against RealPage, a property management software company which uses algorithmic software to set recommendations for fair market value. This sounds benign, but it's not. Using sensitive data about rental prices, algorithmic software is alleged by multiple states, red and blue, to be sharing data across multiple clients to set fair market value. This comparing across multiple clients violates antitrust laws and amounts to price fixing. As noted by Acting Assistant Attorney General Doa Mekai of the Department of Justice Antitrust Division, quote, "While Americans across the country struggle to afford housing, the landlords named in today's lawsuit shared sensitive information about rental prices and used algorithms to coordinate to keep the price of rents high." You know, we have a housing crisis in Connecticut. We know that we have the lowest vacancy rate in the country, and we'll be hopping around 1 foot forever if we're building, but then we are not addressing the software that is this algorithmic software in particular that is being improperly used to inflate the costs. And so I just wanted to draw that to your attention. I do want to let you know that there are 17 states that currently have laws introduced this year to regulate or ban the use of this software. Philadelphia and San Francisco have already passed city level ordinances to ban the use of the software. This is being used across a variety of property management companies. Software like Yardi is being used, and it's as simple as saying that they can turn this mechanism on and off in their software, and they should turn it off. This is not a software that is used to look at what rents currently are and what additional bills are being introduced, costs to the landlord are being introduced, and sorting out what will keep the landlord in good standing with their goals. This is quite literally just comparing data in an inappropriate fashion. So I urge that we advance this bill for the wellness of the rental situation in the state of Connecticut and all of our renters across the state, so that we can make sure that we're doing something that is meaningful to address the crisis in Connecticut. And I just want to also highlight to you that Governor Hochul in New York has included this initiative in her budget proposal that was passed that was introduced a few weeks ago as well.
Great. Thank you very much.
Absolutely. Any questions?
Are there questions? Thank you for bringing this. And I think it was a Yardi, their survey, I think they're expecting 70% of landlords to be using software like that. And so I think that it is incumbent upon us to act to protect potential tenants in this.
Yeah, it's not a matter of property management software. It's a matter of this algorithmic tool that's being used inappropriately to set rates. There's other ways to set rates using computers that does not involve this algorithmic software.
Right. And in addition, I think my concern beyond just setting the rates is making decisions on whether or not to approve tenants. And I think we need to look at that as well.
Absolutely.
Thank you very much.
Thank you.
Next is test item.
Hi, everyone. Good afternoon to you, morning to me. I'm here in Colorado. My name is Dr. Tess Edom, and I'm a senior research scientist at the University of Colorado Boulder in the Aerobiology and Disinfection Laboratory in the Environmental Engineering Department. So my PhD is in microbiology, and I work directly in the cannabis industry for nearly 4 years. I'm here today to address concerns about cannabis consumer protections, specifically Section 21A, 421J, 14N, regarding cannabis remediation disclosure. The proposed signage does not go far enough and does not actually protect or inform consumers and patients about remediation. So the underlying problem is really in this practice of remediation. Unlike in our food system, where spoiled or contaminated products must be discarded, microbially contaminated cannabis flower can be treated with decontamination methods like X-ray irradiation or ozone to remediate it after failing microbial tests. Sometimes manufacturers will actually use these remediation technologies before submitting to testing labs because they know that their products will fail due to plant infection or visible mold on the product. Remediation is essentially a cover-up for poor handling and growing practices, and this practice is specifically prohibited by the United States Pharmacopoeia in their recommendations for cannabis flower products, which state that such treatments should not be used to recover contaminated cannabis. Importantly, these remediation methods have not been thoroughly studied for safety, efficacy, and critically, they do not eliminate all contaminants. Mold allergens, toxins, and other potentially harmful microbial byproducts due to heavy levels of microbial contamination likely remains on the flower product. And many of these microbial byproducts are known inhalation hazards, and I study them in the laboratory. Remediation poses a risk to consumers, especially to individuals with allergies or compromised immune systems. Think about it. Would you want to eat food that was remediated with irradiation after it went moldy? So back to this labeling issue. Imagine a grocery store simply posting a sign stating that some items it sells contains peanuts. A generic sign like that is insufficient. In similar industries, product labeling of decontamination treatments is required by the World Health Organization in their recommendations for medicinal herbal products and by the FDA for irradiated foods. Cannabis consumers deserve to know exactly what they're purchasing and if microbial contamination resulted in remediation treatments to recover that product for sale. Cannabis flower manufacturers must disclose the type of decontamination or remediation treatments on the label specific to that batch of flour, not hidden behind vague and broad warnings at dispensary storefronts. Thank you for your time, and I'll take any questions.
Great. Thank you very much. Does anyone have a question? Representative Acker.
Yeah, thank you for your testimony. I have heard of complaints here in Connecticut in terms of the quality of our cannabis product, mold specifically. So what you're saying is that there's remediation that is being used here, and then that still poor quality is being sold and consumed in our Connecticut cannabis?
Right. So remediation is allowed in most states. It's allowed here in Colorado as well. And that basically, if a product fails for microbial contaminants, there's a couple different types of testing that it can undergo, from total yeast and mold to different bacterial counts to specific pathogens that can be found on that product. And if it fails, manufacturers have a chance to treat that product and recover it. And that process is called remediation. That is distinguished from decontamination methods that are used in food, like irradiation it can be used in food, but that food cannot be contaminated. It's an extra measure of control. And so it's not used in the same way. There's actually no equivalent in food safety for something like remediation. And so those types of decontamination treatments cannot be used in food to recover, let's say, spoiled product or product that was mishandled or processed in an unsanitary environment.
Thank you. And thank you for your testimony and calling in from Colorado. Thank you, Mr. Chair. Appreciate that.
Representative Iacarino.
Real quick, Mr. Chair, and thank you for your testimony. I've heard the same rumors, but is it more prevalent in Connecticut, the contamination and the mold? There must be a reason why this is happening.
So these types of contaminants can come in along the process at different points. They can come in as plant pathogens, so they infect the plant directly. And, because cannabis manufacturers are really relying on every single plant to harvest, they will harvest those plants that are diseased. And it can come in the post-harvest processing with spoilage microorganisms like Penicillium and Aspergillus species, which are very common microbial contaminants of cannabis. It is because most cannabis operations are actually indoors. A lot of this is linked to what I study, which is indoor air quality and proper airflow, circulation, sanitation practices, things like that. And that is usually where some of these processes are not really dialed in. Many of these manufacturers don't typically have, an equivalent manufacturing understanding in food safety, hygienic zoning, sanitation, good manufacturing practices, good agricultural practices. And so what typically happens is that these products get spoiled or infected or are improperly handled or stored, and they might be stored in warm, humid environments that allow for outgrowth of some of these microorganisms, and that can contribute to these high levels of total yeast and mold. And there's actually a researcher in Canada named Dr. Zamir Punja, who came out with a paper about a year ago showing the contributors to high levels of total yeast and mold. And most of it is linked to the environment in which it is grown and processed. And so, poor air quality, poor water quality, not removing diseased plants or decaying plant materials, all of that contributes to high levels of total yeast and mold.
It makes sense. Basically mass produced and not enough airflow.
Yeah, I say when you scale your operations, your problems scale too. And so that's typically what I've seen working as a quality consultant in the industry. Now I work full-time at CU Boulder.
All right, thank you. Thank you, Mr. Chair.
All right, thank you very much. And if you wouldn't mind, you mentioned that Colorado also allows for remediation. If you wouldn't mind just sending along to the committee their process as well so that I could look at that.
Sure.
Great. Thank you very much. Are there any further questions? Okay, hearing none. Next is Representative MJ Shannon. It's nice to have.
Love it. Thank you, guys. Weird being on this side, I guess, in a general law hearing. Um, Senator Maroney, Rep. Lamar, Rep. Retigliano, and Senator Ciccarella, and the rest of the honorable members of the General Law Committee. Thank you for having me here today to speak. I'm here to express my strong support for House Bill 5429, a bill that would grant caregivers the right to cultivate cannabis for patients in Connecticut. This legislation is a critical step forward in ensuring that patients across our state have reliable access to safe, high-quality, and locally grown cannabis for medicinal use. Currently, Connecticut's medical cannabis program has a gap. Many patients are unable to grow their own cannabis, and caregivers who have the knowledge and skills to cultivate it for them are restricted from doing so legally. House Bill 5429 seeks to address this by allowing caregivers to legally grow cannabis for patients in need. This would ensure patients have access to fresh, organic, and carefully cultivated cannabis while also creating a more sustainable and resilient system for medical cannabis access in Connecticut. What makes this bill especially important is that it empowers caregivers who are passionate about producing high-quality cannabis. Many of these caregivers have developed specialized knowledge and expertise, some of whom are also individuals with disabilities or other challenges. By allowing them to legally grow cannabis for those in need, we not only support their passion, but also make a direct positive impact on the lives of patients who depend on cannabis for medical relief. House Bill 5429 is about much more than expanding rights to caregivers. It's about improving patient care, supporting the growth of Connecticut's cannabis industry, and allowing more people to contribute to their communities in meaningful ways. I urge you to consider the far-reaching benefits this bill offers to Connecticut's patients and caregivers. I respectfully ask for your support in passing House Bill 5429. Together, we can make cannabis access in Connecticut safer, more equitable, and more sustainable for everyone involved. Thank you for your time and consideration.
Thank you, Representative Shannon. Are there any questions? Representative Lamar.
I want to say thank you for coming in today and testifying. I know we talked earlier on in session. There's a lot of letters of support on behalf of this. I know you could have generated 500 people here today to reiterate the same thing. I appreciate your ability to sort of consolidate that to make sure we're getting relevant testimony, but it isn't just 500 people saying the same thing. It was really, really well done to organize your effort here today. I appreciate your leadership on this issue. With that, I think we'll have greater conversations moving forward.
Thank you, Representative Lamar, and thank you to our Canna Warriors as well for organizing the effort too. So,
thank you. Okay, next, Jeffrey Dugan. What? I apologize. Next is, I had crossed off earlier because we thought he wasn't here. Kirk Wesley with Reno, correct? Okay. All right.
Affinity Dispensary and Grow. Good morning again, General Law Committee. Thank you for the opportunity to speak with you here today. My name is Kirk Wesley, and I am a co-owner in the Affinity Dispensary in Bridgeport. I appreciate the opportunity to speak today and would like to discuss the language in HB 6855 around eliminating the 20-mile radius rule for cannabis businesses with common ownership. Our organization participated in the state's social equity program that was the foundation of the state's adult use cannabis program, otherwise known as Responsible and Equitable Regulation of Adult Use Cannabis Act. I want to emphasize the equitable language. In the authoring of this legislation, the legislature created a 20-mile radius rule for cannabis businesses with common ownership. This rule was originally designed to ensure fair distribution of cannabis businesses and prevent large operators from oversaturating Connecticut's most populated areas. With cities like Bridgeport, Stamford, New Haven, Hartford, Waterbury, and Norwalk all within 20 miles of each other, removing this restriction would allow businesses to cluster in those markets, creating an unfair advantage for well-funded operators while undercutting those who followed the original rules. It's important to recognize that this change does not help small social equity operators like us. It benefits large companies that control equity joint ventures. While all EJVs include a social equity partner, most are tied to well-funded corporate operators, not independent businesses. This rule change would allow those companies to consolidate their failing EJVs into stronger markets, putting additional pressure on existing operators who followed the original regulations. If the goal is to help struggling EJVs relocate, how does this align with the intent of social equity? The program was meant to create opportunities to individuals from disproportionately impacted areas, not to provide large companies a way to reposition underperforming businesses. Smaller operators don't have multiple locations to move around. This change will only make it harder for us to compete. At the same time, Connecticut's legal cannabis market is just a fraction of the illegal market. Every day, more unlicensed shops open selling unregulated, untested products while consumers can easily access cannabis online. I'll wrap up by saying legal businesses must not compete only with these illicit markets, but also with the neighboring states that have stronger programs. And we're just asking you to consider and reconsider how this 20-mile radius will impact smaller operators in the state. Thank you so much for your time and appreciate the opportunity to come before you.
Thank you, Greg. I really appreciate your testimony today and helping clarify some of the issues here. Because my first read of this didn't reach the same conclusion that you did, that would be the necessary impact of it. So I think getting your insight into this is really helpful. I'll bring this up with the Department of Consumer Protection, try to clarify what the original intent was here and ensure we're on the same page. Because I think your market analysis has credence, and I'd like to ensure that we're protective of the original intent of the legislation, what we're trying to accomplish. So I think that was.
Thank you so much.
Are there any questions for Mr. Wesley? Seeing none, thank you again. Thank you. Jeffrey Dugan. It's not here. We next have a group, Mike Trahan, Paul Lemereau, and Sean Reel, that are going to be presenting together.
Mr. Chairman, good afternoon. Members of the committee, my name is Mike Trahan. I'm an executive director of Connecticut Solar and Storage Associations. Our members are most affected by this proposed bill. Our members are rooftop solar installers. They're also developers of commercial projects across the country. This session, the 2025 session, is the 15-year anniversary of the first time that this legislation was proposed to the General Law Committee. Back in 2010, then House Chairman Jim Shapiro of Stamford presided over a meeting in the General Law Committee conference room at which I attended, a couple of other members of our group did, and about 10 members of electrical unit contract groups from across New England. And at the end of that contentious meeting, it was decided that the language being proposed that would have eliminated the exception that solar installers currently use would not be part of any bill moving forward that year. Fast forward to today, this same bill proposal has been raised 4 other times. Today, this year, last year, and the year before, and the same comments that are being proposed by the proponents of the bill, you just heard them from Mr. White from the IBEW, have not changed. They're concerned about worker quality workmanship. They're concerned about worker safety issues. But the issues have not been backed up by any data, any substantial facts. And each time this bill comes up, it ultimately goes away because of that. What has changed over the last 15 years is that over 100,000 home solar systems have been completed by solar installers who have enjoyed the solar license exemption. all of those projects have been inspected by some combination of Eversource, UI, local building officials, or the Green Bank. All those projects are in place and working well and providing low-cost power to homeowners. So I have several, or two other members of our group that are going to speak to the technical issues of the solar installations, but I want you to know this. We brought this issue to the Connecticut DAS last year and asked them if any of the work, all of the work that unlicensed workers are doing in rooftop is considered electrical and required a license. He said no, that those contractors are working well within the rules of the state of Connecticut license. So with that, I can demonstrate the process of how this works if you all are interested at some point, but I'll see it over to Paul Lamro if I can. Paul is with Trinity Solar, the largest solar installer, residential solar in the state of Connecticut with over 300 employees based in Cheshire.
Good afternoon, general members of the General Law Committee. I'm here to go basically speak against SB 1236. By the words that were given before about the definition of electrical work, honestly, what he described as electrical work, plugging this little device in to charge your phone would be considered electrical work. The difference between this and our solar panels is the electrical connections. The prongs you have here are fully enclosed, showing no voltage. They're producing 53 volts max in full direct sunlight. These prongs that you can touch are 120 volts that your teenage kid can plug into a wall, plug their phone in. The output of this ranges between 5 and 90 volts. Our panel with plug-and-play connections requiring no tools, once they're connected to an optimizer, only produces 1 volt per panel. Any work that is requiring a tool, which is what the state has said in the past, is done by licensed electricians that we do have on every single job. So any connections where wires are stripped, connected, terminated, requiring a tool is performed by a licensed electrician.
Thank you, Paul. Sean, were you going to jump in here as well?
Absolutely. I'd like to speak a little bit to the implications of, some of the implications required that under this new version of the bill, that installers would have to, they would be allowed to install the racking, but they would have to climb down from the roof to allow an electrician and an apprentice to essentially mount the panels on the roofs. Now, for the reasons that Paul mentioned, that's needless. It creates operational inefficiencies that should not be in place. It also brings into mind an issue with, in the event that installers like Earthlight or like Trinity want to keep our installers on the roof able to mount panels, proponents of the bill would argue that we could just enroll them in apprenticeship programs. Well, due to the onerous installer ratios that are in place, we are not able to do that. That we would have to hire 3 electricians for every 1 apprentice. That presents a mathematical impossibility. There's just simply no way that we or other installers would be able to hire enough licensed electricians to do that work and to bring in that level of the apprentices needed. Now, what that leaves us with is increased timelines, installation timelines, which creates a bad customer experience. It creates a bad homeowner or business owner experience for folks who are looking at going solar, which can actually lead into increased costs. We're looking at if the bill were, if this legislation were in place today, we are seeing increased equipment costs that would undoubtedly be felt by consumers, by business owners, by homeowners. We're seeing interest rates increasing, which would be felt by, again, homeowners and business owners. Not to mention the fact that if you're bringing in licensed, more licensed individuals to perform this work, your labor costs are going to increase for a problem that once again does not exist. Our work is investigated. It's inspected by multiple parties. It's investigated by the municipal AHJ, by the local utility, by the third-party financiers that are ultimately paying out for the work, as well as the Connecticut Green Bank in a lot of cases. So this work really is, really is investigated and vetted out from start to finish by multiple parties. Thank you very much for your time.
Thank you each for your testimony here today. As you might imagine, this is a much larger conversation that's been taking place, as you referenced, for over a decade. And it's going to continue to come back. I mean, that's how democracy works, right? Individuals can be impacted by a proposed piece of legislation, feel it is unfair, and want to reconsider it. That's certainly an opportunity that's afforded to everyone. Like in that a determination was reached 2 years ago on a provision in cannabis law doesn't mean the people who are negatively impacted can't come back and argue to change that law. And I think you have a similar issue before us that you'll hear from more folks later. And I similarly on this issue, I know it's been repeated 3 or 4 times in the past. It's probably going to continue to be relitigated as the impacted profession generally, and specifically the nature of work as it evolves. There is growing concern that maybe some of these installations do require on-premises licensed engineers and electricians who know the complications associated with it. That being said, you've continued to make compelling points that the legislature has taken seriously and will continue to take seriously moving forward. I presume this session will play out as it has in the past, where there'll be ongoing conversations amongst all parties to see if there's a relevant solution in place. But I thank you all for your testimony here today. Seeing no other questions. Thank you. Oh, sorry.
Sorry, Mr. Chair. It's a quick hand raise. I appreciate that. Since they're all three, I can consolidate my questions, and all three can chime in if they so feel. You know, I've been in this building for a number of years, and I've been trying to create additional trade jobs with some resistance, and I continue to work toward that. And my concern is with this legislation, is that the individuals that are doing the racking and the installations on the roof, would it safe to say that you would need less of those individuals because they don't meet the licensure requirement? You can't use them, I should say, due to the licensure, because it doesn't seem like the workload would be lessened. Is that fair to say that we might have job losses due to this legislation?
Absolutely. Yeah, we currently have 61 electricians and 68 installers and 21 apprentices. By changing this, we would definitely have to increase our electricians. We'd probably be up to about 100 electricians we would need and about 40 installers, which would increase costs back to the consumer as well.
Thank you, Paul. And why that is relevant is that I put in legislation that was, we had testimony on Monday, that would eliminate the exemption for state, municipal, and federal workers, that they would have to hold the license. And I got pushback by DAS. I got pushback by the COGS, and all their statements were there's not enough workforce to meet the need to eliminate that exemption. And I know that because I work in that trade and cannot hire people because of the limitations that we have, the restrictions that we have. So I appreciate that. I look forward to continued dialogue on this, and in any way that we can work for a common goal. But one follow-up is, how many, between the two of you, how many installs have you done, let's say calendar year 2024? Residential installs, or all installs, to be honest, solar projects.
Total in Connecticut, we've done a little over 30,000 installs.
So not last year, but totally 30,000.
Correct.
Okay, thank you. There's a Sean.
About 4,500.
4,500 that you guys installed.
That is correct.
Thank you, Sean. Appreciate it. Thank you for being here. And Michael, thank you for being here.
You're welcome. And Mr. Chairman, just 2 quick points. First, I just want to repeat that Connecticut DAS has already determined that the work that these unlicensed workers are doing on rooftops is legal. They're working within the rules and regulations.
Yes, I mean, just to clarify, yes, and that's why people want to change the law, right? Like yes, it is consistent with the law, but some people feel the law should change, and that's the nature of the conversation. So of course they're going to say that it's consistent with the law because they are right. That is actually the law. some people feel like the law should change, and that's the nature of the submission before you.
Second, there are electricians on every job, every residential and commercial job. And then third, this idea that the bill should come back every year, I understand your point. I would also want you to understand that every time this bill comes back and gets out of this committee and is pending on a vote in the House or the Senate, there are somewhere between 800 and 1,000 families across the country who are walking on across the state who rely on this exemption for their job and would be out of a job. And they're walking on eggshells until this bill is dispersed each year. I just wanted to let you know that. Thank you for your time.
Thank you for your testimony here today. I'm sure we're going to hear a conflicting opinion on this issue as we move forward, but I wanted to say thank you for organizing the comments and the insight that is going to be necessary as this committee takes proper consideration of the proposal before us. Next, we have Kristen Souza, followed by Kurt Cameron.
Hi there. How are you today?
Good, Kristen. Thank you.
Good. Well, first of all, thank you so much for allowing me to testify today. I'm here to express my support for an act concerning caregivers, qualifying patients, and the palliative use of cannabis. The main thing that I really wanted to highlight is that we would not be reinventing the wheel here, but we would be building from the demonstrable success of similar programs that are already in place in other states. Colorado, Michigan, Maine, Arizona, Rhode Island, they all have very well established and regulated caregiver programs that help bolster their medical cannabis program. So for example, Maine, their medical cannabis program has been instrumental in providing patients to access with effective medicine. I know that we heard from Aaron earlier, our cannabis ombudsman, and in prior testimony, we hear quite a bit from patients that have concerns about the decline of the medical program, which statistically we can all agree on. I think that if I were to put myself in y'all's position, some of the pushback I think that we would receive is, one, how are we going to be able to track and regulate this? Well, as I noted, there are other states that are very definitely tracking their caregivers. As far as a loss of revenue to the state, that also does not occur because caregivers pay a small fee to be able to be a part of this program. This also allows them to cultivate a specific number of plants that they can then sell to qualifying patients. This is all tracked with the state, so there's no real concern for diversion of product. And on top of which, it helps our patients, which is really the primary objective here. It's going to help our small business owners, it's going to help our patients, and it's going to bolster our medical program, which is where we started in Connecticut. And the growth of the medical program in states like Maine has been achieved through the efforts of small independent growers operating within their well-established medical cannabis program. So I did provide written testimony. I'd be happy to email that to you all after the fact, but I really just wanted to highlight that we are not reinventing the wheel. There are other states that have done this, and us being Connecticut, I very much believe that we can not only utilize their prior successes, but build off of that and become a model for the rest of the nation. So thank you so much for your time.
Thank you. I really appreciate your testimony here today. Are there any questions for Ms. Souza? Seeing none, thank you again, Kristen.
Great, thank you.
Yep. Kurt Cameron, to be followed by Melissa Mychuk.
Thank you to the committee for the opportunity to provide some input on current and proposed regulations affecting the infused beverage market in Connecticut. First, I want to express my appreciation for the thoughtful legislation that was put forth last session. It allowed this industry to develop and grow, and enabled Connecticut manufacturers like myself to diversify, to retain jobs, and has created a framework towards profitability and growth. So thank you for that. It's also worth noting that there's a number of states that are utilizing a lot of the legislation that was put forth in Connecticut to incorporate into their own regulations. So we should be proud of that. That said, as this market evolves, it's essential that we continue refining regulations based on economic and industry data. There are three key areas I believe warrant some attention. Number one, evaluation of the proposed child resistance caps, taxation, and review of potency limits. I'll start with the proposal of child-resistant caps. While we fully support responsible regulation and consumer safety, to our knowledge, there's no documented evidence we are aware of any accidental ingestion of infused beverages by minors in Connecticut. In fact, beverages are inherently probably the safest format for cannabis consumption. To put this in perspective, I know there's been a lot of articles written lately on gummies. A child can grab a box of gummies and ingest upwards of 100 milligrams of active ingredient. To put in perspective, to reach that same amount through infused beverage, a child would have to drink 33 12-ounce cans of seltzer in a short period of time. Some might argue that's impossible. It's also worth noting that in states where they have enacted cap mandates, their allowed potency is 50 to 100 milligrams a can. And they use this loophole of a 12-ounce can actually has 10 or 20 servings in it. So Connecticut was wise in legislation last year by saying 3 milligrams in a 12-ounce container, more or less taking that loophole off the table. So it's our feeling that childproof lids in Connecticut are essentially a solution to a problem that doesn't exist. And we just would like to have an open dialogue about whether or not it makes sense here. Secondly, taxation. It's no surprise that at $24 a case, we lead the country in the highest tax going. I never thought I'd say this, but please tax us like California does. California is, no surprise, number 2. Their tax is a 15% excise tax, which comes in about $12 a case. Colorado is second with a $15 excise tax, but they don't apply a sales tax to it. So they're in at about $10 to $11 a case. And New York has a 13% tax, which is about $11 as well. It's our position that this high tax burden has significantly hindered the market growth. And we would just like to have an open dialogue about a more reasonable tax rate for these type of products. And lastly, potency limits. We have 3 milligrams per serving in Connecticut. It's the most restrictive in the country as well. Some states have allowed for 5 to 10, but that's per serving, not per container. Now, I'm not advocating for 50 milligrams per container. I frankly think that that's irresponsible. But something a little more modest, like a 3 to a 5 in an entire container, would be something that we would appreciate so we could be a little bit more competitive with surrounding states. So thank you very much for your time.
Thank you. I really appreciate your testimony on this issue and your investment in Hartford and beyond. I do recognize that it's extraordinary investment that a lot of companies in Connecticut have put into both the packaging, marketing, development of business in here in Connecticut. And so I recognize a new regulation being proffered this year has caused a little bit of concern because a lot of you just finished designing your product placement. I certainly do appreciate that. I do question sometimes well, because this isn't as bad as accidental ingestion of gummies, you shouldn't regulate us at all. So that's the part I would differ. I was like, yeah, that's terrible. We need to regulate that. Also, should we potentially be considering this too? Is I think a reasonable conversation point.
Oh, absolutely.
And I think the distinction I have is we don't require the childproof caps on other forms of intoxicating beverages,
right?
And at this standard. So I wonder why we would start that process now with a relatively low potency beverage, right? Like I think that's the more salient, more actionable opposition to this bill is
No.
in that vein rather than, well, it's not as bad as accidentally ingesting gummies, so don't bother.
Yeah, no. And that's, candidly, I was in New Jersey earlier this week. 50 milligram, 12-ounce cans are everywhere.
Right.
And in that particular scenario, a child could get a hold of that and do some real damage.
Right.
But with these products at 3 milligrams, that coupled with the fact that there's no documented evidence that it's ever happened in Connecticut, I think you're looking for a solution to a problem that doesn't exist.
Yeah, and I think part of the worry is the prevalence of those highly dangerous levels of infusion in other states. People end up with those things, even though it's illegal to bring them into Connecticut, they end up in a refrigerator. And do we want to be the first state that starts to put real hard rules on this, recognizing, gosh, we actually can't control that marketplace that ends up in Connecticut, and then we end up unnecessarily burdening Connecticut businesses by regulation that we're not impacting the problematic elements of regardless. So I do, right, like as you can see, I'm struggling with this one because I kind of see DCP's points on this, but I kind of see the broader business implications.
Certainly.
A little bit more. So I think that's
And this is an ongoing sort of thing we're all learning about, right, as we go. And the reason I'm here today is the open dialogue with you guys to make sure that we enact common sense regulation and legislation around this topic.
And I think the experience you referenced early on in your testimony, working with this committee in the past, even before I was chair, with prior House Chair Representative D'Agostino and Senator Maroney, to craft reasonable common sense resolutions is the model that we want to incorporate this year as well. And so hopefully this conversation is the first of a few that we can have to make sure that we're getting there.
Great. I
And I
appreciate
think
the time.
the compelling ask with respect to the tax rate is on point. I think we're all with you when we want to push that over to the Finance Committee, because it does seem largely unreasonable at $1 per can. Like
Yeah, when California laughs at us, we know we have to review something, right?
I don't know if I go that far, but I'm with you on this very specific regard.
Okay.
Are there any other questions for Mr. Cameron? Seeing none, thank you again for testimony. We have Melissa Mychuk, followed by Yasha Khan.
Hi, everybody. My name is Melissa Machak. I am a Manchester resident, and I've been a medical cannabis patient for over 8 years in Connecticut, very involved in recovery, and I'm an advocate for myself and others. I do work as a peer recovery support specialist in Connecticut, and I'm a drug and alcohol counselor. I appreciate the opportunity to come here and talk about HB 5429, which I strongly support. Many of the people in Connecticut have been in a worse position since the quote-unquote legalization of cannabis in our state than when it was totally illegal. The current language in the bill is confusing, and historically, when something is confusing, it isn't to the benefit of the receiving party. This is a term called obfuscation. It is a way for the big folks on top to change meanings as needed so they meet the intended agenda. We as patients and caregivers need clear language with clear definitions and penalties that are appropriate. There's been restriction and red tape for patients and more recently recreational consumers who want to grow their own plant medicine. There are astronomical fees for consumers to test the cannabis not only grown at home, but to verify test results provided by dispensaries who have loosened regulations on mold allotment, pesticides, and treatments done to the plant to maximize profits at the cost of providing quality medication to consumers. Instead of investing in and changing the program to benefit the people the program was meant to protect, we are spending money to help discriminate against and restrict people and line the pockets of the corporations at the expense of the well-being of people who desperately need a model that keeps their best interests in mind. Many people cannot afford what's being offered in the dispensary, and many times can't even get their hands on something that's needed for complicated physical and mental health issues because the growers simply aren't growing it because it doesn't make up enough of a profit for them. The integrity of the cannabis culture and of nature's medicine is at stake. Cannabis legalization for most was expected to be the better alternative to big pharma, and yet all of the greed of the opioid epidemic is on par with the greed displayed here in our state over a plant with healing properties. Adding more qualifying medical conditions so that more people can be subject to the abuse of the Connecticut medical marijuana program and the DCP is unethical. As the people with the ability to make a difference, I ask that you guys get educated and make decisions based on what constituents need, not what the greedy corporations want. This bill will help small businesses in the state and help people who have families and jobs, yet still do what they can to make sure that people they serve have safe, affordable medicine. This bill would help put patients over profits. This bill would benefit people who can't afford, want to grow their own, need it to survive and function, and those who have been sitting in jail for the same things the DCP and CTMMP are doing legally. Legally, yes. Ethically, no. It's very shameful that in this day and age there is so much greed driving humans to be inhumane. Patients are suffering, and caregivers are risking themselves daily to do the right things by these patients because those who have the ability to do right things by them are not doing it. Thank you for your time.
Thank you for your testimony, Melissa. I really appreciate you joining us this afternoon. Seeing no questions. Thank you again. Yasha Khan, followed by Ray Antalina.
Good afternoon. Thank you for the opportunity to speak today. My name is Yasha Khan, and I am calling in from New York. I've worked in cannabis testing for the past decade, and this testimony is in reference to proposed bills relevant to cannabis. In every legal cannabis state, including Connecticut, cannabis products must undergo testing by cannabis labs. Only products that pass safety screens can be sold. Most states collect and retain all of the cannabis testing data because this information is very valuable. Policymakers, auditors, public health specialists can rely on this data and use it to monitor product safety, assess market trends and dynamics, and strengthen enforcement and consumer protections. With comprehensive testing data, states can make informed policy decisions, compare their markets to others, and identify why a market may be underperforming. This data-driven approach helps improve consumer safety and the overall success of cannabis programs. However, Connecticut is an outlier as it is one of the few states that only collects a small amount of this data, making it far less useful for oversight, public health, and market analysis. Not collecting this data is a missed opportunity that can easily be remedied. Fixing this is simple and can be nearly cost-free. For example, some states require labs to email test results to a designated email address maintained by the regulatory agency. This data doesn't need to be analyzed in real time, just collected and available for when analysis is needed. By making this small change, mandating that all results be submitted to the state, Connecticut can gain the tools to better understand its cannabis market, to make data-informed decisions. And maybe half an hour ago, a committee member asked the question, does Connecticut have more mold problems than other states? Now, I don't think that Connecticut can answer this question, or anyone can, without this data being collected. So my recommendation is for a small change to the regulations so that all testing data starts to be collected by the state. Thank you.
Thank you for your testimony, Asha, and I appreciate your research and knowledge of the overlying economy on this. Any questions for you, Asha? Seeing none, thank you again. Ray Pantalina, followed by Gordon Welpe.
Good afternoon, Chairs Maroney, Lamar, ranking members Ciccarella, Ritigliano, and honorable members of the General Law Committee. My name is Ray Pantalina. I'm a dispensary pharmacist at Affinity Dispensary. I've been a dispensary pharmacist for 6 years in the state, working in both New Haven and Bridgeport. I support the proposed legislation, House Bill 6855, particularly the section allowing dispensary pharmacists the ability to qualify patients for the medical marijuana program. I am in support of not only dispensary pharmacists extending patients' cards, but also renewing existing patients' cards and qualifying new ones. Dispensary pharmacists are trained frontline professionals of the medical marijuana program. We have both the pharmacologic and cannabis knowledge necessary when evaluating, consulting, and meeting with medical patients. We see and interact with all the medical patients on a regular basis. When orders are placed and reviewed, questions need to be answered, and consultations are requested. To improve continuity of care within the medical program, it's just common sense to engage the dispensary pharmacists as another option for medical patients to obtain their certification and medical cards. I'd also like to follow up on earlier comments by Representative Candelaro's comments on the proliferation of the illegal untested cannabis sales in smoke shops, gas stations, and the corner markets across the state. New Haven has thoughtfully begun the process of licensing the vape shops in the city and will be limiting the numbers and locations. This will enable them to monitor and control the explosion of these stores and sales of illegal products. I also agree that a prominently displayed sign at the front door, similar to the health department scorecards that have been talked about, that restaurants post at their entrance would be helpful. That sign would inform customers that the store is not legally licensed to sell cannabis and that the products being sold have not been tested for contaminants. Lastly, the ability for local towns to fine landlords once they're notified who knowingly rent 2, or allow continued use by these tenants selling illegal and untested cannabis is an enforcement tool that all the towns should start using. I want to thank you for your time, letting us speak today. If you have any questions, I'm more than happy to answer.
Thank you so much for your testimony here today and in referencing some of the tools that other communities across the country are using to crack down on illegal sales at a lot of vape shops, smoke shops, and convenience stores. Senator Maroney.
Thank you very much for your testimony. I have just some questions. I need your help in understanding something. I think Representative Tigliano and I were discussing this issue earlier. Like, I definitely agree with the ability of the pharmacist to extend the medical card, right? That's kind of within our, we've expanded the practice of pharmacists over the last couple of years through the collaborative drug therapy management, allowing them to practice with, with agreements and to do that, to renew prescriptions without necessarily having to go back to the doctor. My question is, with certifying the new patients, so with the new patients, I mean, there are certain diagnoses that would qualify you to become a medical patient. Would that be done then by the pharmacist? They would just look at something from the doctor and then certify that the patient had met that to allow them to get the temporary card, I guess, until they went back to the doctor?
So we would obtain documentation from the physician that's been treating them for the underlying condition. There's currently 42 underlying conditions for adults. We would collaborate with the doctor. Currently, the way the system works are the physicians or APRNs qualify the patient. They then meet with us when they come in the first time. We go over their underlying condition. We discuss what products are available. We come up with a protocol. We titrate over time. We titrate up, we titrate down to get the best effect. So we're already working with the patients, but we would work with their doctors that have been treating them for those conditions. We just can't have someone come in and say, hey, I've got this. We'd have to have documentation.
Okay, great. No, that makes sense then. So you would have the documentation that they have the condition. I think one of the issues now is I don't think insurance covers when they go to the doctor to get certified. So this would allow, they would have the diagnosis of the condition and then come to the pharmacist with that diagnosis. So great.
Correct.
That makes sense to me. Okay, thank you very much. Thank you, Chair.
Thank you. Senator Cigarella.
Thank you. I just have a couple quick questions for you, just so I understand this process. When they have a medical marijuana card and you have a patient come in, depending on the diagnosis, is there a specific type of marijuana or plant you would give them for the specific ailment they may have?
Yes, there are. So depending on what their condition is, it could be a combination of a THC product. It could be with CBD. It could be an oral tablet. It could be a capsule, a tincture, depending on their lifestyle and what they're trying to achieve. Some of the products have much longer durations of action. If elderly people come in and they're trying to no longer use Ambien or Zolpidem or any of the sleeping pills, we'll go with a preparation that'll give them 6 to 8 hours of duration versus something that's quick onset and short duration. Depending on whether they're older, a lot of the older folks that come in, they're no longer willing to smoke or vape anything. So we work very closely titrating with oral preparations.
Thank you for answering that question. So you could essentially mix multiple different types of THC and you put it in a capsule or an oil or some type of an edible. Would that be how you would be able to provide I guess a tailored dose and strand to a patient?
We don't, the dispensaries are not allowed to formulate any products. That all products come pre-formulated from the producers. However, the producers do have, they have them by dose and they have them by combination. So you may have a THC product, that capsule that you can get 5 milligram, 10 milligram, 20 milligram. You can get them that are 1-to-1 ratios of THC and CBD. So you get both the pain relieving effect or you get the anti-inflammatory effect. and depending on their condition is what we work with.
Thank you. And medication, you know, that you would get from your pharmacist, prescribed from a doctor, sometimes it's based upon your, I guess, weight or body mass, and how often you would take it. Is that calculated into the you know, process of you determining what you're going to prescribe to the patient?
So we take that into consideration, also their tolerance. If they've been using cannabis either recreationally or have had experience with cannabis during our first consultation, their body mass, if they're a little 106-pound, you know, 65-year-old woman versus a 40-year-old, 240-pound man, yes. We try to start everyone as low a dose as possible. We feel more comfortable titrating them up to to where they need to be than titrating them down. So we do take all that into account.
Got it. And just my last question, if somebody comes in with a marijuana card and you make your recommendations to what they should be taking, and they say, I want something completely different, will you give that to them?
We'll try to talk with them and dissuade them back to a protocol we've come up with. However, we do have patients that come in and say, well, I really don't want this. I've been using this in the past and this has worked well for me. So we'll accommodate that too.
Okay. So to clarify, basically with that card, they could come in and say, you know, I want anything in there, and then you would give it to them through you.
At the end of the day, we would give them with a request after trying to consult with them in a different direction, but ultimately it's their choice. It's always patient choice. And yes, you're correct.
Okay. Thank you very much. Just trying to understand it. And I appreciate you answering the questions. Thank you very much for your time.
No problem.
Wondering if you can do any cleanup on that. All right, seeing no more questions, thank you very much for your testimony here today. Thank you, Ray.
Thank you, guys. Bye.
To be filed by Frank Price.
Can you press your button, please? Yeah. Thank you.
There we go. That way I don't have to yell. Senator Ciccarella and members of the General Law Committee. My name is Gordon Walpley, and I am representing my company Float House, a hemp-infused food and beverage manufacturer located in Windsor. I appreciate the chance to speak to you all today about House Bill 6855, as it directly impacts whether local businesses like ours can survive and thrive in Connecticut. Over the last 4 years, we've poured our focus and energy into creating safe, high-quality hemp beverages that consumers love. This is a complicated space to navigate, and we appreciate the hard work the committee and DCP have done to design and implement thoughtful regulation here. I'm here today to offer my perspective as a Connecticut manufacturer on the proposed definition for a container in HB 6855 that would require child-resistant packaging for infused beverage. This requirement imposes a costly and unfair burden on infused beverage manufacturers and brands. If you've seen hemp-infused beverage for sale here in Connecticut, you might have noticed that they're sealed in standard cans and, per Public Act 2476, exclusively sold in package stores, which are age-restricted environments where no minors are allowed to purchase. The proposed requirement to add difficult-to-source and expensive child-resistant ends or toppers unfairly targets our industry. Alcoholic beverages can have far higher levels of intoxication potential and don't require child-resistant tops. Hemp beverages with just 3 milligrams of THC shouldn't be regulated more harshly than Hard Mountain Dew, Spiked Sunny D, or Four Loko. Accidental ingestion by a minor is a paramount concern for any intoxicating beverage, and I assume this is what DCP is looking to address with this requirement. While CR toppers can be a clear visual indicator that a can is not meant to be ingested by a child, I've got one here, You can see it on the top, not from the side. The other option is a plastic top that has to be manually applied to each can. And it is, you know, a good visual indicator. There is a far less costly option, which we would like to suggest. The International ASTM icon for products with intoxicating cannabinoids. The icon is bright yellow and stands out clearly on any package and can be easily added to label design at a negligible cost. In short, we want to compete on a level playing field to grow our business here and provide jobs and tax revenue for Connecticut. Let's limit adding costly obstacles and give us the chance to succeed here at home. Thank you for your time, and I'm happy to answer any questions.
Thank you so much for your testimony. And I look, your submitted testimony is outstanding, and I encourage anyone to go ahead and look at this because it actually goes into great detail about some of the practical implications of the child-resistant tops and how they would apply to the business. Makes it so that 4-packs are largely impossible to distribute. The overall cost basis for each of the types of child-resistant thing versus the labeling, like it's really, for purposes of understanding the issue a little bit greater detail, your testimony has gone a long way and at least providing me that background on that. So that's terrific. We've spoken before. You came in for our screening and had some early stage conversations about some challenges internal to the business itself. I really appreciated that conversation. I think this is an exploratory issue that the DCP has introduced for us because it is problematic. We did I appreciated the prior person's testimony that there's no documented case. Well, like I'm hearing from people actually in my community who are a little bit worried about the things they put in their refrigerator and whether or not their child, when they come home from school the next day, may or may not inadvertently drink something. Ultimately, I tell them, look, that's on you as a parent to sort of like, first and foremost, that's your responsibility. But recognizing that maybe there is an additional producer responsibility as well. And so I think that label may be the appropriate way for us to get to the point. So I think your testimony is well founded here, and I do appreciate the patch visuals that you've provided and sort of like the cost basis understanding of it. It's great. It's great. So thank you very much.
My
Are
pleasure.
there any questions for Gordon? Seeing none, thank you again.
All right, thank you.
We have Frank Price to be followed by Ed Hawthorne. Frank, are you online? All right, Madam Clerk, if you do see Frank come online, just let us know and we'll come back to him. Ed Hawthorne to be followed by Bill Finch. I saw Bill was in the room, so if anyone sees him outside.
No, Bill has important things to say. Good afternoon, Senator Mulroney, Representative Lamar, and members of the General Law Committee. My name is Ed Hawthorne. I'm proud to serve as the president of the Connecticut AFL-CIO, a federation of hundreds of unions representing over 250,000 working people here in the state of Connecticut. It's on their behalf I testify for multiple bills here today. I'll start out with SB 1249, Act addressing innovations in artificial intelligence. First of all, as always, we have to thank Senator Mulroney for his leadership on this. I was able to watch your online forum via YouTube with your interaction with the AFL-CIO Technology Institute. Very informative as always, and thank you for including labor in this process. So AI offers opportunities and challenges, as we've heard today. It offers incredible opportunities, but it also poses something that we all want to protect, which is the potential for vulnerable populations to be left behind unless significant regulations are established. There are serious issues at play here. Discrimination, surveillance, suppression of rights, possibly suppressing the right to organize a union in the workplace, contingent work, the increase in temporary and contract work, and lower wages and job loss. The impact we're looking at here, AI can either improve working conditions and prosperity, which I believe is our collective goal on both sides of the aisle. We want that. But it also has the potential for economic inequality, curtailing of rights, and the undermining of our democracy. Workers want a voice in how AI is developed, implemented, and enhanced in their jobs and work product. So Governor Lamont's bill and the AI Venture Fund, we do have some concerns with it. The standardizing and integrating agency data systems and data management practices without sufficient protections. We need to protect public data from unauthorized access and ensure accountability. Also, some recommendations: rigorous procurement process to ensure compliance with labor standards, data privacy, transparency, intellectual property rights, and civil rights. We're concerned about testing without protections or proper licensure for workers and consumers. We want to create good jobs, living wages and benefits as a fundamental principle for funding recipients, and also include necessary guardrails for protections for workers and consumers. And I know Massachusetts was mentioned earlier, a few bills up in our neighbor to the north, HB 1873, which is an act preventing a dystopian work environment, and also the new bill that they have, which is SD 838, which is referred to as the FAIR Act as well. We're also concerned with the piecemeal approach. We have concerns about addressing different aspects of AI policy in separate legislative vehicles. By doing so, we risk omitting important pieces, creating imbalance and an unequal footing. We're looking for unified legislation that addresses all components of AI together as a cohesive and effective regulation. We look for collaboration from the members in a single bill. And I'd also like to indicate my full support, which Bill will talk to you about in a moment, for SB 1236, an act concerning solar licensing exceptions, or exemptions, I should say. And we stand in full support of our IBEW brothers, sisters, and siblings there. And I'd be happy to answer any questions you all may have.
Thank you. I appreciate it. Both this testimony that we wrote in person, but also submitted testimony on each of the bills. I do appreciate that.
Thank you.
We'll be able to explore a lot of this in detail over the next couple of weeks. I don't know how much of the AI conversation we want to have right now, but it's going to be an active conversation. And you've been a partner on this and made it clear to us what some of your concerns are. So we anticipate working closely with you as we move forward.
Absolutely. And I thank you for that.
Of course. Representative Ritigliano.
Just quickly, if you had to take SB2 last year or whatever iteration that we have currently, and then the governor's bill, do you have a preference between the two?
We would like improvements. SB2 is all encompassing, but we would like to see worker protections incorporated into SB2. And we look forward to seeing that bill and having worker protections in there where workers' voice is valued and heard. We mentioned Massachusetts earlier, and I mentioned two bills. I mean, an act performing a dystopian work environment has been replaced with the FAIR Act. FAIR Act has been described by NELP, the National Employment Law Project, and the AFL-CIO Technology Institute as the most exciting and strongest bill to protect workers and the AI in the nation. I haven't really delved into that. It's new, so I haven't fully digested it yet, but I can discuss the dystopian work environment bill, which is all-encompassing. I mean, it regulates automated decision-making systems that use machine learning and AI intelligence to make employment-related decisions concerning wages, benefits, compensation, hours, work schedule, performance evaluation, hiring, discipline, promoting, termination. Like I said, it's all-encompassing. It's a great bill that really gets at what we're trying to protect here. I think we're all on board with. It has two procedural requirements. It would give employees the right to dispute the accuracy of worker data that employers are obligated to investigate and correct if it is incorrect. And two, and if an employer relied on an automated decision-making system for termination or discipline, it requires the employer to corroborate that by other means, such as managerial documentation, personnel files. These provisions provide transparency to workers. I think we're all in favor of that. And it could expose potential biases, which is important to protect a workforce that is largely at-will workforce. And it helps the not-at-will workforce, which is often just cause within the union movement, and it helps our union reps to do their job and defend those employees.
So just based on what you said, it seems like your concern more is how the employees are treated at the workplace, or is that your primary concern, which is legitimate, or the fact that AI may or may not replace or displace some workers? What's a higher concern for your organization?
It's tough to pick your favorite child.
Understood.
We don't want to see a mass replacement of workers with AI. We want it to enhance our work. We don't want it to replace our work. And we are very concerned that AI will be used detrimentally to discriminate against people, consumers, workers, everywhere. And we're looking for transparency. accountability, and the ability to know what the data they're using is so that we can expose potential biases within that data. And it's all about transparency. That's why the regulation and all-encompassing bill is so important, because if we do piecemeal, we all know how session works. At the end, some things happen and some things don't, and we'll get to it next session. But AI is coming fast. I recently attended the Labor Innovation Technology Summit out in Las Vegas that was done at the same time as CES, the Consumer Electronics Showcase. AI is here. AI is coming fast. And we need to lead as the state of Connecticut to ensure that we are protecting the folks that we take an oath to protect. And we need to make sure that workers are not left behind in this, consumers are not left behind in this, and that we are a leader, we set an example, and that we show what our Connecticut values are, and that we value our workforce. We want to be transparent with our workforce, we want to be transparent with our consumers, and that we can lead on that subject, because we all know that DC is not going to do this. We need to do this at the state level, and we need to work with other states, just as Senator Mulroney does so well. And we need to set that example and show everyone a path towards a bill that is all-encompassing, that regulates AI in a way that is fair to not only the developers, but also fair to the implementers and fair to the people that are going to be using this technology and the people that are working with it. The workers are going to be using the technology. They deserve a say in how that technology is implemented and how it's used. Thank you.
Seeing no other questions, let it be stated that before the General Law Committee, I think you definitely came down on the side of Senator Maroney's bill over the governor's. We appreciate that.
That's what I got from it.
Well, thank you all, and I'm sure I'll be seeing you again.
I'll see you soon.
Be in 2 weeks.
Bill Finch to be filed by Joseph Asalado.
Chairs Maroney, Lamar, ranking members, Ritigliano and Ciccarella, thank you very much. Happy Valentine's Day. Hopefully you'll get out of here in time to celebrate Valentine's Day, as we all will. I've given written testimony, but I'd just like to highlight a couple of points. And Senator Maroney talked earlier about the brilliance of simple legislation. This bill really is very, very simple. And I would disagree with Mr. Trahan where he said that it's the same bill every year. It's really much different. It's evolved over time. And right now we're poised with looking at a work site where about half the work is done by electricians if this bill were to pass, and half non-electricians. And it's very simple. If it handles electricity, if the part of the job handles electricity, it should be a licensed electrician. In my testimony, as Jerem White also testified, the definition of electricity in Connecticut is extensive. Everything that touches or is touched by electrons requires a licensed electrician, except for solar electricity, which is a mistake. And I have to say, every time I tell family and friends that if you're getting solar on your home, it can be done by people who are not licensed electricians, they're shocked. And then they're even a little bit more shocked when I tell them that I voted for it. And in 2007, I voted for a very large energy bill. This part of the bill, as I remember, had no public disclosure or public hearing. And it did make a lot of confusion. And we think this bill is just going to clean up the confusion and require electrical work to be done by licensed electricians. Pretty simple.
There's a compelling point to the opposition's testimony with respect to this will cost us jobs. Now, you and I have had this conversation in the past, and I think I understand your point is like, right now, there is no pathway to a career. So if you're actually concerned about growing the number of trained, licensed electricians, you'd pass this bill to get rid of this exemption, because that will ultimately lead to more jobs, more high-paying jobs, more career-based jobs, rather than an installer job, which generally does not give you skills to grow in your career.
I'll give you my short answer, because I'm really passionate about the building trades. As mayor, I did about $500 million in project labor agreements, which does favor the unionized trades. Construction is really complicated, and the business model of the building trades is a miracle. If other sectors of the economy did this labor management cooperation, labor and management rarely, if ever, disagree in the building trades, because we all have a building we've got to create, and we have to feed in apprentices to the process and educate them at night. We deduct all of the expenses for healthcare, for retirement, and for education apprenticeships out of our wages and pay for it forward. It's a miracle. The building trades are a miracle that should be replicated in others. And so what we have in Connecticut with the requirement of a license is a credential that we help all the electricians that become apprentices that go through the 5 years of training to learn incredible skills. Asterisk next to that, a PV license is only 2 years. So it's much less. We don't require people who are just doing solar on the roof to have a full license. They can do it with this lighter level license. You're not wiring millstone. We can do that with our license E1s and E2s. PV licenses give a person a mobile credential. If you look at the testimony, you're going to see a number of people who are training to be apprentices right now. And Representative Rutigliano has visited 488 in Monroe. He's seen the men and women working very hard. They work 8 hours a day. They go on a job as an apprentice. They learn as they're doing, and they earn while they're learning. But then at night, 2 nights a week, they're in class. They do 1,000 hours in the classroom. When they're done, they can wire millstone. But if they go for 2 years, they can wire your house. And I know people have said, well, let's have a carve out for residential. Bad idea, because your kids are sleeping right under those solar panels. You want this done by licensed electricians. When I had solar put on my house, I asked my vendor, I wanted to meet the licensed electrician who was going to be in charge of the job. And I think every consumer should be empowered to do that and know that the legislature's not creating this loophole that says all electricity has to be done by a licensed electrician except your solar panels. That's just dumb. That doesn't make any sense. And if I had been paying closer attention, as well as the other 35 senators, this may not have happened. But it did. And I think it's our chance to correct it and put everybody on the same footing. That was my short answer, sorry.
Yeah, it's a heck of a short answer. Are there any questions for Mr. Finch? Seeing none, thank you so much. We have Joseph Acetulio. Acetullo. Okay, I apologize.
No, that's fine. Representative Lamar, Senator Maroney, Representative Rutigliano, and esteemed members of the General Law Committee. My name is Joseph Acetullo, and I am the co-founder of the CT Canna Warriors, High Bazaar, and the president of the New England Craft Cannabis Alliance. I am here before you today to share my personal journey as a caregiver and cultivator, which has driven me to advocate for fair, equitable, and just cannabis laws. In August 2013, I was unjustly targeted and arrested by a statewide narcotics task force. They entered my home with a falsified warrant and arrested me on charges of cannabis cultivation. Over the next 2 years, I attended 42 court appearances, facing 62 years in prison during a trial that put my entire life on hold. But I persevered. I fought back, and I ultimately won the case with the Franks hearing due to the falsified affidavit. Since that day, I've dedicated my life to fighting for fair cannabis laws and against the injustices that continue to affect the cannabis community. Unfortunately, I've watched the state give away the entire cannabis industry to opportunists, people who didn't believe in legalization until it became profitable. Meanwhile, the existing infrastructure, which had been in place before legalization, has been largely ignored and in many ways made even more illegal than before. In years since, I've seen corrupt politicians who voted against legalization, such as Art Linares, be rewarded with social equity licenses. These individuals have prioritized the bottom line, pushing low quality, mass-produced cannabis for the adult use market with no regard for the medical patients who have relied on niche strains and high-quality products. Those patients who have once had access to the medicine they needed are now left behind as profit-driven corporations flood the market with subpar offerings. This bill, which redefines the role of caregivers, provides a solution. It creates a path for individuals to responsibly and accountably grow cannabis for medical card holders much in the same way that Maine's successful caregiver system operates. This system delivers some of the highest quality cannabis on the East Coast, curating rare strains that meet specific needs of patients. It's a model built on It's a model built on relationships between caregivers and patients, where caregivers only grow what patients require, not to make a profit, but to provide quality medical grade medicine. In Connecticut, however, the state has created laws that actively work against the caregivers who are already providing patients with this high-quality flower. These laws put caregivers at risk and force them into a corner where they are treated like criminals for doing nothing more than helping those in their community. The state must embrace the culture of community cannabis, which allows patient access to affordable, safe, and high-quality cannabis. As it stands, the medical cannabis supply is dwindling, leaving patients with limited options and forcing them into long drives to Maine or Massachusetts. Patients across the state are searching dispensaries for the medicine they rely on, only to come to caregivers like us in search of the specific strains they need to manage their health. This bill is not just a policy, it is a form of harm reduction for caregivers and a lifeline for patients. We are in the final year to make decisions and to make changes. At the end of this legislative session, the cannabis market will be codified and all decision-making will be handed over to the Department of Consumer Protection. This would be the final blow to the medical marijuana market. We can already see the numbers shrinking as patients struggle to find products that meet their needs. Maine's caregiver system works because it fosters authentic, personal relationships between caregivers and patients, relationships that ensure patients have access to specific strains and high-quality cannabis they depend on. We cannot allow the medical market to disappear. We must protect caregivers, protect patients, and protect values that made this industry great in the first place. I thank you for your guys' time.
Thank you for your testimony, Joseph. And I really do appreciate your willingness to come here and kind of walk through a number of the issues that we face as a committee, but also as a state, and some of the challenges that we've got in our current marketplace. I think it's really important. I just want to clarify one thing. I know folks feel like this is it. This is our last chance to fix things, and then DCP is in control. That's not how the process would play out. The legislature continues to retain its ability to go back in and legislate and re-legislate any aspect of the program itself. We do give DCP some certain powers and abilities to influence on their own, going through a traditional hearing process and a regulatory review process, but the legislature will ultimately be able to come back in and change rules as we evolve. So I don't want people to think oh my goodness, if we don't get this now, those regulators are the only ones in control. We'll ultimately retain the authority to make adjustments.
And I appreciate you clarifying that. I think more of the urgency is the lack of cannabis for the medical marijuana patients that we're most concerned about. And I think the other concern is that we don't turn a blind eye to it. We help out. We are a community. So we need some kind of path of compliance going forward. We're no longer trying to be, on the wrong side of the fence all the time. We are responsible and accountable citizens of the state, and we'd like to be treated as such. I appreciate you guys.
That was a great close. Good job. Any questions? Thank you. You say none. Thanks again. Thank you. Paul Traglavine. I'm sorry. I don't have my glasses today.
All these vowels and consonants.
Paul Travaglino. I apologize.
Travaglino. Yeah, I would ask the I know. I would ask the good representative from Trumbull. I'd like to say your name Rotiliano. Do you pronounce the G? Okay, we say Travaglino in our family, but just don't call me late for dinner. That's all really that.
When I moved to this country, I moved to Westerly, Rhode Island, which is a very Italian community. So I have no excuse to not get these names right.
I was born on Olive Street in New Haven, so
Oh, okay. So yeah, and I now live in Worcester Square. This is like a political detriment to me that I can't do this right.
I want to thank the chairs and the ranking member and the esteemed members of the committee for the opportunity, the ongoing opportunity for us to come before you to talk about all sorts of things. Today, I'm here to speak in opposition to the CR caps. From an economic standpoint, the Food and Beverage Alliance has the last couple of sessions been able to, we think, positively impact legislation. And when we were part of this discussion last year, it was very much about the out-of-state larger companies that were importing, which they still can do direct to consumer over the internet. We are subject to a supply chain which has us manufacturing those things locally, trafficking them through a wholesaler, and then into a retail environment. And you may not know, but the margins are super slim on this type of product. It's maybe 50 cents a can. You've already seen the testimony of others. That and the dollar tax makes this a product that is impossible for a smaller Connecticut business to compete against these larger out-of-state operators who could really come in and work for market share and almost really no margin just to build. Some of the largest companies that are moving these products through the federal hemp framework are out raising millions of dollars just to kind of stay afloat. Not so with us. We want to build a small business. I just got my food and beverage manufacturer license last week. So we are a small startup with just a couple guys and family people at that. So I thank you for your bilateral participation in this framework. You could do far less, and you are leaning in, and we appreciate that. I just want to associate my remarks with Kirk Cameron. I think Connecticut's a great state. Been here all my life. God bless us. Any questions?
No, I think this is an issue that you guys have done a great job sort of underpinning what the economic concerns are for the business that's established itself here in Connecticut over the last few years. I do think the DCP's concerns are well taken. We understand where they're coming from and the ultimate challenge that we've got in trying to ensure that there isn't incidental ingestion or whatever the concerns are. And I think that's something the committee is taking seriously, but we're also taking seriously sort of the impact this would have on you and the already large cost structure basis that we've placed upon the industry that your competitors aren't confronting at the same level. And this would be an additional point of pain for you guys that your competitors also don't face. So I think that's a fair point.
Thank you. And not to mention our out-of-state competitors, because it is Connecticut being the size state that it is, you can easily drive a few minutes. And
The out-of-state people still, everybody pays.
no, everybody pays $1. I mean, just in terms of they can afford to not make a lot of money on the product for market share. I won't name any names, but there are some very big names in the state right now with large format distribution. I will also tell you my personal, sample of one going around to package stores. Some of them don't want to participate because of the $500 fee. So we may look to help cut that price down by participating with them in the cost of that fee, making it even more difficult for us to run a profitable model. But it would potentially be the only way to do that. So we understand the revenue component of this for the state. We'd like to just engage in ongoing discussions about what really makes sense. And nobody's going to come up here and say protecting children's access is, you'd be a fool to do that. I have kids. But I think we can strike a happy medium. Thank you.
Thank you, Mr. Avellino. Christina Capitan. Close. Come on.
Capitan, you got me.
Perfect.
All right. Thank you for having me here today, Senator Baroni, Representative Ritigliano, Representative Lamar, and I'm sorry, I don't remember his name, I don't have my glasses, but honorable members of the committee. My name is Christina Capitan. I'm a representative of the CT Canna Warriors in the state of Connecticut. We're a grassroots advocacy organization that tries to look out for the best interests of cannabis patients, cannabis consumers as a whole, and the plant in general, just to show some respect to that plant that is life-saving and has helped so many people in our state. So I did send in my written testimony, so I'm not going to read from that. I think I do better when I talk to you from my heart. In the state of Connecticut, I have watched as Connecticut patients have been kind of thrown to the wayside as we legalized recreational adult use cannabis. As I fought for adult use cannabis, I was caring for patients in our state. And I had no intention of seeing them, suffer more after that. So I was pretty disappointed to see that happen. And I know that a lot of those patients or would-be patients had written in for this testimony, very heartfelt testimonies. I encourage you to take another look at some of those. But I'm going to actually read a little bit from a couple of those if I can to give me some inspiration for why I'm here today. My friend Douglas Moore was born with no arms and no legs. He was also born with a gift to grow cannabis plants. So he has been growing cannabis plants for quite a while. He's had 40 successful harvests. He's a patient himself. And what he would like more, 40 successful harvests that have been mold-free on top of that. And what I would like more than anything is for my friend Doug to be able to grow plants organically, safely, and individualize nature for people that he cares for so he can share without feeling like a criminal. People in our state shouldn't be made to feel like criminals just for having a compassionate heart and being able to grow or access a plant that people are in desperate need of, that the state is not adequately meeting their needs. Patients definitely need, I'm here to support HB 5429, the caregiver bill. We appreciate Representative MJ Shannon and his ambitiousness to help the CT Canna Warriors. As many of you know, we've sat in front of this committee for a very long time, and we've come a very long way fighting for respect that this plant deserves and the respect that the community and the people who consume it deserve. I feel that we've gone completely in the wrong direction to help people in our state with cannabis and really just monopolized and profitize off cannabis currently. And that seems to be the biggest concern, as well as enforcement. Enforcement on cannabis is never going to be effective unless you start with education. And I think I've said that many times in front of this committee as well. Cannabis has been illegal. People have had their children ripped away. They've been threatened with spending years and years of their life in prison, and that has not stopped them. So I think as we move forward and you're looking to focus on enforcement and put funding into enforcement, I think you should really think about putting some of that money into outreach and education and helping to positively educate individuals so that people aren't discriminated against and treated unfairly for choosing cannabis. Thank you very much. Happy Valentine's Day.
Thank you, Christina. That was terrific. Any questions for Christina? Seeing none, thank you for the years of testimony that you've helped provide and educate this community on.
Yes, I'm not going anywhere until.
Oh,
we're
I'm certain
done.
you're
You know
not.
that,
Yeah,
right? Okay. Thank you very much.
Bill Garrity, followed by James Brabham. Bill, are you online? No? We'll keep an eye out for Bill along with Frank. James Brabham. I have James in person. Cara Capone.
Good afternoon, everybody. Thanks so much for letting me testify today. My name is Cara Capone. I am the CEO of Community Housing Advocates, a housing organization that oversees both Mercy Housing and Shelter in my sister's place, with services in both Hartford and Middlesex counties. And annually we serve about 4,000 people per year. And so I wanted to talk to you today about my support of HB 6478, an act prohibiting the use of certain software to establish occupancy levels and rental rates for the purpose of increasing landlord and property manager profits. You know, as an organization that houses people who are homeless or about to become homeless, I'm really concerned about the impact of AI on the housing market. Connecticut has the most constrained housing supply in the nation, with only about 7% vacancy rates compared to a national average of about 11%. You know, we had the whole housing committee yesterday, and there's at least 110,000 more housing units that need to be developed to meet growing demand for our state. And this includes people who would be at earning 80% or less of their area median income. So that equates to, in Connecticut, around $116,000 per year or less to qualify for this type of affordable housing. But when you think about stereotypes or you think about conceptions of who uses affordable housing, that really doesn't fit it. It's hard to live in Connecticut. It's a beautiful place to live. A lot of people found out how great it is to live here. And a lot of people moved into the state. And so right now, what we have is a supply and demand issue in Connecticut. There's not enough supply. There's too much demand. We have people who want to move into a home ownership market that are remaining in the housing market. And that puts downward pressure all the way to our folks who are homeless or precariously housed. And so what also happens in regards to housing is that for people who want to change, they can't change apartments. People are getting priced out. We're seeing huge increases in the number of folks who are elderly and disabled or are in families. These are our most vulnerable citizens who were housed and now are new to homelessness because they've been pushed out of the market. And then in the same token, what happens is that people who are in shelter can't get out of shelter. because they can't find affordable or supportive housing. And so they're stuck, and that absolutely log jams the system. You know, when, for example, we have a teacher right now who comes to our day shelter. He's at Denny's overnight and he stays with us during the day and eats with us during the day. He's a retired teacher. He is newly homeless and he was priced out of his apartment. Somebody from out of town purchased his apartment, priced him out. He couldn't afford it anymore. And now we're trying to find housing options for him, but they are slim to none. And there is a direct correlation between homelessness and the lack of affordable housing in communities. I touch upon it in my testimony, which has been submitted. You can certainly see it there. But ultimately what happens is that if we introduce any type of form of AI, it's hard enough already to get people into housing. And, you know, unfortunately, if we're getting AI generated software with some of these very large property management corporations we're already dealing with, our folks get absolutely pushed out and we have very limited options for them. So, you know, once again, I just want to throw my support behind HB 6478, and I'd be happy to take any questions you may have at this time.
Thank you. I really appreciate the perspective on this. I think it's you've seen in newspaper articles throughout today about yesterday's housing committee meetings. There's a similar bill in judiciary about the illegal use of algorithms in determining housing outcomes. This good senator to my left has got a bill that looks at the use of AI in determining rental outcomes for a number of Connecticut residents. I think this is an issue that's gained a lot of attention over the last few years. And so I appreciate putting this into perspective on the ground for your clients and both for your organization about the impacts it's having more broadly in our community. So thank you so much.
Thank you.
Next up, we have Peter Sullivan.
Hi there.
Hello, Peter.
Hey, chairpersons, vice chairpersons, ranking members, and members of the General Law Committee, thank you for the opportunity to testify today in opposition to the proposed section of SB 1235 that would prohibit lottery courier services in Connecticut. My name is Peter Sullivan, and I currently serve as the Senior Vice President of Lottery at DraftKings. Prior to being acquired by DraftKings last May, I was a founder and the CEO of Jackpocket, which was the first licensed and regulated lottery courier service in the United States. Currently, Jackpocket operates in 19 jurisdictions across the country, including New York, New Jersey, Massachusetts, New Hampshire, and Maine. Having built a company that prioritizes customer protection, regulatory compliance, and responsible gaming, I strongly encourage a pause to the process to examine what states like New York and New Jersey have done by regulating lottery courier services rather than prohibiting them entirely. Instead of a rush to prohibit these courier services, the focus should be on setting clear requirements that ensure only responsible, compliant operators that The focus should be on setting clear requirements that ensure only responsible, compliant operators participate in the market. New York and New Jersey have done exactly that, and today the licensed courier services in those states account for approximately 15% of all draw-based ticket sales on a given day. From 2020 to 2023, that newfound capacity helped increase traditional game sales by 27.8% in New Jersey and 11.6% in New York. The success of this model proves that responsible regulation not only protects consumers, but also drives meaningful incremental revenue to the lottery, which is revenue that Connecticut could be capturing instead of eliminating entirely. There's an important distinction between responsible, ethical lottery couriers and rogue operators who do not follow strict consumer standards. Companies like Jackpocket operate transparently, working closely with state lotteries to provide players with a secure, compliant way to participate in the lottery. By virtue of being regulated in both New York and New Jersey, Jackpocket must comply with rigorous evidence-based standards, including age verification, identity verification, geolocation, and responsible gaming tools, as well as strict operational oversight comprising daily reports, annual audits, and internal controls and protocols. These safeguards ensure that players are protected while also helping the lottery grow in a substantial and controlled way. It is important to note that allowing lottery couriers to operate under strict regulations does not conflict with Connecticut's iLottery program. In fact, lottery courier services and iLottery can complement one another, just as different forms of lottery distribution coexist in the retail world. Both in New Hampshire and Washington, D.C., we already demonstrate how iLottery and couriers can serve distinct player preferences while working together towards the same goal, which is increasing revenue for the state. In closing, I strongly encourage a thoughtful examination of the benefits that lottery couriers can bring to the state, rather than trying to solve a problem that doesn't currently exist. Thank you for your time and consideration, and I welcome any questions to the committee.
Thank you for your testimony. I think there's going to be greater exploration in this committee about the online casino peer-to-peer games and more broadly what the courier responsibilities are. There is some concern, it's violative of our compact. There's some concerns about the nature of your business versus other rogue businesses that don't have the same level of regulation and internal controls. But more broadly, DCP has identified it as a concern that is in need of greater exploration. So I think that's what the committee hopes to undertake. So with your help, we'll likely be able to get to the final regulation that is appropriate for the state of Connecticut. And so I appreciate your testimony here today.
Thank you very much.
Are there any questions? Seeing none? No. Duncan Markovich to be followed by Catherine Kavanaugh.
Good afternoon. Chairs Senator Maroney, Representative Lamar, Representative Ritigliano, Senator Ciccarella, and esteemed members of the General Law Committee. I appreciate this opportunity today to share with you my support for HB 5429, SB 154, and my strong opposition for HB 6855, which further undermines Connecticut's responsible hemp and CBD industry. My name is Duncan Markovich, owner and founder of Better Ways in Branford. I use cannabis every day for pain management and nerve damage. I've seen the potential for a robust, thriving, and inclusive regulated cannabis market get consistently restricted to the suffering of small businesses, local communities, and most personally frustrating, the very patients that were supposed to be helped by the legalization of medical marijuana in this state. It is tragic when I must turn away medical patients I once helped in my store. The number, right now, the committee has to make a choice. Either you can help big multi-state corporations by voting for HB 6855, or support small Connecticut businesses, communities, and most importantly, patients in need of care with HB 5429. The numbers show the decline in both our medical and patient populations and sales. It is indicative of two major flaws in the system: hyper gatekeeping and a declining quality that you have already heard from hurt patients. I fear the state of Connecticut will be the first to undo our medical program. The entire point of legalizing this plant is to help suffering individuals, and we are failing. This caregiver bill would bring Connecticut up to date with the same model that other states have seen their economies and communities thrive with. It is known that the well-funded lobbyist mechanism is behind HB 6855. Unfortunately, the supporters of HB 5429 cannot afford to do the same because the ongoing restrictions in the cannabis industry have stifled us and brought us to the edge of losing our businesses, impacting countless Connecticut natives. The entire country has its eyes on us right now, and I hope we're on the right side of history. The mere fact that after this legislative session, more legislative enforcement powers of all things cannabis will shift to the Department of Consumer Protection. This is concerning. That would be like post-prohibition alcohol legislators assigning extra power to the ATF to then regulate and enforce. That is not a democratic check and balance we deserve, and this industry will simply get worse for all if you allow this continued draconian enforcement modality to continue to fester at the core of this industry. Therefore, I propose, before the session ends, that a commission be formed comprised of a board of several rotating legislators, community leader members, and the Office of the Ombudsman to help balance this industry alongside the Department of Consumer Protection. The composition of this commission would then finally be much more faithfully representational of the true needs of patients, caregivers, the community, and our state. Thank you for listening, and I will answer any questions you have.
Thank you for your testimony. I appreciate it. You've been a part of this committee's deliberations for a couple of years as well. Your organization has at least, and that does not go unrecognized. And I want to say thank you for your work and helping us think through some of the challenges and formulating what regulations and what a regulated marketplace would look like. And I've gotten from your testimony and from others that as this has moved forward and evolved, it's held back the concerns of the medical marketplace that you're helping to serve. And I do recognize that both in testimony of yourself and other folks before you, testimony on behalf of the bill in particular, but also the Cannabis Ombudsman and many others who feel like there's shortcomings in the current structure. And so I know this committee is going to look forward to working with you, Representative Shannon, and a whole group of others who want to see reform to the current marketplace. We appreciate it.
Thank you.
Thanks. Senator Ciccarella.
So you have a business
Yes.
and you're also a pharmacist?
So no, I have, in 2019, I opened a hemp CBD store. We have focused solely on education, first and foremost, how this plant interacts with our bodies, the composition of this plant, the importance of a patient or regular user to be able to read and interpret test results, the importance of sourcing, as well as developing strong relationships of community trust, that this plant is built within the community. And much of that is focused on making sure that somebody is educated, making the best decisions for themselves, ensuring safety from the youth, advocating that there are legal infrastructure to make sure that the youth are not harmed, but as well as the youth are educated just as much as they would be with alcohol or other drugs as well. So I have tried my earnest to build a living by providing non-intoxicating cannabis products. And then from that point, if somebody needed something in the higher THC realm, then making recommendations of where they could legally, find that. The problem is, as things have rolled out, there have been much more restrictions against the hemp and CBD industry. We've talked about that ad nauseum.
Yeah.
But now more so, it's in the beginning of recreational sales in 2022. Almost immediately, the medical patients from the dispensary down the street from me were coming to me. There's lines, there's new staff, they don't know what I need. They tell me, we don't have what you need. You need to go do the research. So they would come to me and say, how can you fill the gap? As of recent regulations, I am now no longer able to fill that gap.
I understand.
So this is rapidly deteriorating.
Well, I really appreciate your testimony here today. And I do appreciate you coming up.
Yeah, thank you for the question.
Thank you again, Doug.
Thank you, gentlemen.
Catherine Kavanaugh, followed by Jackie Latinsky. Excellent. Jackie Latinsky, followed by Alejandro Toro Perdomo.
Good afternoon, Chairman Maroney and Lamar, and ranking members Ciccarella and Ritigliano, and distinguished members of the General Law Committee. Thank you for the opportunity to offer comments today in opposition to Senate Bill 1236, an act concerning solar licensing exemptions. My name is Jackie Latinsky. I am an energy policy and data analyst for Sunnova Energy Corporation. Sunnova is one of the country's largest residential solar and storage service providers and is active across the U.S. and its territories. Our Connecticut operations include a network of small business home solar dealers and installers. Sunnova's customer contracts run for 25 years. We build long-term relationships with our customers, and we believe honesty, transparency, safety, and a well-trained and skilled workforce is a foundation for these relationships. As a national company, we are committed to meeting the highest standards in industry best practices for the sales, installation, and operation of residential solar systems. In Connecticut, training and certification standards are already very high for residential solar installations. All of our dealers and installers comply with these existing regulations and have the proper certification to perform the various aspects of the installation of a rooftop solar system. Our technicians are fully licensed and certified to address the ongoing maintenance of the solar panels, batteries, and accompanying components. SB 1236 would further limit exemptions to certain licensing requirements, which we believe is both unnecessary and likely damaging to our industry. The current regulations in Connecticut are more than adequate to protect workers and solar customers in the state. We agree with the current rule that only licensed electricians possessing at least an E1 license be involved in the interconnection work with residential solar systems. As even this bill acknowledges, though, there are aspects of the installation of a rooftop solar system that do not involve nor require a person to be an electrician, work which many licensed electricians in our experience have no interest in doing. As you all know, there's a great deal of uncertainty facing the solar industry right now. While Connecticut remains committed to renewable energy, federal energy policy, trade policy, and manufacturing are all in flux. Asking independent solar installation companies and even individuals to pursue expensive and sometimes redundant licenses will do significant harm to the solar industry, our workers, customers, and renewable energy in Connecticut, especially when these proposed changes are trying to solve a problem that doesn't exist. Sunnova supports regulations that improve the safety of customers and installers, rules to ensure that equipment works correctly, and that systems are properly installed and interconnected. SB 1236 would not improve any of these things and would harm Connecticut workers and small businesses. On behalf of Sunnova, I appreciate the opportunity to testify and work with this committee. Thank you. I'm happy to answer any questions.
Thank you, Jackie, for your testimony here today. We've had some good back and forth, I think, over the years on this issue. Generally, it plays out where compelling points are made on both sides, and we end up in a back room trying to figure out what the right answer is. I don't know how it's going to play out this year, but I imagine we might be talking more to you as the session progresses.
Yes, please feel free
Thanks
to
again.
reach out. Thank you.
Alejandro Toro Perdomo. Alejandro, are you online? I don't think so. And I nailed that name. Terry Hopper. Followed by Brian Williams.
Thank you, all members of the committee. I'll just skip the pronunciation tightrope there. And my name is Terry Hopper. I'm a 69-year-old resident of Hampton, and I host a program on WPK in Bridgeport for the past 30 years. But I'm also a cannabis medicine patient. I have epilepsy, and I also have anxiety and PTSD from a near fatal attack. But anyway, when we first started having the seizures, the first couple of pharmaceutical medicines really didn't work, and they had really bad side effects like personality changes, and it was horrible. And then finally we found Lantin, which decreased my seizures a lot. Then I got into the medical program, and they decreased a little more. Though touching on an earlier subject, I do have to say I've returned my medicine from the Connecticut program many times for mold or for being clearly under the stated weight of the package which we were supposed to receive. But then anyway, Providence kind of steered me towards some caregivers. And as of January, I'm 8 years seizure free now, completely, only because I was getting knowledgeably grown cannabis, without mold. And I question whether it's even possible to grow 100,000 plants really well, radiating them afterwards. I think the small grower model is a much better way. People can grow with care and attention. But I also say you might be missing out on another economic opportunity, because we have microbreweries and craft beer fairs, with like niche kind of brews and stuff. And that's quite a popular thing. And I think the farmers of Connecticut are second to none. And we could be a Napa Valley of cannabis too, if we look at it from that position too, and to really celebrate the master growers that we could have here. But in any case, I hope you'll move towards the caregiver model. I think that's really a much better way to deal with it. I had to go through so many different kinds to find the kind that would actually work for me. And like I said, certain niche strains may not be viable for mass production or mass product, might not be profitable that way. So just let smaller people just specialize. I think that would work better. And anyway, thank you for hearing me. And I have to say, I'm very proud to be a citizen of Connecticut at this time in our nation's history. I tell you, it gives me hope. Thank you.
Thank you for your testimony, Terry. We have Brian Williams to be followed by Dennis McBride. Both online, if we see them. All right, we're not seeing Brian. Dennis, the floor is yours.
Thank you. Good afternoon, esteemed members of the General Law Committee. My name is DJ McBride, not Dennis, DJ. And I'm here today to speak on SB 1249, an act addressing innovations in artificial intelligence. I'll explain my support of this bill through a use case. In my free time, I volunteer to help the Glastonbury government. I believe it's important to give back to your community, and I'm sure many of you can understand this, as you're not listening to me right now for the great pay. Last week, our town manager asked me to build a report about our animal shelter. He wanted to know how many dogs were in the shelter for each day over a 3-year period. He wanted to know how many days one kennel was in use, 2 kennels were in use, and so forth. He wanted to be able to select a single day and know what dogs were in the shelter and how many days they had been there. He also wanted to have the average length of each stay and to highlight edge cases. In other words, which dogs stayed over 200 days. To manually do this, someone would need to take a calendar and go through all 1,095 days, tracking which dogs were in the shelter on that day. ChatGPT estimated a 40-hour work effort to complete this. But I'm a programmer, and I can write programs to do this. Normally, a program to do this would take me about 4 hours to build, test, and debug. That is a 10-fold increase in efficiency. Well, with modern AI tools, I was able to take that same task and build it in about 15 minutes, another 10-fold increase in efficiency. It took more time to put all the data into a PDF than it took to actually gather the data. And that's why I support this bill. AI tools are the next leap in efficiency. One issue that Connecticut suffers is brain drain to large cities like Boston or Atlanta. Indeed, if I were not able to work remotely, I couldn't live here. People move to where the jobs are. Alec McGillis covered this in his book called Fulfillment, Winning and Losing in One-Click America. We're not going to get companies like Google or Meta to move to Hartford. All the tax incentives in the world wouldn't change that. But we can create the next Google. We can create the next Meta. SB 1249 gives us the opportunity to do this, and it gives us a chance to be a leader in the AI space. Thank you.
Great. Thank you very much. Are there any questions? I think you did bring up an important use case is government use of AI, making it more efficient the way we interact with our constituents. I would just let you know that we do have a bill coming up that solicits pilot programs and attempts to try to work to help implement AI into our government use.
I think that's a great idea.
Great. Thank you. Okay. Hearing no questions, thank you very much. Next, Charles Michael White. Online.
Hi, yes, I'm here.
Great. Please proceed.
So I wanted to talk about Connecticut Bill HB 06855 as it relates to other substances of abuse. I think the bill is overall really good. I think that it should be amended, though, to remove Mitragyna speciosa in lines 223 and 224 on pages 8 and 9. On line 220 on page 8, it should be expanded past just 7-hydroxymitragynine to say that it would be when its total alkaloids exceed 2%, but also include mitragynine pseudoindoxyl or any other semi-synthetic or synthetic kratom alkaloid. Michael White, a distinguished professor and chair of pharmacy practice at the University of Connecticut School of Pharmacy in Storrs, Connecticut. I'm not representing the University of Connecticut in my testimony today. I've written extensively about kratom, the dried leaves of the Mitragyna speciosa tree, since 2018, and I chair the Kratom Consumer Advisory Council, which is a national advisory council made up of a clinician scientist, which is me, and then consumer volunteers who have either been helped or harmed by kratom. I've personally heard hundreds of compelling consumer testimonies where whole leaf kratom products or mitragynine extracts have allowed people addicted to opioids to stop snorting or injecting illicit opioids, to hold down a job, and to care for their loved ones. I've heard from people with intractable pain syndromes being able to regain their ability to function. Observational and descriptive studies have shown that the risk of stopping breathing is much less, the risk of sharing needles goes down, and that people are better able to carry out functions of daily living using kratom rather than their illicit opioids they were using before. There's more than 80,000 deaths a year for opioid overdoses in the country, and while there are FDA-approved treatment options for opioid use disorder and for debilitating pain, they're not accessible to everyone, and others have tried available options but without success and have been left with only this option. We've seen attempts in the past to combat the opioid epidemic by abruptly stopping prescriptions for chronic opioid users and adding tamper-resistant technology to prevent people from snorting or injecting them. But the result has not been a reduction in opioid deaths, but more people turning toward heroin and fentanyl-laced illicit and counterfeit opioids. Taking away whole leaf kratom and mitragynine extracts will undoubtedly turn people who have gotten their lives back to start using illicit opioids again. Whole leaf kratom and mitragynine extracts are not risk-free, and they do need to be regulated. The Kratom Consumer Advisory Council created 4 position statements where we identified best practices to regulate the kratom marketplace, including no sales to individuals under 21 years of age, no sales of candy formulations, no mascots that appeal to children, no semi-synthetic or synthetic alkaloids, proper labeling, and prospective regulation and testing of products. These best practices are included in Colorado Bill SB 25-072. If whole leaf kratom and mitragynine extract products were removed from Connecticut HB 06855, I would happily work with legislators to craft a Kratom Consumer Protection Act that would balance access with safety for the people in Connecticut. Thank you.
Thank you very much. I just looked online and I did not see your written testimony yet. Have you submitted your written testimony?
No.
Would you mind just sending that? I would like to look over your suggested red lines and then I'll reach back out to you.
Sure, definitely.
Great. Thank you very much. All right. Are there any questions from the committee? Okay. Hearing none. Thank you again for taking the time to come speak to us today. Next, Olivia Rinkus.
Thank you so much. Good afternoon, and thank you to the General Law Committee for the opportunity to testify. My name is Olivia Rinkus. I'm from the town of North Stonington and also an undergrad at the University of Connecticut studying political and cognitive sciences. I'm testifying today first in strong support of HB 5429, an act concerning caregivers, qualifying patients, and the palliative use of cannabis. Connecticut has taken the first steps of recognizing that the criminalization of cannabis has been detrimental to individuals and communities. We began this process by legalizing cannabis, but by letting corporate greed take priority over rectifying the harms of the war on drugs, cannabis patients have been locked out of the industry that their medical needs and advocacy helped to shape. Legalized cannabis should not look like medical patients unable to access their medicine, caregivers arrested for sharing a plant that is now legal, increased amounts of mold in commercial cannabis while home growers can't even afford to test their own supply, and individuals with cannabis convictions still on their records while corporate growers and dispensaries profit from the plant that they were arrested for. I appreciate Connecticut taking steps to make the medical market more accessible to patients by enabling skilled growers to provide for individuals who do not have the space, resources, or knowledge to produce on their own, and by reducing the legal risks to caregivers who are providing what is now recognized as legal and medicinal. I ask legislators to please pass HB 5429 out of committee and into law. I would also like to quickly add my testimony in support of SB 1249, an act addressing innovations in artificial intelligence. As a consumer and a citizen, I understand that businesses utilizing artificial intelligence may feel stifled at the prospect of regulations being placed on this industry, and that there's a great amount of potential and momentum in artificial intelligence at the moment. However, I fully support legislators in Connecticut acting to create a set of regulations that will prevent this technology from being used in ways that can be harmful or discriminatory. Artificial intelligence can not only discriminate in its responses to white users versus Black or brown users, it can also infringe upon constitutional or civil rights in a variety of ways, such as the use of AI technology in traffic cameras or other public areas, and the issues of surveillance, discrimination, or false accusations that may occur because of this, environmental impacts, infringement of workers' rights, privacy concerns regarding the storage of data, and also the potential for HIPAA violations for stored medical data, copyright infringement, or other theft of intellectual property for AI training purposes, among others. With all of these potential risks of harm coming to private individuals through the use of artificial intelligence without regulations in place, I strongly support this bill and thank legislators for beginning this discussion of how to reduce these risks. Thank you again for the opportunity to testify.
Great. Thank you very much, Olivia. Are there any questions? Not, thank you for coming to testify today. Next, Tom O'Hearn.
Hello. Hello, Chairperson and member of the committee. Thanks for the opportunity to testify today. My name's Tom O'Hearn. I began my career in the solar industry in 2011. Now I act as the head of operations at Venture Solar. We're a solar company that we've done about 2,000 installs across Connecticut, and we employ 50 people in the state of Connecticut. I'm here today to express my deep concern about SB 1236 and its unintended consequences for our industry, the workers, and Connecticut families. So I have 3 points that I'd like to make. The first one that I'd like to make is that these proposed licensing requirements will destabilize the CT solar industry. So we currently have 2 licensed electricians and an apprentice on every installation site. We also have an additional 2 skilled installers who assist in the work related to installing the structural racking and helping to move heavy equipment around the site. We actively move people from the installer position to the electrical apprentice position when we're able to. Unfortunately, we're strained by having to balance the strict licensing ratios with our ability to provide cost-effective installations for homeowners. If I could somehow have 5 license holders on site and do it at the same price for homeowners, I absolutely would. It is currently very difficult to hire licensed electricians. This bill would actually cause us to have to let go 7 employees and tremendously slow down our ability to install solar systems for CT families. I'd also like to address a point that was made in an earlier testimony, that there's non-licensed people installing electrical components on installations. The parts of the installation that this exemption allows are structural components of the system and providing additional hands that are required to properly move large equipment around the site safely. The second point that I would like to make is that Connecticut families and small business owners are going to bear the brunt of this bill. Higher labor costs and longer installation timelines, it's going to translate into higher prices for ratepayers. And so CT already struggles with energy affordability, as noted in Governor Lamont's State of the State address. So solar energy is cost competitiveness is its greatest asset. SB 1236 jeopardizes this by adding bureaucratic layers. Families and small businesses will pay more, slowing our state's clean energy transition. The third point I'd like to make is that I'm personally a very big proponent of proper training, continued education, and site supervision. I would love to see Connecticut roll out a licensing structure that makes sense for solar installation professionals performing the job's general construction aspects. We internally do a significant amount of training with both our licensed and unlicensed team members to stay up to date with the latest equipment, the best practices, and most importantly, safety. I would recommend the community look at an organization like NABCEP, which is like the North American Board of Certified Energy Practitioners, as an example of what this could look like. So, in short, while I believe that SB 1236 is well-intentioned, I think it threatens Connecticut's solar industry, the livelihood of skilled workers, 7 people that are very close to me, and Connecticut's families' access to affordable energy. So I urge the committee, please reject the bill the way it's currently written and work with industry experts to develop, CT solar industry in a way that makes sense for everybody. Thank you for your time.
Great. Thank you. Are there any questions from the committee? Okay, hearing none. Thank you for taking the time to come testify before us today.
Thank you.
Next, Robert Porter.
Members of the committee, thank you so much for your time today. We really appreciate your dedication. My name is Rob Porter. I'm the Chief Legal Officer of Lotto.com, and I'm here today to oppose the lottery courier ban that was included in Senate Bill 1235. So by way of background, I've spent most of my career in public service. I was an assistant attorney general in my home state of Iowa for several years. I spent several more years as vice president and general counsel of the Iowa Lottery. My work for the Iowa Lottery actually won an international award for gambling compliance. And because of that, I'm a strong supporter of consumer protections, but the provisions in Senate Bill 1235 are a solution looking for a problem. You've heard a little bit about couriers in Pete Sullivan's testimony earlier today. Lottery couriers aren't a new thing. They've operated in the United States for several years now. We're not a small thing. Actually, 1 in every 3 U.S. lotteries are supported by couriers. But you haven't heard much about what couriers do. Lottery couriers are essentially the Uber Eats of the lottery industry. Uber Eats isn't a restaurant. They don't hold a license to prepare food. Uber Eats takes an order from a hungry person. They go to the restaurant, they get the food from the restaurant, and they deliver that food the last mile. That's exactly what lottery couriers do. Lottery couriers allow adults who are physically located in the state to place an order to get an official state lottery ticket. Couriers then purchase those tickets in cash at licensed retail locations, and they deliver those tickets electronically to customers. Couriers operate all across the country, including in states that have their own iLottery platforms like Connecticut. We do this with integrity. We have systems designed to protect against sales to minors, to ensure that only adults can place orders on our system. We have geolocation to ensure that there are no orders placed in the state. If you tried to log on to Lotto.com now, we're not live in Connecticut. You wouldn't be able to order in any state we are live because the geolocation wouldn't allow you to. We also are dedicated to responsible play. We have default daily, weekly, and monthly limits that we don't allow customers to exceed, but customers can always lower them, or they can exclude themselves from the platform altogether. And if we see data that suggests a deviation from a customer's pattern, they start playing significantly more than they used to, we will notice and we will reach out to them because it's our responsibility to ensure responsible play. We will intervene, and we can do that in a way that you can't with purchases at retail. So in this way, couriers are able to reach non-traditional lottery customers. The folks that we reach get their prescriptions delivered online. They get their groceries delivered. They order things off Amazon. They aren't always ordering lottery tickets today. We purposely try to reach those individuals to bring them into the lottery ecosystem, to have them be responsible participants. I will just close by saying, if you're looking for the prospect of regulation, we would fully support that. The Colorado Lottery Commission has administrative rules right now that are pending to regulate couriers, and they'd be a great model.
Great. Thank you for pointing to something to look at Colorado. So just for clarification, I guess, to help us. So you deliver the tickets electronically, I think
Yes,
you
sir.
stated. So is it more than just the draw games that people can order? Could they order scratch-offs from you as well?
It
And is
depends
that the issue?
It depends on the laws of the state in question. We do have a mechanism to securely deliver scratch tickets as well. That's not live in every state. Not every state is ready for that. And so we always defer to the direction of the state lottery on what products are allowed in that given state.
Okay, so in Connecticut, you're not currently operating, is that
No,
what you
sir.
said? Okay. And then obviously if this passed, then you would not be operating. But
Yes, sir.
so in Connecticut, if you operated, it would only be for draw games and not for scratch?
If the lottery directs us to do draw games only, we will do draw games only. If the lottery directed us for consumer protection to only accept debit cards, we would only accept debit cards. We depend on and turn to the lottery to tell us what's the best thing for your state.
Okay, great, thank you. And again, you pointed to Colorado to look at their regulations.
Yes,
So,
sir.
okay, thank you. Are there any other questions from the committee? No, thank you for hanging around
Thank you.
and for testifying. Okay, next, Vahid Bezadon.
Good afternoon, Senator Maroney, members of the General Law Committee, and thank you for allowing me the time to speak in strong support of Bill number 1249, an act addressing innovations in artificial intelligence. I'm an assistant professor of computer science and data science at the University of New Haven, where I also direct a research lab called Secure and Assured Intelligent Learning, focusing on AI safety and security research. I also had the pleasure of being a member of the Connecticut Legislative Task Force to study AI in 2023-2024. And I have also actively been involved in efforts to establish the soon-to-be-launched Connecticut AI Alliance, which is a collaborative initiative bringing together over 9 universities, key industry partners, and community organizations to create a nexus for AI research, workforce training, business development, and policy guidance in the state. Bill number 1249 represents a forward-thinking approach to harnessing the benefits of AI while ensuring responsible innovation. In particular, the creation of 2 new staff positions within the DECD, Department of Economic and Community Development, to coordinate AI efforts across higher education aligns well with the core mission of the Connecticut AI Alliance. With numerous academic institutions, businesses, and advocacy groups already committed to the Alliance, there's a pressing need for structured coordination across Connecticut to foster an AI ecosystem that is greater than the sum of its individual components. Also, our discussions with industry and academic partners have highlighted the need for structured support mechanisms, such as AI-focused accelerators in verticals like biotech, life sciences, finance, and advanced manufacturing, in order to enable AI entrepreneurs and small businesses to thrive. The establishment of the AI and Quantum Technology Investment Fund under this bill is a critical step in that direction, providing much needed funding to nurture Connecticut's AI-driven innovation economy. Connecticut has a unique opportunity to position itself as a leader in AI innovation, governance, and economic development. This bill lays the groundwork for a cohesive strategy that promotes responsible AI adoption, strengthens our workforce, and ensures that Connecticut remains at the forefront of AI-driven economic growth. I appreciate your consideration of this important issue and urge the committee to advance Bill number 1249. Thank you for your time. Happy to answer any questions.
Hi, Vahid, thank you very much. And thank you, it was great working with you on the AI task force. For people listening, we actually had 2 years of AI task forces in Connecticut, contrary to an op-ed that said that Connecticut should just run an AI task force. Unfortunately, that professor didn't do his research and realized that we had run extensive task forces in Connecticut. But Vahid, thank you for your work on the Connecticut AI Alliance. SB2 will be coming back. We are actually looking to partner with the AI Alliance to help the state, as part of that bill, to help the state create a state tech plan. Because as you mentioned, it's universities and industry. It's important that going forward, we maintain that conversation. We formalize a way for industries, academia, and government to communicate. Now, what would your thoughts be on creating some form of a Connecticut AI Safety Institute?
Well, the institute, I suspect, will be responsible for research on not just the technical aspect, but the policy aspect, and then would probably end up hosting the regulatory sandbox that has been talked about in various contexts. However, AI safety on its own, while it's my main area of research, cannot be performed outside the context of a more fundamental as well as applied research. If we are thinking about establishing an AI Safety Institute and we are planning on budgeting for that, why don't we think a little bigger and aim for an AI Research Institute in general to support various aspects of R&D in the AI domain?
Yeah, and thank you. That actually, I like that idea to think bigger. I was recently at a conference where University of South Florida has created an applied engineering institute where they solve problems for industry. So mimicking that, perhaps creating a Connecticut Applied AI Institute where we could have industry working with academia to solve problems. So, well, thank you, Vahid, for taking the time to testify today. Are there any other questions?
Thank you, Senator.
And hopefully we'll see you back in 2 weeks when SB2 should be out next week.
Looking forward to it. Thank you, Senator.
Thank you. Next, Ronald Harichandran.
Hello, Senator Maroney and other senators and members of the General Law Committee. My name is Ron Harichandran, and I'm the Dean of Engineering and the Vice Provost for Research at the University of New Haven. I am testifying on behalf of Senate Bill 1249. There is a dire need for state investment in AI, given the rapid development in this technology that will have a profound impact on the state's economy. There is also a need for the state to effectively regulate the ethical use of AI without being overly zealous so as to stifle innovation. I want to point out that AI and quantum computing technologies are different, but are often confused as being the same. AI is here now and is driven by existing computing technologies. Quantum is a new computing technology that offers tremendous promise, but will likely take a decade to become mainstream. And if it does, it will indeed enable more powerful AI algorithms. I support the state's investment to add expertise in AI to DECD so that they can effectively coordinate statewide initiatives and efforts related to AI. I also support the establishment of the AI and Quantum Technology Investment Fund to support companies in the state that develop these technologies. Finally, I want to reinforce the Connecticut AI Alliance that my colleague who testified just before me alluded to. So far, 10 higher educational institutions and a few major nonprofits in the states have asked to be a part of this alliance, and we expect more to sign up. The alliance is intended to bring together experts from academia, nonprofits, government, and the private sector to advise the state on AI education, workforce development, research, regulation, and so on, and to also undertake some of that work. Thank you for the opportunity to testify at this hearing. I'd be happy to answer any questions that you may have.
Great. Thank you very much. Thank you very much, Dean Harichandran. Does anyone have any questions? I just have one question. You may not be able to answer it. One of the concerns, again, it's not something we've brought up, not something we're looking in legislation in this committee, but around the country, there's a lot of concern about the power and resource consumption from AI. As we move to, quantum, again, you point out it's a decade, right, before it becomes practical, maybe more. But That will expand the compute power by an order of magnitude. But what does it do then to the power consumption?
Yeah, I'm not an expert in that area in terms of the power consumption of these computational resources, but I know at least with the current technologies, it is a concern. It was, I think, there was a story on NPR this morning about that. So yes, as we embrace AI and use it very broadly across all the constituents that in the state, those energy consumption will go up. So that's a given. So we'll have to deal with that because I think the way I see it, AI is in some sense an unstoppable force, and we will just have to feed it the resources that it needs.
Okay, great. Thank you very much. Are there any other questions? Okay, hearing none. Next, Brian Candelora.
Members of the committee, my name is Brian Candelora, but you can call me Candelaria, because I think I like Juan more than the other guy. Many entered these chambers today and spoke on numbers and data. I would like to share a story with you in support of my lived experience for HB 5429. I began smoking cannabis at the age of 18. And since you may not be able to see the gray in my beard from where you sit, I can assure you that was a very, very long time ago. Within a few years of consuming the plant, my love for the plant led me to growing my first cannabis plant in a modified Foot Locker in my basement. During this time, I sought out all the resources I could possibly find and everything I could do to make this plant the best it could be. I was introduced to an older gentleman who regaled me with his stories of growing 100+ plants in his basement back in his prime. When I asked the gentleman what advice he would give to a new grower like me, he didn't say anything about the soil or the air quality. He told me I used to play my guitar and sing to my plants every night. I believe it made them happy and helped them grow. But more importantly, it was time I spent loving on my plants. I think about this often when comparing these massive grow operations that we have providing Connecticut dispensaries with their cannabis against the backyard growers I have always gone to and will always continue to go to when I want the best quality cannabis available. Nobody will ever convince me thousands of plants will turn out with the same quality as a handful of plants an old hippie just loves hanging out with and meticulously grew. I share this story with you to challenge you to not only allow for caregivers to grow for their patients, but to do so with minimal oversight so you don't drive costs through the roof with insane licensing fees. Cannabis has been around and thriving for a long time, despite prohibition. So my recommendations to you are that you meet the community where it is, because we have never been willing to play by your rules anyway. So it's time that you guys come and meet us where we are. I'd like to thank you for your time. I'd like to wish you a happy Valentine's Day and open myself up for any questions.
Great. Thank you very much. And thanks for staying. We know it's a long day, so we appreciate you hanging in there with us. Does anyone have any questions? Doppelganger, Rep Candelaria over there, or name twin, not
No,
doppelganger.
the other thing I wanted to say is that we hear you. That's all I wanted to say. We're listening and we understand the challenges that your guys are facing. So
I appreciate it.
definitely going to continue this discussion.
Yeah, the market we're talking about, a lot of people have talked about the illegal market. It is thriving. It is absolutely thriving, and it is beating the snot out of the legal industry right now. So it's time that we open this up and we allow for those people to do so legally, ethically, and responsibly, and to fill the deep, deep void we have in our system. Thank you.
Great. Thank you very much. Next. Oh. All right. Yes, yeah, please. Rep Osborne.
Thank you very much. Oh, he's gone. Never mind. That's okay. That's all right. I'll get it from another. Let's get.
I'm sorry. All right, next, Molly Adler.
Good afternoon, Senator Maroney, Representative Lamar, and members of the committee. Thank you for allowing me the opportunity to testify before you today. My name is Molly Adler, and I'm here in support of Bill number 154, allowing cottage food operators to sell products at any farm store or cafe located within a 20-mile radius. As a small cottage food operator based in Connecticut, I began my cottage food operation in New York before relocating to Connecticut 3 years ago. I'm enthusiastic about Connecticut's efforts to amend its laws, particularly concerning Bill 154, which will enable me to expand my products into cafes. I believe this is a significant step toward fostering the growth and success of small businesses, allowing them to flourish and reach a broader audience. This change not only supports entrepreneurs like myself, but also encourages innovation and diversity in the marketplace. By providing more opportunities for small businesses to showcase their products, Connecticut is creating a more vibrant and dynamic local economy. Since my move from New York, I have found that the cottage food laws in Connecticut have severely limited my sales and opportunities to just farmers markets, festivals, and fairs. I would like to discuss how my business operated in New York. During my time there, I had the opportunity to sell my products through various channels, by both wholesale and retail. These included restaurants, cafes, grocery stores, bagel shops, theaters, gourmet markets, farm stands, farmers markets, as well as home delivery and online mail order shipping. All of this was done without a revenue cap, and I was on a path toward establishing a brick and mortar operation. I raised these issues to highlight how the limitations on marketing channels in Connecticut for my small business have adversely affected its growth. Being confined to farmers markets and events, particularly during these winter months, when such markets and events are scarce, has significantly hindered my operations. Additionally, the lack of wholesale and shipping options has brought my business to a complete standstill. Consequently, I find myself in a position where I'm seeking external employment rather than focusing on expanding my business, which would contribute positively to the economy in Connecticut. Moving forward, there are some additional changes that I would like to see implemented along with this bill. I propose eliminating the revenue cap and expanding wholesale opportunities beyond cafes, as well as implementing shipping options. I believe that introducing a tiered system for cottage food operators would facilitate these changes effectively. Each cottage food business reaches a natural point at which it must transition into a commercial space, and this transition varies for each business. I believe these proposed changes would enable cottage food businesses to identify the optimal time for such a transition, thereby preventing premature shifts that could hinder their growth and stability. I'm excited to see how these legislative advancements will pave the way for future business ventures and contribute to a thriving entrepreneurial ecosystem in the state. I appreciate your time and allowing me to share my opinions.
Thank you very much. And you mentioned you were in New York State previously. Would you be able to send I guess, well, I could look them up. I'll look up the New York legislation, but have you submitted written testimony?
No, but I can.
Yeah. Please email your testimony to the clerk. So thank you
Sure.
very much.
Thank you.
You're welcome. Are there any other questions? Okay, hearing none. Have a nice day.
Thank you.
Next up, Kyle Wallace.
Right. Thank you, Chairman Maroney, Lamar, members of the committee, for allowing me to testify. I'm Kyle Wallace. I'm the VP of Public Policy for Posgen. We're a residential solar and energy efficiency provider. 2025 will mark our 10th year in Connecticut since we first entered to the state through a partnership with the Connecticut Green Bank. And what sets us apart is we help serve low and moderate income households and underserved communities more generally. In 2024, 55% of our customers were in economically distressed municipalities or low income or both. And 100% of our battery customers were low income. one of the ways we do that is through partnerships with municipalities. We do Solar for All campaigns. We've done a few in the last 2 years with Hartford, with New Haven, with Danbury currently. And so that's one way we try to reach those underserved communities. And the way that we do that is to serve those underserved communities is we need to provide meaningful savings. And we do that by keeping our prices low and our costs low. And one of the biggest costs that we can help control is our operational costs. And so as you've heard from others, the change to this exemption for the Senate Bill 1236 would be, it would disrupt that cost, and it would make it more expensive for us to do installations, which would impact the savings we're able to provide. And I know you've heard a lot of testimony on this already, so we'll try not to cover the same points, but I do just want to address briefly that the kind of career path, there's been framed this kind of dichotomy of you can become, if you're an apprentice, that's a career path. If you're an installer, that's not a career path. And I think that's not the right way to think about this. We have apprentices on staff, and most of those apprentices come from our installers. They started as an installer, they move to an apprentice, they become a journeyman electrician. That's the one of the career paths that we see. And those installers are making roughly $30 an hour, 60-ish thousand a year. So it's a good starting place, and there's room for advancement within the company and the operation. So I really think we need to think about all of the different pathways folks can take to get into the trades, to get into solar. And I don't know why we'd want to close that off by limiting this installer exemption even further. One other point is just to reiterate that on the jobs today, there's already licensed electricians doing all of the work that is the electrical work on the inverter, the metering, interconnecting to the home, all of the wiring and conduit. All of that has to be done by electricians and apprentices. We're really talking about a very narrow set of activities that's taking place on the roof, of moving the panels up there and anchoring them to the racking system. And then finally, on the PV license, there's mentioned that there hasn't been uptake in that license, and the main reason why it's not because of the installers. The reason why is PV license allows you to do, or let's put it this way: a solar install requires, let's say, 10 tasks. An electrician's license, you can do all those tasks. If you have a PV license, you can only do 8 of those tasks. So there's some tasks that even if you have that license, you need to get an electrician to do. So as a business, you're not going to use a PV license if you can avoid it, because you still need to bring an electrician on anyways. So it's really, that's the flaw in why that license is not taken off. It's not because of the use of the installers on these jobs doing the non-electrical work.
Great. Thank you very much. Are there any questions? So thank you for coming today. We will have a bill coming up that on consumer protections for solar. So I'm assuming we'll see you again, and look forward to getting your input on that bill as well.
Absolutely. Thank you very much.
Thank you. Okay, next, Cassidy Irwin.
Cassidy, you are muted.
Sorry, I always seem to have trouble with the Zooms. My name is Cassidy, and I'm here to support House Bill 5429 today. And I strongly hope by the end of my testimony, I can sway you all to agree with me. We are currently in violation of federal law. It's called the Sherman Act of 1890. The Sherman Act was established so local governments could not create monopolies around products. Violations of these laws include rigged bidding. So someone per se going on the news and waiving their credentials and being awarded a license would be a violation of this federal law. So I believe the only remedy is to open up the market to everyone who wants to be in it, to be completely honest with you. Individuals can be fined up to $1 million and imprisoned for 10 years for violation of this law. Corporations can be fined up to $100 million. In addition to these criminal penalties, the community can file civil lawsuits against the state. So everyone who was adversely affected by your hemp laws and things like that has every right to file civil suit against you. You guys have done this on the news. There was a person complaining about not getting a license and having a master's in business, and you guys awarded him a lottery winning ticket. That is a violation of a federal statute that protects us against monopolies. So I strongly implore that you guys consider allowing everybody who wants an equal footing in this market opportunity, rather than penalizing them when you're the one breaking multiple federal laws. Thank you for your time.
Great. Thank you. Are there any questions? Okay, hearing none. Thank you again for hanging in all day and testifying. Thank you for your testimony. Next, Ivelisse Correa Brown.
Hello. Thank you for the committee for allowing me to speak today. I'd first like to speak on, I'm speaking on two bills actually. I'd like to begin by saying that DCP has no stakeholders at the table. Users of cannabis should be the ones leading and shaping policy so that we don't have the highest mold and mildew limits in our countries. Or let me start over. I'm sorry, I'm nervous. Right. I'd like to begin by saying that DCP has no real stakeholders at the table and that users of cannabis should be the ones leading and shaping policy so we don't have the highest mold and mildew limits in the country for our medical program. It's users that warned of what would happen in 2021 and 2022, but the state of Connecticut did not listen, making HB 5429 a necessity. HB 6855 is harmful and will lead to more shortages and waste. As a mother of 3 teenagers, my kids don't get into my stash, and we've had talks, so I can trust my kids walking into local grocery stores and ignoring products. My now 20-year-old did experiment on her college campus, but it was a college campus. Connecticut's program is so restrictive, lobbyist regulations are shutting down smaller equity dispensaries as people flock out of state for lower costs and better quality products. DCP is pushing a war on drugs and messing up. Help smoke shops get licensed, and most of the people who can't get licensed are Black and brown. Consumers are not confused. They do not want to go to Connecticut dispensaries. Connecticut dispensaries don't let you see the products in advance. The names are weird, and it's cheaper to go one state over and stock up. Help small businesses and gray market smoke shops get licensed and stop locking Black and brown people up. I don't feel like having to beg a rich white man for $3 million for a joint venture. Our medical market is failing if we don't allow mold remediation for lettuce and tomatoes in our food. Why do we allow it for cancer patients in their cannabis? As for HB 5429, once again, the medical market is dead. I can go to Massachusetts twice in my hybrid and get an ounce of cannabis, which is about less than a week's worth if you're a smoker, and fill up my gas tank at a lower cost than buying half an ounce in Connecticut. I can use my debit card. I can see the actual brand name, and it's not moldy. In the same manner, advocates advise lawmakers that shortages would occur, racial inequities would occur with ownership, and DCP would be interested in police action over quality and equity. Advocates are proposing this bill to solve some issues and prevent upcoming issues. The state of Connecticut should consider hiring the CT Canna Warriors as consultants, as they have called out. I'll summarize. As we have called out these problems for years before they occurred. As a functioning Colombian espresso coffee addict, I'm here to tell you, you can get addicted to anything from CrossFit and veganism to fried food and liquor to crack. More people drive drunk and kill people every year than have collectively died from cannabis as a whole. Also, please support anything restricting algorithms. I'm opposed to algorithms to set rental pricing, and am prepared for all questions regarding abuses from corporate hedge funds and property rentals. You can learn more from AG Tong's lawsuit against rental algorithms or the Justice Department's own raids and federal lawsuits against rental algorithm operators. Thank you.
Thank you very much.
Thank you, Mr. Chair. I appreciate that. Thank you for being here today. Now I know you weren't speaking specifically to 5429, but you did mention mold and mildew content, and that's a
Yes.
subject that I was interested in and played a part in the last session. So one of the questions I have, we know that outdoor grow actually has a higher mold and mildew content than indoor grow. So my question is, how would you, if you were sitting in this chair, how would you balance your concern about mold and mildew content in the product with your desire to have more outside grow available to patients? Because we just know that because weather is what weather is, there is a higher content of both of those things in outdoor grow. Thank you.
Yes. So I think it's a little bit easier with craft cannabis than it would be for a mass distributor. But as you see, the major distributors are failing to meet needs as opposed to local growers. It really depends on the way it's grown. I mean, with smaller scale operations, you can bring it inside, you can bring it outside. So the sun. You know,
Is one or the other of a greater concern to you? Because we know that when you have a very humid or a very rainy season, your product is simply going to have more mold and mildew in it if it's grown outside. So if you had to make a choice about, what's more important to you, is it having the outside grow, knowing that you're going to have a higher mold and mildew content? Is it that you're comfortable with throwing away a lot of that product if you don't want it remediated? How would you balance
Well,
that?
smaller scale operators really don't have to remediate because they can, leave it outside, bring it inside. It's a little bit more mobile. And yes, you do need outdoor grow. That's how you get a higher quality product. And, I'm fighting for my life with Eversource right now. Most people who grow their own stuff is right now.
Well, thank you very much for your
But
input, and I appreciate
if I
your
had
perspective.
to answer that question, it really depends on the grower. If the grower doesn't know how to grow, I mean, you're going to get mold on your stuff. I don't get mold on my stuff.
I appreciate your
So,
perspective. Thank
yeah.
you very much. Thank you. Thank you, Mr. Chair, through you.
Thank you, Representative Osborne. Are there any further questions? Thank you very much for coming to testify. Next, Rachel Lang.
Good afternoon. Yes, can you hear me?
Yeah, yes, we can. Please proceed.
Thank you, Mr. Chairperson, members of the committee. My name is Rachel Lang, and I am a resident of East Windsor. I will speak in support of HB 5429, an act concerning caregivers, qualifying patients, and the palliative use of cannabis. As others have testified, not enough patients can get their medicine consistently in our state. The profit is to be made in recreational adult use, and no one is making enough of what Connecticut patients need because they're too small a market. HB 5429 would give power back to the people to fix this. Caregivers will be safe retailers because they are invested in their own communities, providing medicine to their neighbors and friends. They have the incentive and they share the state's interest in keeping cannabis out of kids' hands. They are invested in providing medicine that not only they would consume, but they are cultivating every single plant with detailed care and caution that larger entities cannot spare to do with massive crops. In Maine, for example, many caregivers couldn't sustain operations facing high utility costs. Well, here in Connecticut, caregivers will be consuming some of the most expensive electricity in our nation. The people who will utilize an expansion of our caregiving market will be doing this because they care about patients and about the plant and about providing safe and affordable access to it. Expanding caregiving is going to be the best way for our state to supplement the dispensaries and give patients access to the medicine as they deserve. HB 5429 is not only the right thing to do, it's a reasonable choice, and it is what the people demand. In addition, the new presidential administration's attempt to freeze funding that our state depends on for critical services means that many of our citizens are going to face losing support systems that could be detrimental to their health, their happiness, and their lives. And providing additional cultivation options for qualifying patients and medical cannabis caregivers would be a clear statement that the state of Connecticut cares and that our legislators do represent us. A statement that we can trust our state government to do what their people demand if it's reasonable and equitable, and that we as a state are going to do what needs to be done to protect people's freedom to survive in the state that we all call home. So I ask that you not ignore this need and not ignore the call of so many citizens who took the time from their families and jobs today to help inform you of their support. And I thank you as well for your time and for listening.
Thank you so much, and thank you for hanging in there all day. Are there any questions? Representative Osborne.
Thank you very much for, is she gone? She's gone.
Oh, no, I'm here. I just turned my audio off. Sorry.
Very good. So thank you very much. Thank you for being here today, and thank you for waiting all this time to, give us your testimony on an issue that's really important to you. One of the questions I have about this bill is, I get the message loud and clear. People want more outdoor grow, but when we're limiting it here with respect to increasing the capacity of caregivers to increase outdoor grow and for caregivers to provide that product to people for whom they care, aren't we putting in the hands of these caregivers almost a medical judgment or a pharmaceutical judgment? And how do we get around the idea that in some ways we're imbuing in these caregivers the medical decisions that we usually leave to a medical professional?
I absolutely understand your concern and appreciate the question. Thank you. I don't think, and that's only my opinion, that any caregiver is attempting to replace or substitute the judgment of a primary doctor or physician. I think many people as caregivers, their goal would be to work in community with these other healthcare providers and to be aware of and work with them rather than substitute their judgment. I think it's also complicated, and I saw your previous interactions as well. The culture of the plant itself involves so much holistic care of a human being. And so I think it's a question that we can't necessarily guarantee or promise you won't come up on a case-by-case basis. But I think anyone who is familiar with the plant, familiar with people who are familiar with the plant, how it's such an individual system, and it's going to be so case by case if we can allow this expanded caregiving model, that I don't think any of these fears that we have are going to rise to the surface as we expect. I think it will be limited to the point where individuals can come up with their own systems with their existing medical providers. But that is just my opinion.
I thank you for your perspective, and thank you, Mr. Chair, through you.
Thank you very much. Are there further questions? Okay, hearing none. Thank you very much again for your testimony.
Thank you.
Next, Lou Rinaldi.
Hello. Good afternoon, everyone. Thank you for the opportunity to speak. My name is Lou Rinaldi. I am a former medical cannabis patient and a lifelong Connecticut resident. I understand that we've heard a lot of opinions and a lot of anecdotes here today, and I'm here to expound on some of that with data, specifically with public data. I am very interested at the intersection of public data with public policy, specifically how public data can be leveraged to advance the public good. In recent years, I have utilized public data to expose fraud and malfeasance at a Connecticut cannabis testing laboratory, which had its accreditation revoked and eventually went out of business. Specifically, Representative Osborne, to your earlier question, I was the one who exposed the backroom collusion between that lab director and a DCP drug control agent in August of 2020, and then worked with the legislature to help shape a formalized regulatory update around those yeast and mold limits. I would also, while I'm addressing Representative Osborne, I would say that you're asking a lot of the right questions, but I would encourage you to review the prior testimony today of the two microbiologists who spoke previously, and we had a robust exchange of information there. And I don't think it's quite accurate to categorize the desire for a caregiver tier of the market and equating that with outdoor grow. In fact, I would contend that the opposite is most likely the case, but that's a separate tangent. I also worked with Leader Rojas to create the Connecticut Office of the Cannabis Ombudsman, who we heard from earlier, Aaron Gorman Kirk, who's doing a fantastic job. So I have used public data in the past to help inform legislators and to drive public policy, and that's what I'm hoping to do again today. What I'd like to do is present you with some of my most recent findings utilizing public data, including the sources of that data, so that these analyses can be independently replicated by anyone. Hello?
Hey.
Did I get cut off here?
Yeah. Yeah. Mr.
Madam
Hall,
Clerk?
Yes, we can hear you. If you could turn your camera back on. I guess the issue is we typically don't allow for PowerPoint presentations. If you want to submit that and email that.
It has been submitted. I mean, it's a visual. It's charts of data that I'm presenting. So I'm not sharing my screen. This is a background in Zoom, and this is perfectly permissible under the terms that the clerk communicated to me yesterday. So please enable me to turn my camera back on so I may proceed.
Okay. You could read from your data, turn the screen back on, but.
I mean, I'm trying to, but the button is, I'm clearly someone's manipulating the Zoom right now. I'm watching it happen right in front of me. So I don't know what's happening here, but I would ask to please be allowed to have my video up so that I may continue my testimony.
Mr. Rinaldi, we're going to make it clear, we cannot allow screen sharing. It's
not a screen sharing, sir.
Mr. Rinaldi, I think you understand the limitation that we place.
Okay,
We're
fair
justifying
enough.
behind
Fair
it.
enough. I'll do my best to proceed without video. Thank you. So the impact of adult use on medical has been addressed here repeatedly. If you could see what I'm sharing right now, you would see that levels of cannabis products that are concentrates or extracts reached well over 1,000 in terms of what the state data shows going back to 2021. However, since the launch of adult use, we have seen that number plummet to levels below 2018. Now, there were good intentions here with unintended consequences. The potency cap was ostensibly something to address safety. So what happened? Connecticut enacted a potency cap for cannabis products for adult use. And why does it matter? Well, the unintended consequences were that producers deemed cannabis concentrates no longer financially viable to produce, so they stopped producing them altogether rather than attempt to comply with that regulation. These products are used by patients on a regular basis to help treat any number of symptoms, and now they're very difficult to find, and when they can be found, they're somewhere in the range of 400% more expensive than other state markets, legal markets. In terms of what do we do about this, how do we solve for it, I would advise the committee to look to House Bill 6058, which contains a provision for product universality that would solve for the root cause here. This is something that producers want. This is something that patients and consumers want. That's a big part of it. Another aspect is it's no secret that adult use legalization succeeded in this legislature largely on the promise of tax revenue. So what happened? We implemented a potency tax right at the launch of adult use. And again, if you could see my screen, you would see the trend lines illustrating that potency was consistently on the rise all the way back to the inception of the medical program. And right around the time of the adult use launch, it dropped off dramatically. So what does this mean? Why does it matter? The potency of these products, it's, imagine if aspirin or Tylenol or something else suddenly dropped in potency by 20%, from one batch to the next. There would be massive recalls. It would be a national scandal. And we're also seeing, a lot of testing numbers coming in just shy of the threshold for the potency tax. It's
Mr.
very
Rinaldi, could
clearly.
you summarize, please, your 3 minutes.
Yeah, absolutely. So only Connecticut and Illinois maintain a potency-based cannabis tax. We need to repeal this tax like New York did and replace it with a weight-based tax. And finally, the revenue target for cannabis on the adult use market, the Office of Fiscal Analysis projected 44.6 million for fiscal 24. The actual revenue collected fell 58% below that target at 18.65 million. 58% below the projections. So we're not getting that return. We're not seeing that tax revenue materialize. So whether it's 5429 or House Bill 6058 or some combination thereof, we need to solve for these root causes or things will continue to get worse. I've also submitted my written testimony, including these visuals, which I wish I were able to present to you right now, including specific statutory and regulatory modifications to help jumpstart this economic growth engine that we currently have idling or in first gear for the nobility at best. Thank you.
Thank you very much. Are there questions? Okay, hearing none. Thank you.
And I would also say that I'm glad to see Senator Maroney, your focus on the importance of task forces for AI, things that you care about. I wish you felt the same about the task forces for hemp and cannabis that came out of the last few sessions, because we could have answered a lot more questions with the research and data that would have come out of those efforts. So I'm hopeful that we can count on you this time around. Thank you.
Great, thank you. So next, DeAndre Brown. And I just want to say for people who are watching, due to our rules, we do not allow for props. And so we cannot bring charts up here when we present on the floor or when we're presenting. So it's just a consistency in rules to not allow for props when someone is presenting. So DeAndre? Thank you.
How y'all doing? Thank y'all for being here. Martinez, all the representatives. I don't know y'all names yet. I'm still a little new, so yeah. Shout out to you guys. Hi, my name is DeAndre Grim D. Brown, Executive Director of Fallen Angels Music and Evolve Love, an affiliate of BLM 860 and of the CT Canada Warriors. I've been consuming cannabis for a long time, and I can say personally I would have hurt myself or someone else if cannabis never entered my life. Where I come from, abuse and constant struggles from multiple angles and losses linked to mental stress that can be detrimental. But I'm going to say consuming cannabis brought me to a level of enlightenment and consciousness that at the time I needed. Most of the time of my childhood, hearing gunshots in your sleep, getting beat out your sleep, seeing poverty and abuse can cause mental illness that needs to be treated. In my case, it would be PTSD and anxiety. So if there's a medicine that's working, why limit or restrict it? We're in a time where also citizens are waking up and tired of being consumers, especially the lower and middle income families of Connecticut. So what's the solution to make an equitable market that anyone from every background can set up shop? We have programs for CDLs, pilot licenses, HVAC. We could even get our serve safe so we could serve alcohol in Dave & Buster's, anywhere. But we can't make it easier for people to get their cannabis license. It doesn't seem right. It doesn't quite make sense to me. I'm here to oppose Bill number 6855, and I'm here in support of HB number 5429, the act concerning caregivers, qualifying patients, and the palliative use of cannabis. Now, before I go to that bill, I want to point out the flaws of Bill number 6855. Increased regulatory burden. Expanded oversight on hemp, cannabis, and infused beverages could impose additional compliance laws and businesses, potentially making it harder for small operators to compete. Unclear impact on market access. While the bill introduces a temporary cannabis operator license, it's uncertain whether this will truly lower barriers to entry or simply create more bureaucratic hurdles. Potential for overregulation, reduced business flexibility, legal and administrative complexity. Frequent changes to regulations can create confusion for businesses, consumers, and enforcement agencies, leading to possible inconsistencies in implementation. Concerns over patient access, uncertain economic impacts, caps on hemp and cannabis-related activities may limit growth opportunities for Connecticut's cannabis industry, especially as surrounding states refine their regulations to be more business-friendly. To sum it up, potential benefits of HB number 5429 for the medical cannabis market, potential market revitalization, encourages home cultivation, for patients and caregivers, expanded cultivation rights, stronger legal protections, enhance anti-discrimination measures, helps protect patients and caregivers from unfair treatment in employment, housing, and healthcare settings, longer, more flexible patient certifications, lower testing costs, and many more if you really check it out.
Great. Thank you very much, DeAndre. Thanks for hanging in all day to testify and for your testimony the other day as well. So,
Thank you.
Does anyone have any questions? And we know you've been here a long day, and we're sorry. A lot of people have testified already. So the fact that we're not asking questions, please don't take that as an insult. We've been
No, it's
listening
cool.
all day. So thank you very much.
Thank you.
Okay. Next, Erica Cusino. Okay. All right. Alexander American. Hi.
Good afternoon, Senator Maroney, Representative Lamar, everybody on the committee. Appreciate you guys taking the time to hear us out today and the ability to testify here. I'm going to keep it short because I have kids to go pick up from daycare, and you guys have already been here for a long time. I also had a prop in my pocket, but given what the last gentleman went through, I'm not going to pull it out. I'm here in opposition to Senate Bill 1236, the act concerning solar license exemptions. I work in Wallingford, Connecticut, so Senator Cigarella in your territory there, and we represent probably 90% of the long tail contractors that operate in this state. Right, we're an equipment distributor. We supply products, solar equipment, to contractors that end up on commercial buildings. They end up on residential buildings all across the state. And I started as a installer in the field and moved my way through various stages. I spent 6 years on the contractor side and now in distribution. I've had a lot of experience in how these systems go together. The bill would allow for essentially unlicensed workers to unbox things, move them around the job site, maybe mount some racking. What it stops them from doing is mounting and connecting the solar panels themselves. This is a very simple connection. All this is a factory terminated connector that's on the back of all the modules and all of the equipment. It simply clicks together. It's no different than connecting this microphone to the stations here. Aside from that, the racking is just nuts and bolts. It's this bill, while has good intentions, and I can see both sides of this for sure, it doesn't add any added safety or quality of installation to this. It only adds unnecessary cost where ratepayers are already suffering from high energy bills. Senator Cigarella, if you're able, I'm more than happy to show you these things in our warehouse in Wallingford if you'd like to stop by and take a look at what we've got going on. But with that, I'll yield the rest of my time. I'm sure you guys don't have any questions at this point since you've heard a lot of this already. But thank you very much.
Great. Thank you very much. Senator Ciccarella, then I just have one quick question.
Sure.
Thank you. Thank you for taking the time to testify, and I'll be short so you can pick up your kids. But we could reach out offline, and we could take a look. I do have some knowledge as it's been coming before us for a couple of years, but I appreciate you coming up here, and we'll connect offline. Thank you.
Thank you. Jamie has my contact info. I emailed her this morning.
Great, thank you. And you mentioned it's just plugging in. So I'm assuming it's correct by construction, so you can only connect things
It's one
in
direction.
one way.
you know, there's a male connector and a female connector. They go together. It's very simple. Yes. It's very simple, small, but I won't pull it out. So, but that's it.
Great. Thank you very much for your testimony.
Thank you.
Okay. With that, Avery Pessa? Is that correct? Okay. Great. Thank you, Avery. Please proceed.
Good afternoon, dear honorable members of the General Law Committee. My name is Avery. I live, work, and attend college in Connecticut. I am submitting testimony in support of HB 5429, an act concerning caregivers, qualifying patients, and the palliative use of cannabis. Since 2016, I had advocated for medical cannabis patients' rights, for responsible and equitable regulation of cannabis, to reduce harms caused by prohibition, with a lot of the same faces you've seen given testimony here today. Since 2019, I have worked with medical marijuana program certification providers as an office manager and patient care specialist. Working with a team of cannabis specialists, mental health, and medical professionals, we serve thousands of patients in need of access to the state's medical marijuana program. We help patients with qualifying conditions navigate the steps to register the program, renew their card each year, and explain how to use cannabis as medicine to alleviate their symptoms with the products available at the dispensaries, along with providing tips on how to cultivate their own plants at home. Though unfortunately, this is not a viable option for most patients who don't have the time and resources to do so. I support increased protections for medical cannabis patients and caregivers. I support allowing patients and caregivers to cultivate more plants than the current legislation allows, as well as allowing caregivers to assist multiple patients. Patients and caregivers also need legislation ensuring affordable access to laboratory testing. I would love for all patients to be able to grow cannabis, enabling a greater connection to and understanding of plant medicine. That said, it can be difficult to obtain ideal conditions for cultivation, along with being very cost prohibitive, paying for the equipment, siege, and energy costs to run the grow lights. As energy prices skyrocket in the state, allowing patients and caregivers to securely grow outdoors will help provide more equitable access to their medication. From the product shortages to pricing concerns, patients and caregivers deserve the opportunity to grow more cannabis if they are able, helping to make this quality of life improving medicine more accessible. Respectfully, Avery Pessa. I am an office manager and patient care specialist for Healing Trees LLC, as well as a cannabis advocate with CT Canna Warriors. Thank you for your time.
Great. Thank you very much. Are there any questions? Again, it's a long day. We appreciate you staying here with us all day, and thank you for your passion to get your testimony across. So thank you. Next, Aaron Doolittle. Online? Okay. Aaron, please proceed.
Hi, thank you. Good afternoon to the esteemed General Law Committee. Thank you for hanging in with us for such a long day. I'm not going to repeat a lot of the things that we've already kind of heard. I did want to reflect back to Representative Osborne, who I think you were asking excellent questions. If you had to make a choice between indoor and outdoor for patients, you know, in a perfect world, yes, we would have indoor for everyone and it would be free and equitable and affordable. But the fact is Eversource is very expensive and having a tent is very expensive. So a small outdoor grow in the hands of a professional caregiver is safer and more likely to be cleaner than the indoor grows that we are seeing at the dispensaries. This isn't just because, you know, it's a smaller grow fully. It's also because you asked what happens if the plant has mold or whatever. Our caregivers, they will pull that plant out and they will wrap it in plastic and throw it away. They will absolutely, without, you know, thinking twice, say this is a danger to the other plants. This is a danger to my patients. And yes, they'll just get rid of it if it's a threat. So I think that's kind of, you know, the heart of this issue is how much caregivers care and how much it really is for them about the craft, about the plant. They do need to be compensated fairly, but they're driven by, they're perfectionistic. They're highly educated. They're not diagnosing anyone, you know, obviously that comes from the medical side, but they are experts on terpenes, which are the other parts of nature that find its way into this plant. So, you know, caregivers are really, you know, they've done the work, they've put in the passion, the energy, the effort, the education. And so that's why, you know, patients are fighting for this today because they are frustrated by the lack of what's available in dispensaries. They're frustrated by the expense. Some of them can't get to the dispensaries, and even with the delivery systems we've got in place now, it's still a challenge for many patients. So the opportunity to have a caregiver who is perhaps closer to where they live, who they can speak to, they can ask for specific strains to be grown and maintained, gives them a much better chance at a higher quality of life, which is what the medical cannabis program really is all about, is an improved quality of life. So I just think that this is an incredibly important bill that directly affects the quality of life and health of some of our most vulnerable residents. Allowing caregivers that are willing to grow in small batches and even teach patients this beautiful therapeutic exercise. Growing your own medicine is a beautifully empowering, thing to experience. It really truly brings something even more to the medicine. People being able to smell it, to see it before they buy it is a big deal to a lot of patients, because a lot of patients are actually experts as well. They know what terpenes work for them. They know what strains work for them. They know if they need flour or if they need concentrate or if they need edibles. They can tell you what they need extremely well. The problem comes when they're not able to get it. So, I think this bill is just, oh, I'm sorry. Thank you so much. I just wanted to support the bill. Thank you all so much.
Okay, great. Thank you. We do have a question, so you will get more time. So Senator Tagliato.
Only because we're having a discussion here. We are listening to you, but we're having a discussion at the same time. What's the yield of a plant that you grow at home?
I mean, it depends on the plant and the grower, but I mean, best case scenario, maybe a pound, if not even. If it's a really, really big plant that you can grow inside your house, it could be a few ounces.
So is that a continuous yield, or do you take what you need off it and then it takes how much time to regrow?
It's a one-shot deal. Once you harvest that plant, it's over. So you do have to, keep things going and have things in different stages of veg, so that you don't run out, because it's just a one-shot deal.
So currently, we were looking this up. You're allowed to do, it seems to be 12 plants indoors legally. Yeah. How many plants? If you had to take that number, what number would you take it to?
That for me, I could maybe handle 2 plants, but a professional caregiver who has the means and the time to put into this, they would probably do well with the 12 plants, but they would be able to separate them. In case of any sort of infection, they'd be able to easily manage any type of mold or bug infestation very easily. And like I said, they will just throw that plant away if it's sick.
So you're saying that the 12 may be enough. It's the person who gets to grow it is what that bill changes essentially.
It's possible the 12 may be enough, but in case of infection and that grower does have to throw away, 1, 2, 3, 4 plants, that could be absolutely devastating. So I understand why advocates might say, well, we need more than that. I can fully understand that.
Thank you very much.
Sure. Thank you.
Thank you. Are there any further questions? Okay, hearing none, thank you for taking the time to testify to us today.
Thank you so much. Happy Valentine's Day.
Happy Valentine's Day. Next up, Jocelyn Serda. Okay. Next, Jennifer Fell. Hi, Jennifer. Thanks for hanging in with us all day.
Well,
yeah.
Right on time, because I have to leave at 4:45 to get my kids.
Getting you in just no questions, then we promise.
No, I'll stay for questions. So thank you. So members of the General Law Committee, thank you for the opportunity to testify today. I am speaking to HB 6855, an act concerning the DCP's recommendations. So I represent the Connecticut Cannabis Chamber of Commerce. We represent licenses from the whole gamut, the previous medical market, every different type of license that has been issued now. So at this juncture, the Connecticut cannabis market is not growing at a sustainable rate. Sales remain stagnant. The medical cannabis program, as you've heard, is at risk. with, lack of product, and businesses across the industry are operating with razor thin margins. So it's critical that any additional legislation enacted doesn't further hinder the market's growth and sustainability. And these challenges not only reduce the state's tax revenue, but also limit funding for programs and services in the disproportionately impacted communities while preventing social equity entrepreneurs from realizing their goals. So we appreciate the efforts of the General Law Committee and DCP in developing this legislation, and we support HB 6855 as proposed by the department, with particular emphasis on the following provisions. So Section 5 expands opportunities for pharmacists and dispensaries to extend the medical access, which is fantastic. Fully support that. In Section 7, clarifying that backers do not include the financial institutions is critical as well for people obtaining funding. Section 12, 13, and 14 does refer to removing the 20-mile distance between EJVs. Our membership has mixed reviews on that. Some are fairly neutral, and as you heard earlier today, some people have some really compelling arguments about why that could be detrimental. They'll also be submitting some written testimony for your review, but the chamber has chosen not to take a stance on that because of the varying opinions. I do want to reference Section 17, in that it looks at the packaging requirements on cannabis or on the THC containing beverages. So I don't want a soundbite to go out saying that we don't support child safety. Okay. We are very much in favor of child safety, but I wanted to offer this up as an example of how overregulation can build up. So we know originally we made the beverages only 12 ounces. Then we limited them to 3 milligrams of THC, which is less than 1 gummy. And then we add a $1 tax. And then we add a childproof lid, right? And so that builds up over time, and that makes a product almost unsellable, right? It financially, it's just not viable to make and sell. And so I would just encourage you, as we're considering all of those things, as we consider changes, understanding the layers of impact that the regulation can have, period. That's the second time I've done that in 2 weeks.
It's like you rehearsed that. Great job. Are there any questions? I think one issue that we discussed before, I think we may have it in our committee bill, was because of the seltzers, right? Our limit to 3 milligrams is much, it's lower than other states, right? And so if you're a manufacturer in Connecticut, you may want it to sell to out of state. Just wondering if you have a position if we were to allow for that, because when we look through in the bill, we have our moderate THC license that does allow, at retail, you can only sell certain limits, but other things, if you're selling wholesale or to out of state, it allows you to create things that are federally legal. So
we don't have a position on that at this time. I can
Okay.
certainly survey our membership for that, though.
Great.
As well.
No, thank you. Are there
Anyone
other questions?
Anyone want to ask me a question about
Representative
mold?
Candelaria? I know you have one.
You said that yes, thank you, Mr. Chairman. Just fairly quickly, what's the opinion on the 20-mile radius from one EJV to another? What are you hearing out there?
So what the general feedback that we're hearing is that some people are fine with it. Some people feel injured because they had to abide by that as they were setting up their dispensaries, right? And that was problematic. Some other people are very concerned that the previous medical licensees have far more EJVs than other people, and that they could create sort of I don't want to use the word monopoly, but they could have an overwhelming presence in an area that could be detrimental to some of the smaller dispensaries that are, that are already struggling, right?
Thank you. Thank you for that. Thank you, Mr. Chairman.
Great. Thank you very much. And only 1 minute late, so you get to.
Thank you.
You can make it up on the road probably while you're driving the speed limit. So next, Walker Gallman, please.
Good afternoon, and thank you for allowing me to testify today. My name is Walker Gallman. I am Legislative Director for the Global Kratom Coalition, an alliance of consumers, experts, and industry leaders seeking to foster a market of safe and regulated kratom products. Our mission is to advance scientific research, encourage consumer education, and serve as a resource for key stakeholders and decision makers in legislative and regulatory matters. I and members of the Global Kratom Coalition respectfully oppose House Bill 6855, which inexplicably includes kratom products in consideration for a scheduling category with unapproved synthetic drugs like tianeptine and phenibut. Kratom is a natural botanical and is far different from the synthetic drugs it's being compared against in this bill. More appropriate would be to include synthetic 7-hydroxymitragynine products, commonly known as 7, that are more akin to drugs but are masquerading as dietary supplements and are often still labeled as kratom in stores. Kratom is a botanical substance from Southeast Asia with centuries of safe traditional use that's grown in popularity in recent years. Today, 24 million people in the U.S. report consuming kratom for mood enhancement, energy, and general wellness. Currently, 13 states in the U.S. have passed legislation to regulate products, and only 6 states prohibit kratom. There has not been a new kratom ban in the U.S. since 2017, as the science that has developed since then does not support the ban of this botanical. The FDA itself has stated during testimony in a kratom-related court case that at this time, they cannot demonstrate that kratom is dangerous. Regarding research on kratom, there is simply too little evidence of adverse impacts of kratom to warrant a ban. In fact, FDA conducted a single ascending dose study in which human subjects were given increasingly larger servings of kratom, up to 4 to 6 times larger than what is typical in a kratom product. Even at this large of a serving, the study found that kratom was well tolerated in humans. We believe adding kratom to the controlled substances list, as would happen under this bill, is scientifically unwarranted as exhibited by the rejection of scheduling attempts of kratom twice on a federal level in 2016 and 2018, and again with the World Health Organization rejecting scheduling kratom in 2021. Scheduling kratom would be counter to the science and would be a significant setback for consumers. Kratom is categorized as a dietary ingredient. There is no basis on which kratom should be lumped in with substances like tianeptine and phenibut. Based on the evidence of other banned substances, we believe prohibitive action will only drive the market underground and create a prolific black market. In the absence of available products, consumers will switch to different, potentially more dangerous products. In addition, the good vendors in the industry who respect the law will leave the state, and only those actors who do not follow the law will remain. Together, these actions will result in an unsafe environment and the need for significant and costly enforcement from authorities. We agree that legislative action needs to be taken and robust regulations need to be in place to guide the industry and protect consumers. However, we support implementing laws that establish age limits, prohibiting marketing to children, establishing serving sizes and clear product labeling, and that restricts synthetics or manipulated products, including limiting the total of 7-hydroxymitragynine products to an amount no greater than 2% of the total alkaloid composition of the product. Any product with elevated levels of 7-hydroxymitragynine should be prohibited. The Global Kratom Coalition views these measures as critical to maintaining a safe and trustworthy market for consumers. Today, we urge the members of the committee to reject this bill on the basis of its illogical, arbitrary inclusion of kratom. In place of this bill, the Global Kratom Coalition urges the Connecticut legislature to consider HB 5427, which would prohibit sales of kratom products to individuals under the age of 21. In rejecting HB 6855 and passing HB 5427, the Connecticut legislature will take a positive step towards creating a regulatory environment that benefits the state's residents and kratom consumers. I thank you for your time and welcome any questions.
Great. Thank you very much. I just checked online and I didn't see your written testimony. Would you be able to just submit that so we have that in the record as well?
Absolutely. What's the best way for me to do that?
Can you email the clerk? It's on the committee page at the cga.ct.gov. And
Yep,
then
okay.
you'll see to submit, it'll say submit testimony and there'll be an email address there. But
Happy to
thank
do
you.
that.
It's a long day. We appreciate you hanging in to testify, and we would appreciate you submitting your written testimony.
Absolutely. My pleasure. And thank you again for your time.
Thank you. Okay, next, Paul Costello.
Good afternoon. Chairman Maroney, Chairman Lamar, ranking members, Cicerella and Retigliano, and fellow members. Appreciate the opportunity of speaking for you this afternoon on SB 136 in support of it. I won't take the time. It's been a long day, as everyone's stated. We all know. You do have my written testimony, but I would request respectfully that there are a couple portions of it that you do refer to. What I'd like to speak on is a lot of the comments that were made today. First of all, I do represent the International Brotherhood of Electrical Workers. I'm a member of the State Licensing Board, State Apprenticeship Council, Governor's Workforce Board, and the Connecticut Codes and Standards Committee. And I'm not speaking on behalf of any of them. These are our opinions. But this is not a union issue. Opposition keeps saying it's the unions. It's a licensing issue. That's the concern for Department of Consumer Protection, occupational licensing. It affects all electricians. Statements were made that they refer to DAS for an interpretation. Licensing doesn't come under DAS, it comes under DCP. And if you would take a minute to look at the comments, I raised this question a year ago in March. And if I can, comments or concerns from any public person present today. Board Member Costello is looking for clarification on wiring exemption. Chairman went through the chair. John Mesner is with Occupational Licensing Division. Clarified, there are no wiring exemptions for unlicensed individuals. Unlicensed, unregistered individuals can put the panel down, but the physical wiring must be completed by a properly licensed individual. As I sat here today, I realized something. I'm old. I've been around here testifying on this, as Mr. Trahan said, 7 times already, and we still can't fix it. It's cut and dry. The wiring is not exempt from licensing. When I read the exemption in the existing language, employees of or any contractor employed by and under the direction of a properly licensed solar contractor performing work limited to the hoisting, placement, and anchoring of solar collectors, photovoltaic panels, towers, and turbines. It does not mention wiring. It's all electrical work. So that's been the problem. And the reason I say I'm old is because I was part of the group that was put together by the Connecticut Department of Labor, union representation, non-union representation, solar industry. Mr. Trahan was at the table with us. We wrote the curriculum for an apprenticeship program. The apprenticeship program failed. It didn't turn out anyone because of the exemption. You took a large portion of the coursework, both on the job and classroom training, and exempted it. And with that, I'll take any questions. I appreciate your time.
Great, thank you. I think you do a good job of, in your presentation of saying you're looking more for a clarification.
That's all.
And so,
We recognize that there is work that's unlicensable, and this is not looking to do away with the exemption as in previous years. It's just to clarify it. That's all.
great. Thank you. Representative Acker.
Thank you, Paul. It's always good to see you, and I just truly appreciate the work that you do for our tradespeople. I would like to sit with you and really iron this out, because I think that's what we have. We have a confusion piece here, and I would like, because I know exactly how a solar job goes together. I've been on the roof. I know my technicians have done the job. I know exactly what we're doing electrically, and so I know what the other non-licensed folks are doing also. So I would love to get with you, whether I'd come down to your education facility. Would love to go down there anyways, as you know. And then as I have in the past, but I can get to sit down with you and literally separate it out so that I can do my best to relay that to the people that aren't in our trades. So if you
We
can,
look forward to that.
thank you, Paul. Really appreciate that. Thank you, Mr. Chair.
And I'll offer to go with you, Rep. Acker. When
That would
you
be-
go,
that would
so
be
the
great.
3 of us
Yeah.
could
I appreciate
sit down.
that.
That would be great. So, okay. Are there any further questions? Okay. Hearing none.
All right.
Paul, thank you
Thank
very
you for
much
the opportunity.
for coming.
Have a good weekend.
Next, Josiah Schlee. Josiah here? Okay, he's not here. All right. Next, Devin. Devin, you can pronounce your last name for me when you come up. Like?
Ever get it right? No,
Okay.
Good afternoon-ish. I've been here a long time today, guys. I'm a little sweaty. I'm sorry if I'm not the most pristine looking person right now. My name is Devin Schleich, and I'm a proud resident of Connecticut. Always have been. It's where I call home. But I'm also a caregiver in Maine. They allow out-of-state residents to become a caregiver there and serve out-of-state residents, right? So we're actually, it's kind of, I'm going to go a little off script because I have a lot to say about this as a caregiver. So what I'm seeing is medical patients leaving the state of Connecticut, taking 5.5-hour drives and seeing me, another Connecticut resident in Maine, right? This underscores everything we're doing here. We're trying to keep the taxes inside of Connecticut. We're trying to boost local talent like myself. I've been in this industry for over 15 years. I might not have gone to college. I mean, I'm 30 years old. So at 18, I believe Oaksterdam University was the only one offering cannabis classes at that point. And both my parents being ministers weren't very eager to send me there. Let's say I had to make my own pathway across this beautiful country to California, and that's where I started my trip in the cannabis industry. To be honest with you guys, I don't support even recreational. I'm here for the patients. I don't drink. I don't use drugs. I'm a straight individual, as people my age would say. I know our words are a little different than yours. I guess it's just the problem. Over and over again, I hear that there's just no medicine for these people, right? They go to the dispensary, and in Maine, we have open deli style, so they can choose out whatever they want, you know, and that's the way it should be. You know, if I go to the grocery store, I'm going to want to see my apples before I buy them, to be truthful with you, because those apples are probably gross if I didn't see them. So they need specific things. Let's just highlight that. I just wanted to bring up a few things. You were talking about the outdoors, and that is a great thing to bring up. One thing you have to realize with cannabis and growing it, okay, so medicinally, right? Smoking it, ingesting it, whatever, can have beneficial effects. Now, growing the plant in and of itself is beneficial. For a person like me, being able to foster a seed into something that blooms into something I can ingest is just absolutely beautiful and gives me a sense of belonging in this world, where honestly, my age demographic, we don't have much sorry, I'm not very great at speaking. Entrepreneurial options, right? We don't have much. This is one of the only industries that we could take. And I will touch on this. I have 30 to 40 of my friends who have moved out of Connecticut to Maine to start businesses there so they could serve their patients here in Connecticut. This is ridiculous, guys. This is absolutely absurd. And at a lower tax rate, 5.5% up there, I don't even mind making it a little bit higher. One last thing I'll say to you guys. I had a million things in here. You all have it. You can read it. Maine generated $179 million last year through the medical cannabis market with fewer patients than we have. That's ridiculous. We generated, what, 70 to 75 million? That's nothing. That's nothing. We have companies in Maine doing that yearly. So I would just ask you guys, if you have any questions, I would feel happy to answer them. I know we have a lot of people who don't know the logistics about dehumidification, you know, in your grow room. How many BTUs you should have in a 400 square foot room. To answer your question, it's 72,000 BTUs. That's a lot. So with that, I urge you to support this bill that puts patients first and keeps our talent in Connecticut, because that's huge. We don't want to lose this talent. We have master growers here, and I would like them to stay here and foster their skills. Anyway, I'm over my time. Thank you, guys.
Yeah, thank you. Does anyone have any questions? I noticed you before, you were getting ready to answer when Representative Fratigliano had asked, how much can one plant produce? So if you wanted to answer that, I think you alluded to, you have the statistics.
Oh,
so
absolutely.
Please share the
It
statistics.
really depends on genetics. This is something I'm super into. As a medical patient for a very long time, I've traveled across this country to find the best genetics, right? So I've traveled to California, Oregon, Hawaii. I've been to Oahu, Kauai, to a back row to find a person who could teach me how to grow genetic properly. So I'm going all over the place. So generally, depending on how good of a grower you are, you're getting about 3 to 2 pounds per plant, right? We like to go, just to go with the mold thing. So in Maine, we reference the Connecticut grows as pushing 3 per light, 3 pounds per light. So if you're running 100 light grow, which is less than 10,000 square feet, let's be realistic, my 2 400 square foot rooms are 24 lights. That cost me the down payment on my house that I was supposed to buy in Connecticut. Let's be real about that. I'm sorry, I'm getting all over the place. I'm super passionate about this. I've always been passionate. Let's just divert to the question again. I'm sorry.
You answered it.
So
too. We
3
appreciate
to
that. 3
2 pounds, depending on how good of a grower you are. Now, if you are a money-hungry company, you're going to be pushing 3 pounds per light. That's when you get that serious bud rot, serious mold that's visible inside your plant. It's gross.
Okay, Representative Osborne, one more question, I believe.
Yes.
Sorry, just really quickly. You said per light. How many plants per light?
So that really depends on how you want to grow. This is a really complicated thing, guys. This isn't, you know, I know for a medical patient, they can figure it out on Reddit and stuff, but as a commercial grower, this is not simple. So it really depends on how you're going to set up the licensing for our growers, right? Are we going to go with a canopy space or are we going to go with a plant count? Now, a plant count is going to allow me to generate more plants quickly because I'm going to go from clone to 3 weeks in veg to 4, et cetera, in flower, right? Now, if I'm just vegging out these plants, I can veg a plant for unlimited amount of. I'm sorry. As I said, I'm very educated. I like
I
this.
don't know.
So a
It
vegetative
sounds
state.
like I did for a little while, but pretend. just
So a
pretend.
vegetative state plant's not going to produce the flower that has the THC on it that you would expect to see. I don't know if you've ever seen a marijuana plant before. I've seen way too many at this point. I've thrown out quite a bit too. I'm so tired. I'm sorry. So anyway, back to the point at hand. So you could grow larger plants that produce more, right? That's when you see these California outdoor grows with those huge 100-gallon sacks. As he's shaking his head, he's seen it in High Times and stuff. Who really cares about that? That's mediocre cannabis at the end of the day. We're looking for the lower yield is the better cannabis. Remember that, the lower yield. So like Granddaddy Purple, for example, harvests less than 3 ounces per plant, right? Well, you can get, I mean, one of these Kush strains that these guys are running over in CT Pharma and all of them, that generates 3 pounds per light or has the tendency to go towards that way. We want to stick towards smaller grows, smaller plants. This is how we can keep the mold out. It's the only way to do it because as soon as it goes over in my personal experience, as soon as it goes over 1,000 square feet, you're looking at trouble. You know, the smaller, the better. The best weed in this country comes out of 10 by 10 tens, plain and simple.
Great.
Thank you, guys.
I think is there another question?
Yes,
A
sir.
quick question from Senator
So
Chicorella.
we hear a caregiver.
Yes, sir.
That's somebody that provides the marijuana to anyone, or is it a patient?
Any medical patient throughout the U.S. country. I
Okay.
think we do have an expectation. We do have a couple states that we don't, but we're pretty open to everyone. Actually, Connecticut's one of the only ones that doesn't accept out-of-state patients, and that's really troublesome.
So if we allow individuals to grow more than 3 plants per person or up to 12 plants, what would they do with all of that marijuana? As we just said, it's very expensive to grow it, right?
Yes,
It's very
absolutely.
time consuming. What are people doing with the marijuana?
Are you
That are not
asking as a medical patient or as a commercial operator?
No. Put aside the licenses that we have, individuals that
yes,
want to grow marijuana for personal consumption. They could do that. This
Yeah.
is sheer, right?
It's
So if people want to grow that amount of marijuana, and as you said, the lighting and the utility costs are super expensive. If they grow that much marijuana, what are they going to do with that marijuana?
I feel like that's the same problem as if you were to make a bunch of moonshine, you had way too much moonshine in your tub left. You know, you should get rid of it so that children cannot get their hands on it. You should throw it away. I would suggest putting it in jars, making tincture out of it, making other remedies, tropicals, stuff like that you could purposely use for yourself. I
So-
really would like to see the caregivers only take care of patients and not patients growing for patients and distributing that way, to be honest.
Got
with
it.
you.
I got that. So are the caregivers selling this product?
Absolutely, sir. And they're paying taxes.
Okay. But the individuals that are not caregivers, right? They're growing their own, but they're saying we need to grow more because we want to give it away to individuals.
I really don't have any comment on that. I'm here as a medical caregiver. I want to help supply supply patients, right?
Mhm.
That's what I'm really here for. What they do on their own time and transactions between each other, some of these patients are better growers than me, so they can do what they want. I really, I guess I would say throw it away. Get rid of it.
Throw it away.
Yeah.
So they're going to grow extra. Do you want to increase
Well,
the
grow
yield?
extra as in like, are you talking about a license to grow for other patients? Or are you
No.
talking strictly just, hey, I've got my 3 and 3 downstairs and now I have extra of this cannabis in my house? They shouldn't. I mean, 3 and 3 shouldn't put out that much weight in total.
I understand, but that's why people are advocating to be able to grow more so they could take care of their patients, their caregivers. But they're not able to legally sell it here in Connecticut.
I
If you
think
don't
we're-
have a
I-
license,
I
you
think-
can't sell it.
I think you and me are kind of getting a little separated here. So you're talking about, hey, I want to let a medical patient grow for another medical patient, right? That's kind of what you're getting at? No,
Yeah, about the bill.
yeah.
Yeah.
I don't support selling from patient to patient now. I
Okay.
support caregiver to patient. That way we can have a direct line of access to the patient.
Got it. Okay. Thank you so much for answering the questions. Really appreciate
Thank
it.
you very much. Okay, next, Pat Garofalo.
Hello, co-chairs Maroney and Lamar and members of the committee. My name is Pat Garofalo, and I'm the Director of State and Local Policy at the American Economic Liberties Project, an organization dedicated to reducing the power that dominant corporations wield over our economy and democracy. Thank you for the opportunity to testify on this legislation, and I know that I am all that stands between you and getting out of here, so I promise I will be quick. I'm here to offer our support for HB 6478 and to commend Representative Rochelle for introducing it. Last year, my organization released a joint brief with our partners at Local Progress explaining that there's a new culprit in the housing crisis: rent-setting software algorithms that facilitate pricing coordination among landlords and property managers, which this bill directly addresses. Now, according to extensive work done by independent journalists and several antitrust enforcers, including at the Biden Department of Justice and your own Attorney General's office, third-party platforms, of which RealPage is the most prominent, but certainly not the only market participant, are using private proprietary data from landlords and property managers alongside publicly available data sets to recommend rent and occupancy levels that maximize not just one individual landlord's revenue, but revenue across all clients in the market. Regardless of the beneficial services they provide, these platforms that use black box algorithms have the functional result of suppressing competition. Instead of trying to fill units via competitive pricing, landlords and property managers are cooperating to set prices. Again, according to several investigations and legal complaints, these algorithms advise landlords to hold some units off the market, creating artificial scarcity, as well as to maximize churn, i.e. displace renters in order to raise the price of a unit. According to a report released late last year by the Biden administration's White House Council of Economic Advisors, third-party rent setting costs renters an average of $70 per month above what they would be paying in a competitive market, totaling $3.8 billion overall in 2023 alone. Now, I know it's easy to get caught up in discussions about algorithms, AI, certain types of data, but focusing on the tech here is honestly mostly a distraction. This is the core point. Landlords and property managers who use these systems understand that their competitors won't undercut them on price and act accordingly. Importantly, if you do not address this issue, supply-side housing interventions will not have the desired impact. More housing supply is absolutely necessary, but will not have the desired effects absent competitive rental markets. San Francisco last year became the first municipality in America to limit the coordination of rent prices using third-party algorithms, and was joined by Philadelphia a few months later. Bills to impose statewide bans, such as HB 6478, have been introduced in 17 states this legislative session, including New Jersey, New Hampshire, and New York, where Governor Hochul endorsed a ban in her executive budget. There's no silver bullet for the housing affordability crisis, and this bill alone will not solve it, but it is a very important part of the solution. Thank you for your time, and I'm happy to answer any questions about this.
Great. No, thank you. Oh, Representative Luxembourg.
Thank you, Mr. Chair. I was wondering if the person testifying thought that the fact that there is a fair market rent system produced by HUD that tells you what the fair market rent is for any area, any zip code, any number of bedrooms, and that's publicly available by the federal government, is a point that strengthens the argument for this bill. And what I mean by that is landlords, tenants, and everybody in the housing marketplace don't need specialized software. They can literally just go online and see exactly what the fair market rent is according to the federal government. So is that sort of an argument in favor of this bill, that when they're using this software, it's more often than not for the nefarious price fixing purpose that you described that's artificially raising rents?
I think that's correct, right? The issue with this software is not that it uses an algorithm or not that it's recommending rents necessarily, right? You can imagine a world in which a property manager builds their own proprietary model, uses an algorithm to suggest what rents should be across the properties they manage. Now, that could obviously be problematic for lots of other reasons because algorithms can be discriminatory, but that's not a competition problem until the second landlord has access to the same platform. Until you start adding other landlords and their data in, and all of them using the same algorithm that are suggesting the same prices, again, to maximize revenue for multiple participants across the market right now. You're not competing, you're colluding. So I think that's absolutely right. You don't want to prevent market research and quarterly reports about rent prices. You want to prevent the ability of multiple participants in the market to use the same tool to play in the same sandbox, if you will, that's suggesting the same revenue maximizing rent numbers to all of them. And honestly, this is something that regular renters really get because it explains a lot of the bizarre behavior that they see in rental markets. Landlords who refuse to negotiate, who give them odd lease lengths, who won't let them move to a vacant unit within their own building. It's because the algorithm is telling them that none of those things will maximize revenue across the market.
Great. Rep. Luxembourg, thanks for the question. I think excellent point that there is data so we can measure the variation, right? And so great. And thank you very much, Pat, for hanging in there with us to close out the day. I think you were we have one more. Okay. All right. Thank you very much. So we have one more person testifying, but thank you, Pat, for coming. And the floor is yours.
Thank you. Good afternoon. I've been here since 8 in the morning, so I'm a little nervous. Good afternoon, Chairman, ranking members, and all members of this committee, especially Representative Tim Ackert, my representative who's allowing me to testify. I'm testifying in support of HB 5429, an act concerning caregivers qualifying patients in the palliative use of cannabis. My story and details are raw, so I apologize for those that might be sensitive or feel uncomfortable.
Hold on, before we get,
Yeah, you have to
you give us your name.
Oh, sorry.
State
I
your
thought
name
I did.
for the record.
Jason
That's my
Blakely,
fault.
Coventry, Connecticut. Sorry, I missed that. My story and details are raw, so I apologize to those that might be sensitive or uncomfortable. In 2014, I was arrested, convicted, incarcerated for cultivating cannabis without a license, even though I had my medical cannabis card at the time. Following my sentence, I was transferred in a prison van, shackled to 10 other inmates, without any of us being seatbelted in. Upon arriving in prison, I had to strip my clothes and get naked in front of 30 other men in prison. I had to bend over and cough while a correction officer inspected my anal cavity for contraband. At one point in prison, there were 2 working showers for 60 inmates. I consumed the most horrific food that was prepared at another correctional facility. I watched inmates smoke crack using tinfoil and an electrical socket. I witnessed countless fights, heroin addicts shaking and moaning all day and night on their cot with no pillow. This type of trauma will negatively impact your mental health for the rest of your life. Immediately following my release from prison, I had to report to the state to submit my DNA sample. For the next 7 years, I lived as a felon, unable to get good work. As ridiculous as this might sound, I was even banned from working in the cannabis industry. Even more absurd, despite the fact I was negatively impacted by cannabis laws, I did not qualify for an equity license based on the neighborhood I grew up in, which is not included as a qualifying neighborhood, nor is my current home in Coventry. Unfortunately for my case, it was adjudicated in the Rockville courthouse, which has one of the highest incarceration rates, not only in the state, but in the country. After 7 long years of stress and a few $100s, the Board of Pardons granted me an absolute pardon. Also, the lead detective in my case was allowed to resign with pension due to allegations of grooming minors for sex. Perhaps in the near future, we could include HB 6377 and act those that were directly harmed by the senseless and endless war on cannabis. Without my felony conviction, I was finally allowed to start my career in the cannabis industry with an MSO, multi-state operator. It quickly became a nightmare to witness the most horrific conditions and quality of cannabis being grown. Immediately, I noticed nothing but problems. Cannabis was covered in mold, bugs, and powdery mildew. This was extremely concerning for someone like me who has an autoimmune disease. To think I've been consuming state-approved medical cannabis for the last 7 years because I was unable to grow my own, nor was I able to purchase a much safer medicine from a caregiver. The commercial industry will disregard their patients' own health for safety and profit. A perfect example is when cannabis fails testing, the THC could still be extracted to produce products like vape cartridges, edibles, and other products. These companies don't care about their own employees, evidenced by the incredible low pay, hazardous, and unhealthy working conditions. I have worked for multiple large-scale MSOs in Connecticut and Massachusetts. MSOs pay 99% of their employees just above minimum wage, an unlivable wage, especially in Connecticut, which has the highest costs, taxes, and cannabis prices. As a result, turnover in the industry is extremely high, which is why they're always shorthanded. Connecticut has the highest allowable molds colony forming units in the country. Connecticut is 100,000 square CFUs. Our neighbor Mass is 10,000. Cannabis flower is sprayed with fungicide before harvest just to pass testing. This is why I'm in full support of HB 5429, an act concerning caregivers, qualifying patients, and the palliative use of cannabis. This is why I truly believe that medical patients should have a better, safer choice than the options they are forced to choose.
Great. Thank you very much. Representative Acker.
Thank you, Mr. Blakesley. I appreciate your time coming here and getting here early in the morning to sign up like we used to do in the old days, and I know that you can't, but thank you for your patience. There's been a lot of discussion on the caregiver piece, and so why would you say caregivers over the, being safer over the commercial side of it?
Well, I want to start by saying that first, the caregivers would have a personal relationship with the patient. They would actually have access to the grower. It'd be more of a face-to-face communication, where I feel like the MSOs really only care about the face that's printed on the dollar bill. I could get to know what strain specific works for them. I get to know what their disease, their ailments, and then I can grow a strain that would actually work for them. Where the big MSOs just grow for the masses. They're not growing for the small patient. They're really just growing for the recreational market because that's where the profit is. So I say that, and also I said we live in Coventry where we have the local farmers market. It's most popular. People from the state come to Coventry because they want to talk to that local farmer. They trust that local farmer. He could tell you exactly what he's putting into that product, what fertilizers, what fungicides, what sprays, what's his IPM. IPM's integrated pest management. So I feel like you're going to get a better product because that person is going to know you personally. Just like you would rather buy from the Coventry Farmers Market than probably a Walmart, because you know that grower knows you personally and actually cares about you. And also I mentioned that how we have the highest allowable mold in the state. When a state, we fail something, we still extract it. So people are buying vape carts that failed. We've not known if DCP has ever bought a product and then retested on the side and compared the testing to saying it's passed. When MSOs send their batch to testing, it's a small batch, very small batch per 40 pounds. So I can send a half ounce to have tested out of a 40-pound harvest. So they cherry pick what flower they're going to send to have tested. They also spray all the time to pass testing, and that's what's causing their mold. They also run 1,500 to 2,000 CO2s of ppm, which makes the flower bigger because they want more money, but that also causes mold. They overcrowd all their facilities. They usually do, every company has the same standard width table. They put 3 plants in a row. I call the middle row death row because it gets no light, no irrigation, and those plants die. But anyone who consumes that plant will probably also die because that is covered with nothing but disease.
Thank you, Mr. Blakesley. I appreciate that, and thank you for waiting all day long. And did you submit testimony?
I did.
Okay, great.
Yes.
Thank you. Thank you, Mr. Chair. I appreciate that. Thank you for the indulgence.
Great. Thank you very much. Okay. I believe that's it for the day. So thank you for hanging in all day. Thank you to everyone who testified. And with that, we are adjourned. Have a happy weekend, everyone. Happy Valentine's Day.
Thank you.